Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are off of the New Jersey versus Paul Canero trial. So in the meantime, we are turning our sights on a trial that's happening or had happened in Georgia. And let me just double check my audio for joining us. All right. So welcome in. While everybody has a seat, we'll just put this up and C. Gilmore, good to see you. Jenny, hello. Thank you. Sleep with one eye open, good to see you. Little Lulu, good to see you. Chris Wallace, hello, good to see you guys. Cindy, Missy, Sherry, thank you for joining us. Allison, hello. Nana, Debs, Lori, good to see you guys. Thank you for joining us. Richard in the kitchen, hello. All right, so we understand that this is very politically charged. So right off the top, I'm going to ask you, we did cover this trial when it happened. It was before I was on camera. We asked that you guys leave your politics at the door. We are not a political channel. We cover trials. So even though this has politics involved in it, for some of you, I understand it might be too much. So if it is, then I would invite you to leave and talk politics on another channel. We are not going to get into politics here. We're going to cover the trial. We're going to continue to find justice for Laken Riley. And if you do continue to bring politics into this, we will delete your comments and we will ultimately time you out. So I don't want it to get to that. So I would ask you again, leave your politics at the door, no matter what sides, wherever you land on it. Let's just focus on the trial. Let's focus on justice for Laken Riley. And if you need to talk politics and vent, please go somewhere else and then come back here because that is not what we are about here. So with that being said, Laken Riley is the victim. She was 22 years old. She was going to the University of Georgia. She was a nursing student. Jose Ibarra is the defendant. He is 28 years old. This happened February 22nd of 2024. He already went to trial, and like I said, we covered this, but this was before I was on camera, so we had to take it down. So we, in fact, do not have this. So he was convicted of malice murder, felony murder, kidnapping with bodily injury, aggravated assault, aggravated battery, and tampering with evidence. So, February 2024, University of Georgia nursing student Laken Riley was found deceased near the University of Georgia campus in Athens, Georgia. The investigation quickly focused on Jose Ibarra, who was arrested and charged in connection with her passing. Prosecutors alleged that Ibarra encountered Riley while she was out for a run, forcibly restraining her and causing fatal injuries during the attack. Investigators relied on surveillance footage, body-worn camera video, forensics evidence, and digital data to construct Riley's final movements and identify Ibarra as the suspect. The case was tried as a bench trial, meaning it was decided by a judge rather than a jury. After hearing the evidence and testimony, the court found Ibarra guilty of multiple felony offenses, including deletion and kidnapping with bodily injury, and sentenced him to life in prison without the possibility of parole. The case has now entered the post-conviction phase. Ibarra has filed a motion seeking a new trial. That's why we're covering this right now. So 4 days ago, he asked for a new trial. He's arguing that errors occurred during the original proceedings, including issues related to evidence handling and the defense's ability to adequately review and challenge that evidence. The court has heard arguments on the motion and has taken the matter under advisement with no ruling issued as of yet. So we're going to watch, not only are we going to watch that appeals hearing, but we're going to go back before that and we're going to see how we got here by watching some of the trial. If you guys missed it, we're going to watch a little bit of the trial. So, Just a Girl Baking, good to see you. Shadow, good to see you. Thank you for joining us. Hell Rider, good to see you. Shirley Roth, Missy, and Richard. Joe and Jedi Platypus, good to see you. Gordon, thank you for joining us. All right, Chris, have a good one. I understand. If you guys can't handle it, come back another day because we're not going to deal with politics here. So appreciate that, Chris. Thank you for respecting our wishes. All right, so let's get over here, and we're going to start with, now he was arrested before, so he came in through El Paso, and he was arrested in New York City September 14th of 2023. He was charged with acting in a manner to injure a child less than 17 in a motor vehicle license violation. But he was released by the NYPD before a detainer could be issued. However, the NYPD said there was no records of arrest for Ibarra. And I remember when we first showed this, I thought I found that he was arrested for stealing food. I thought that's what he was arrested for. So I couldn't find that per se, but I think he was arrested with like a loaf of bread and eggs or something to that effect. So I wasn't able to find that quickly because I had to, I wasn't able to find that. So anyway, let's turn our focus on this current appeal. So first off, we're going to get to Laken and his arrest, and then we'll get into the actual trial, and then we'll go to the appeal.
Learning more about the suspect arrested for the murder of a 22-year-old on the University of Georgia campus.
ICE telling Fox News that he came to the U.S. illegally from Venezuela, and they also say that he has been previously arrested here in New York. But local officials are so far not confirming that part of the story.
All right, Fox 5's Chris Welch joins us now in studio with a breakdown of what we know. Chris.
Yes, Stephen and Tasha, ICE is telling us that the suspect, a Venezuelan man named Jose Ibarra, was arrested by the NYPD last year, charged with endangering a minor. ICE adds that he was then released by the NYPD. However, the NYPD is telling us this afternoon that they have no record of an arrest for that individual. Nonetheless, this story is now the latest flashpoint in the debate over U.S. immigration policy. Students at the University of Georgia holding a vigil this afternoon to remember 22-year-old nursing student Laken Riley. Police say Riley was killed Thursday, a result of blunt force trauma, while running through the nearby intramural fields. Riley's freshman year roommate speaking out.
I never would have thought that on such a busy campus, something like this would have happened. I don't think anybody had expected it.
In a statement, Immigration and Customs Enforcement officials say the suspect is, quote, Jose Ibarra, a 26-year-old citizen of Venezuela who was arrested by U.S. Customs and Border Protection on September 8th, 2022, after unlawfully entering the U.S. near El Paso, Texas. According to Fox News, Ibarra remains in jail without bond. ICE says the NYPD released him before they could issue a detainer. However, an NYPD spokesperson telling Fox 5 there are no arrests on file for the individual in 2023.
More than 8.5 million illegal immigrants have crossed the border since President Biden took office.
Meanwhile, Georgia's Republican Governor Brian Kemp using this incident to call out President Joe Biden's immigration policy.
Laken's death is a direct result of failed policies on the federal level and an unwillingness by this White House to secure the southern border.
And Laken Riley's funeral is now set for Friday. Steve, Natasha, back to you.
Chris, thank you.
All right, so that is some initial reporting. Now we're going to get to a report on why he wants a new trial. I already kind of covered that, but let's hear what the news has to say.
To Athens, you know, they are going to Athens, you know, they are going to get hit harder than Metro Atlanta when it comes to the snow over the weekend. But before we get to the snow, we're also watching a big case at the courthouse there in Athens, Clark County. We're talking about Jose Ibarra. Remember that name? He was the man convicted of killing Laken Riley. Now his defense team is going before a judge this morning, and they're going to be making several arguments for a new trial. They want his conviction overturned, his life sentence thrown out, result and a new trial granted. That hearing happening in, we're told, about an hour and a half, 11 a.m. Now, one argument they're going to be making before the judge is that the judge improperly denied a motion to suppress cell phone evidence during his trial, which was back in 2024. But that defense team is going to be making that argument to the very judge who decided Ibarra's fate. He waived his right to a jury trial, decided to have his case heard before a judge, and that is the same judge who's going to be hearing this appeal this morning from the defense team. Prosecutors also going to have a chance to talk this morning. A judge going to make a decision. So we're going to be keeping an eye on that. Laken Riley, of course, I mean, you know her name by now. This whole case led to heightened tensions in the national debate over immigration. Ibarra was here in the country illegally from Venezuela. This killing led to the passing of the Laken Riley Act, which was in fact signed a year ago by President Donald Trump, a year ago last night. And it basically expands federal authority to deport undocumented immigrants who commit serious crimes, including theft or violent crimes. So we're going to be keeping an eye on what happens there in that Athens courtroom this morning. Will Ibarra be granted a new trial? Those motions are going to be underway, and attorneys are going to be beginning their arguments in just about an hour and a half.
All right, so let's get to those motions. That's a good little lead up, good little intro. Thank you for that.
We usually talk about it. Also ordered the evaluation, and I have it marked as State's Exhibit 1, an evaluation that is dated November 17th, 2025, signed by Dr. Bailey and Dr. Garrett, so Doctors Bailey and Dr. Garrett at DBHDD. It is a 15-page report. I know Your Honor has seen it because it is addressed to you, and it finds no issues to proceed on competency. I'm going to seal it and ask that it be admitted as State's Exhibit 1 and just preserved for posterity at this point. And considering they've not raised a special plea of incompetency, I don't know if the court wants to make any kind of finding beyond that. But may I approach and hand the court State's Exhibit 1, which is in it.
You might.
Okay, go ahead.
Your Honor, if I could just add real quick, I think technically, just because there's been the order to conduct the evaluation in the first place, there's technically supposed to be an adequate hearing finding Mr. Ibarra competent to proceed. This is that hearing. We stipulate to the report. I think the court just has to find him competent, which we have no.
All right, hold on. I want to get to his trial first, and then I want to do the hearing. So let's just put a pin in that for now. And I want to do. Let's just backtrack a bit. Let's backtrack a bit. I want to actually get to his trial first. Then we will get to his hearing. So I want to just. I want to do it this way. Okay. So this is his hearing. This is from November 15th, 2024. All right, just give me a moment. State openings from. All right.
May it please the court, counsel. On February 22nd, Jose Ibarra put on a black hat, a hoodie-style jacket, and some black kitchen-style disposable gloves, and he went hunting for females on the University of Georgia's campus. And in his hunt, he encountered 22-year-old Laken Riley on her morning jog. And when Laken Riley refused to be his rape victim, he bashed her skull in with a rock repeatedly. That is what this case is all about. The evidence will show that Laken fought. She fought for her life. She fought for her dignity. And in that fight, she caused this defendant to leave forensic evidence behind. She also marked her killer for the entire world to see. The forensic evidence that he left behind in this fight is his DNA, and only his DNA and Laken's, underneath Laken's right fingernails. He also left behind in a struggle with her over her phone, because the court will hear that she called 911. He left behind his left thumbprint on her iPhone, which was found not far from her body at the crime scene. And it is that forensic evidence alone that would give you enough evidence to find him guilty as charged on the counts in this indictment. But the evidence in this case will come in basically three forms. There'll be forensic evidence, there will be digital evidence, and there will be video evidence. And all three forms of those evidence will point to one person, Jose Ibarra, as the killer of Laken Riley. And this is not working. We'll start with a timeline, and the timeline is established by a lot of the digital evidence that you're going to hear about. And for Laken, that timeline begins basically at 9:03 in the morning. At 9:03 on Thursday, February 22nd, Laken Riley did something that she does all the time, and she went out for a morning jog. She lives not far from the crime scene, and Your Honor is going to see several maps in this case, and you will see that where Laken Riley lived, where the defendant lived, where our other victim, who you're going to hear from in this trial, Tasia Swee, lived, Building S at the University of Housing, at University of Georgia Student Housing, and where items of evidence were dumped in this case, and where Laken was murdered. It's all clustered together, and it's all clustered together within about a half-mile radius of one another. And you'll see several maps throughout this case. But she left her house at 9:03 in the morning. We know that for several reasons. She was captured on her Ring doorbell, and you'll see that video through our first witness. And she also was captured on a trail cam that becomes very important in this case. And at about 9:05 a.m., she's captured running from her house down Rogers Road, eventually towards the crime scene where she encounters this defendant. She is running, as you will see, with a few things that are important. 2 AirPods, and they are noise-canceling AirPods, and her phone, her iPhone, is in her left hand. She's wearing typical running clothes, and you're going to hear a little bit about how she runs, what she runs with, because these things are important to judge what eventually happened between her and this defendant on the trail. She wears typically very tight running clothes because that's what's comfortable when you run, so it doesn't get it doesn't come off or get loose when you're running. And so this particular day, she's wearing running tights, white Hoka shoes, and 3 layers of clothing on her top. She's wearing a running bra, a shirt, and a tight black Lululemon jacket when she leaves her house. At 9:11 a.m. exactly, Laken is a few minutes into her run, and we have some digital data which we'll talk to you about, which is a Garmin watch that Laken had gotten for Christmas that she's wearing on her run. And this watch captured a lot of important data that you're going to hear about. But she is on her run, and her phone, she activates the emergency function of her iPhone, and you're going to hear about that through testimony of the witnesses who examined her phone. She activates the emergency function of her iPhone, and she attempts to call 911, and she in fact does call 911. Her call is connected to ACC PD. At 9:12, you'll hear that the call was hung up, and I'm going to play the call for you. At 9:12, the call was hung up by the caller, not the 911 center. The 911 center did not hang up on Laken Riley. The phone hung up. And at 9:12, they tried to call her back, and there was no answer. This is an enhanced version of the 911 call, and there will be several stipulations between the parties in this case. We will execute a waiver of them as they come in. One of the stipulations was that this 911 call was sent to the FBI in Quantico, where they attempted to enhance the call. And this is a 1 minute and 8 second call, and this is the enhanced version of that call. And I'd like the court, when listening to the call, right about 55 seconds into the call, you're going to hear a voice.
Clark County 911. Hello, this is Clark County 911. Hello, Clark County 911. Can anyone hear me? Clark County 911.
Yo Tango. There is a long break in what happens next. It was Laken's mom, who Laken usually talks to on her run, who started calling Laken at around 9:06 that morning. And you'll just see the call logs from that and the evidence of that through Laken's phone. And when she could not reach Laken, she began calling Laken's 3 roommates. And you'll meet all 3 of them: Lily Steiner, Sophia Magana, and Connolly Huth. All 3 of them are University of Georgia students at the time. They were all seniors. And Laken herself was at UGA, but had recently transferred to the University of Augusta Athens campus because she wanted to be a nurse. But the 4 of them still live together. And the roommates are all, I would say, technologically savvy and security savvy. And they, all 4, had iPhones. And there's a function with an iPhone called Find My iPhone, which you can share your location with other people. And the 4 ladies in that house, roommates, shared their digital location with one another 24/7. And so when Allison Phillips, Laken's mom, began calling and looking for Laken, she notified all the roommates. And then the roommates started checking the ring door camera, checking for Laken, texting Laken, calling Laken, and no response. I will say that this particular day, February 22nd, 2024, happened to be the day where there was a widespread phone outage by AT&T. And so some of the girls did have AT&T as their service provider. Laken did not. She is Verizon. And so the girls were having phone problems due to that widespread outage. And so you'll hear about how that kind of interfered with their ability to really find where she was. But eventually, they could not find her. They could not find her for hours. And even though Laken would go out on long runs, she always had her phone with her, so they became concerned. So at around 11:30 on the day of her murder, two roommates, Sophia and Lily, went and walked the trails back behind the intramural fields at the University of Georgia where Laken used to run, but they also had her digital profile. And her digital profile put her in the middle of the Oconee Forest, and they had noticed that she had not moved. She had not moved for hours. And so they walked to where they could last see her digital profile, and the two roommates found one of Laken's AirPods. They photographed it, they collected it, they went back to their house where they could have Wi-Fi to connect because they had no phone service in the forest and the outage was on. And at 12:05 p.m., they called the University of Georgia police and reported that Laken Riley was missing. So it isn't until the police respond immediately, and they take that digital profile, and you'll meet Sergeant Maxwell. He is the officer that found Laken's body. And it takes him, even with her digital profile, this is a very forested area, and she obviously wasn't on the running trail, she was off the running trail. And it took him about 25 minutes, even with her digital profile, for him to locate her. And he did locate her, and you're going to see the body cam footage of him locating her. And what he found when he found her is that she was hidden kind of almost under a tree and covered up with a bunch of leaves. The first thing he noticed was that her breasts were completely exposed. All three layers of her top clothing were pulled up above and around her neck. He also noticed that her running tights, which she typically wears above her navel, were pulled down and her underwear was protruding from her tights. He also noticed severe injuries to the left side of her head. He began immediately trying to save her life, but he could tell that she was dead. She was cold. But he began CPR, and you will see the efforts of him and several other University of Georgia police officers where they try to save her. They have to move her out of this area so that they could get her flat on the ground. They give her chest compressions. They give her CPR. They put those pads on her chest to try to start her heart. Eventually, the fire department and EMS comes and they do the same, and they work her for several minutes, but she is dead. She is dead, and there was nothing they could do to stop it or help her. You'll see the crime scene measurements. The crime scene in this case was worked by the GBI in conjunction with UGA PD. You will hear in this case from GBI, UGA PD, FBI, and ACC PD. The four of them really in conjunction worked this case. And the crime scene, importantly, when they get there, there's really very few items there. But item number one, where you see on the trail, is the other AirPod that Laken was wearing at the time that she was running. And then they saw a disturbed area of leaves to a point where they found two rocks and a tree, both of whom have, or all three of which have Laken's blood on them. And then Laken's body was a few feet away from that, where you see the green there. And then her phone was not found near her body. It was found where you see item number 8, which is the other tree that you see there. But her person was taken 64 feet off that trail. So from where AirPod is, item number 1, to where you see items 2, 3, and 4 is 65 feet. So in legal terms, he asportated her 64 feet off of that trail so that he could attempt to victimize her. This is the crime scene, and you'll see how wooded it is and why it took Sergeant Maxwell so long to find her, even though he did have her digital profile. And in here, this photo is actually the phone. And so it took them a really long time to find the phone. They were calling the phone, they were pinging the phone. Her phone was on silent, so they couldn't hear it. It wasn't until it got dark that they could find her phone, but they kept looking for her phone because they knew the phone was there. And they found it. And when they found it, this is what Daniela Stewart of the GBI saw on her iPhone, exactly where your thumb would be if you go to hang up a call on an iPhone. So at the bottom of the iPhone, she found this latent print in blood. They processed the phone immediately, and that latent print was sent to ACC PD, and we'll talk about that a little later. And here's some of the Garmin data. And There are some things that we will never know about exactly what happened between Jose Ibarra and Laken Riley on that trail, but we know enough. And what we know is that at 9:10 a.m. from her Garmin that she was wearing, as she is trucking along and she is clipping 7-minute miles, she's running, doing her thing, listening to music, something happens. He does something to her to make her stop dead in her tracks. She initiates the SOS function on her phone and calls 911, and she immediately stops. And after that, you'll see some of this Garmin data, her movement, because it went to the FBI CAS team. They're the ones that analyzed it, and you'll hear about it. She's on this trail with this defendant for about 4 minutes, and then you see 4 minutes later, her Garmin move 65 feet into the woods, and there's some additional movement of her along that time, and her heart rate is still going until 9:28 a.m. Her encounter with him was long. Her fight with him was fierce. And that is what the Garmin data shows. And once her heart stops at 9:28 a.m., there's no more movement from her Garmin. So what happens next? Well, UGA PD leave, and they really got nothing other than a Peeping Tom incident that had occurred on campus at 7:57 a.m. And I'm going to talk to you about that one last. So what they do is, it is a combination of good police work and luck, pure luck. But they start dumpster diving. ACCPD is dumpster diving, UGA PD is dumpster diving, GBI is dumpster diving, FBI is dumpster diving. Everybody is just looking into every dumpster in the Athens area for anything, because they had nothing. And at a dumpster, at an apartment complex where he lived, a police officer named Zach Davis of ACCPD finds this hoodie jacket. And when he looks in and sees it, it's in a recycling bin, and it's standing out because it's right on top. And he noticed it had long, dark hair on it, wrapped around one of the buttons, and he could see blood. And he thought that was suspicious. So he calls UGA PD. They respond at 9 o'clock on the day of Laken's murder. They collect the jacket found in the dumpster, and they send it immediately to the GBI Crime Lab indicator for testing. But while they're there, they look around and see that one of the residents in this apartment, and B32, had what's called a Eufy camera, which is like a Ring camera but works a little different, had a camera aimed at that dumpster. And so they asked the resident that night, hey, can we come in? Can we see your camera? He agreed to let them see it, and this is what they saw. At 9:44 in the morning, about 15 minutes after Laken Riley's heart stopped, this is what they see. So they saw an individual who they did not know who it was at the time, dump the jacket in the dumpster and go to those bushes there and dump something there. So they go to the bushes, and this video has been enhanced, and I'm sure you're going to hear a lot of testimony about this video, enhanced the best they could by GBI Cyber. And I know the court sat through some motions to suppress where this black Adidas hat, there was a lot of discussion about, and you're going to hear more about all of those things. But this is an image that they locked in on and began to circulate around the neighborhood, or as the cops call a bolo. Be on the lookout for this individual. They didn't know who he was, and they circulated that. But they did go also that night, still the night of February 22nd, to the bushes, and they found 3 black disposable kitchen gloves, and those gloves were also sent immediately to the crime lab. And one of the interesting things about the black disposable gloves, when they got to the crime lab and they were analyzed, this is a picture taken at the crime lab, is that on the thumb of the gloves there was a hole. There's also other holes in the gloves, and they found them, but on the thumb area of one of the gloves that the crime lab examined, they found a hole. And they also found blood, and that blood was later to be determined to be Laken Riley's blood on those gloves. So I've already told you about the geographic locations. They're all clustered. You can see in this map, the crime scene is up top in the middle, called body crime scene. The dumpster where the items were found is marked. Building S is right by the bus stop, and then Laken Riley lived further up, Millage Avenue, towards the top of this photo. But the distance between the Building S, which will become important, and Laken Riley's body is about 300 yards. The distance between the dumpster and Laken Riley's body is about 500 yards. And the distance between the dumpster and the bus stop and where the defendant lived, because he lived in that apartment complex, is about 150 yards. Everything is close together. So what happened next in the investigation is that the very next morning, on Friday, February 23rd at 8:32 a.m., as ACCPD, again, is just looking out for anything. They had the bolo at that point. They encounter a person named Diego Ibarra. And Diego Ibarra is wearing a black Adidas hat that has some interest to them, which is they believe to be the identical hat that they had seen in the video the night before. And I will tell you this, on that hat that Diego Ibarra was wearing the next day is Laken Riley's blood. So their theory that that was in fact the same hat was absolutely correct. So they encounter Diego Ibarra. He gives them a fake green card. They know it's fake because it has 2 different dates of birth on it. And so they ask him to go back to his residence, and they begin talking to him. UGAPD arrives, and they begin to take over the scene. From the information that they had gotten from Diego Ibarra, they knew that hat was a hat seen in the video because of the proximity of the crime. And at some point, Diego began telling them he's got brothers in the house sleeping, and there were many communication difficulties at first because the first responding officers did not speak Spanish. No one in this apartment, D126, could speak English. So at some point, UGA brought 2 of their Spanish-speaking officers on scene, and the communication became a little easier. Officer Bridges, Officer Sand, both of whom are native speakers of Spanish, arrived and began taking over the communications. When they get there, they are attempting to secure the residence for a warrant, and before they could do a security sweep to secure the residence for a warrant, Argenis Ibarra, who's in the middle in this slide, comes out with a garbage bag in his hand. He eventually gives officers consent to enter the residence, and when Sergeant Epps enters the residence, he sees Jose Ibarra asleep in the bed. And that is how he's been identified in this case. You will see there are 5 residents that lived in apartment D126. Jose Antonio Ibarra, this defendant, also goes by the name of Victor, which will be important because a lot of the communications within his phone and some of the witnesses just call him Victor. So Jose Ibarra is Victor. It is in fact the same person. Diego Ibarra is Jose's older brother, goes by the name of El Gocho, is a nickname that many people, including this defendant, call him El Gocho. Argenis goes by Manny, and Rosbelli Flores Bello goes by La Gorda, and then Juan Carlos Diaz Hernandez they call Carlito. And I suspect the state will tell you right now we are definitely You're going to hear from Rosebelly and that residence. You will also hear that all the residents, Diego, Argenis, and Rosebelly, at least those three, are currently in federal custody on some immigration issues. But we are going to produce Rosebelly to testify to the court about the things that she saw and observed that day. And it is Rosebelly who identifies Jose Ibarra from the dumpster video. The officers, when they saw Jose Ibarra that day, saw that he had many injuries to him. Scratches on his arm, scratches on his wrist, scratches on the back of his neck, scratches on his hand. And they photographed those injuries to him. And then they began to do an additional canvass of this entire apartment complex. There are multiple buildings in this apartment complex, A, B, C, D, and E. Multiple teams of agents began going around looking for cameras, talking to residents. What do they know? What do they not know? And one of the things that they found is that the Ibarras lived at D126. Right next to them is D125, and right next to D125 is D124. 124 had a ring camera. 125 had a still camera. And they went and collected videos from those two apartments. And importantly, on the day that Laken Riley was murdered, at 10:21 a.m., Jose Ibarra is captured on D124 coming out of his apartment with a bag, and now his clothes have changed. He's wearing different clothes than he was wearing about 40 minutes ago. And he has a bag in his hand, and he's walking towards a dumpster, another dumpster in their apartment complex. And that dumpster, by the way, had been emptied the day of the murder. So when the officers went to check that dumpster had nothing in it for them. But in the next door neighbors, still camera shot at 10:24 a.m., 3 minutes later, Jose Ibarra is walking back towards his apartment, empty-handed, nothing in his hand. So they searched the residence that day, and they found a few things of significance. Number one, they found 3 more black disposable kitchen gloves, which were sent to trace evidence for plastics and polymer examination, and they concluded that they had originated from the same source as the gloves that were recovered in the bushes. They recovered 2 of the defendant's Samsung cell phones, which you will hear some evidence out of, but they also found no bloody clothing, no bloody anything. And the shirt and the satchel that you see the defendant wearing in the video, the dumpster video, were never found. They're not in that residence. So what other forensic evidence? The parties will stipulate to the prior Daubert hearing that this court has heard, so we will not be recalling the fingerprint evidence, but we will have a stipulation with the transcript and all of the exhibits that thumbprint, latent print that was on the phone, was sent to ACCPD that night, and eventually the digital image of that thumbprint on Laken Riley's phone was compared to Diego Ibarra, Argenis Ibarra, Rosebelly, and Juan Carlos, and they were all excluded. They didn't leave that thumbprint behind. And it was matched to this defendant, Jose Ibarra. It is Jose Ibarra's left thumb on Laken Riley's phone. And the analyst or the expert who did that analysis testified at the Daubert hearing. He showed the court 15 points of comparison that he found, and his results were peer-reviewed by another examiner. They were peer-reviewed blind, and she agreed with him. There's also DNA in this case, and you're going to hear about 3 different types of DNA: traditional, YSTR, and true allele. All true allele is probabilistic genotyping, but it is a computer software program that deconvolutes or separates complex mixtures of DNA. That's what true allele does. But before you can go to true allele, you have to start with traditional DNA. So all of the items of evidence that you're going to hear DNA results from started with the traditional DNA. They were swabbed, they were amplified, they were
quantified, all the things that you do with regular DNA. But we do have some regular DNA results in this case. First and foremost, the jacket. The jacket found in the dumpster has blood on it, and in the blood for traditional DNA is Laken Riley's DNA and this defendant's DNA, and only the two of them. Jose Ibarra and Laken Riley's blood are on the jacket that he dumped in the dumpster. The rocks and the trees from the crime scene, they were also processed for DNA, for latent prints, and for everything we got. But on the rocks in the tree, just Laken's DNA, Laken's blood on the rocks in the tree. They attempted at first, which is protocol, to do what's called YSTR DNA testing on Laken's fingernails. So both her left and her right hands were swabbed by the medical examiner in this case, and they were both sent to DNA for analysis. YSTR is a better fit for trying to separate male and females because only males have Y chromosomes, and so they attempted YSTR first, and they were successful. The problem with YSTR, and the officers did gather the DNA of Jose Ibarra, Diego Ibarra, and Argenis Ibarra. They are brothers, and blood brothers share the same paternal line, and they share the same YSTR profile, unless there's a genetic mutation. And what the lab found when they tested the fingernails of Laken Riley is that, first of all, the left hand, there's nothing. No DNA of any other person other than Laken. But on her right hand, there was male DNA. And for the YSTR testing that they tried first, Jose Ibarra could not be excluded as the donor of that YSTR profile, and neither could Argenis, because, again, they're blood brothers, they share the same YSTR profile. But Diego could be excluded, and that's because Diego carries a genetic mutation that the lab was able to see, and he was able to be excluded as the donor of YSTR profile underneath Laken's nails. But after the YSTR was done, it was then sent to True Allele, along with a lot of other items. And when True Allele tested, and the data was sent into the True Allele program. It didn't test it, but when the data was sent into the True Allele program, True Allele excluded Argenis as the donor. True Allele excluded Diego, who had already been excluded by STR anyway, but True Allele matched Jose Ibarra to the DNA underneath Laken's right fingernails, to this likelihood ratio, which I have before the court here. 10 billion times more probable than a coincidental match. I will tell you the gloves that were tested, that's all just Laken's blood, the black gloves that were in the bushes. There's a straw that was tested, that is the defendant's blood. I want to talk to you about that a little later. And then the hat, the black Adidas hat, is also Laken's blood. And then the jacket also did contact swabs. So in addition to the blood on the jacket, they did contact swabs that were sent to True Allele. And again, it's the defendant and Laken on the jacket. But importantly on this dark blue jacket also, Laken's hairs that were wrapped around the button were sent to trace evidence. They are consistent with Laken Riley's hair, and of course it's consistent with her long dark hair and all the microscopic analysis on it. Her DNA is on that jacket, so there's really no need to do DNA on the hair because her DNA is already on the jacket in the form of blood, but they looked microscopically at her hair and it was consistent with her hair. But the important thing they found about several of the hairs, I believe over 15 of them, is that they were forcibly removed from her head. They did do a sexual assault kit on Laken, and several things were tested. But the bottom line is her entire sexual assault kit was negative for male DNA. Her clothing was looked at with AP, P30, you'll hear about that. There was no semen present. However, her underwear was sent to the trace evidence section as well, where they concluded that her underwear had been forcibly torn. So the medical examiner, Laken was sent to GBI headquarters in Atlanta or Decatur, where Dr. DeMarco conducted an autopsy on her the very next day after her murder. What the medical examiner found is that Laken had depressed skull fracture on the left side of her head, and she had 8 other lacerations on the left side of her head, which literally look like holes. She had a small subarachnoid hemorrhage on the right side of her head, and she had multiple abrasions to her face, her neck, and her torso. She also had what's called petechia in both eyes, which is consistent with some form of asphyxia. And asphyxia can come in many forms. It can be a drowning, but most importantly in this case, it can be a form of strangulation. It can be manual, it can be ligature, it can be all kinds of things. But what the medical examiner said in this case is that Laken Riley died as a result of the effects of blunt force trauma to the head and asphyxia NOS, not otherwise specified. She can't really say if it was from chest compressions, maybe manual strangulation, but there was something going on in this struggle where this defendant deprived her brain of oxygen for long periods of time. And that was her cause and manner of death. But I want to talk to you about something that happened before, and it is count 10 of the indictment, and it is a peeping Tom. Shortly before 7 a.m., Jose Ibarra is seen on a trail cam, and this is a version of the trail cam, or this is the angle you'll see. And you'll see an individual, and the state will be the first to tell you this video quality is not fantastic. But there's more than just this video. You'll see an individual wearing a dark hoodie, eventually a dark hat, black gloves, and holding a styrofoam cup. And UGA attempted to enhance this video. GBI Cyber attempted to enhance this video. This is about as good as it gets. You can see a bag. They've studied this video 1,000 times. You'll hear the things that they saw in looking at these videos. The male is seen on the trail cam exiting the defendant's apartment complex. That's how he gets onto the trail. It's further beyond outside the scope of this exact clip. But he gets on through a path from the defendant's apartment complex to this trail that leads onto campus. And this is Rogers Road. This is UGA Village housing for graduate students. And this is a bus stop that's used by students to take the bus to get to a class. At 7:01 a.m., this individual is seen at this door that you're going to see in the bottom or the middle of your screen. That's apartment 114. And in that apartment, 114, Building S, lives a graduate student. She's an Indian national. Her name is Tejaswi Sarathi, and she is here at the University of Georgia studying. This defendant is seen trying to open her door at 7 o'clock in the morning. And there's about an hour's worth of video that was watched by UGA PD that between 7:01 a.m. and 7:57 a.m. on the 22nd day of February 2024, about 70 minutes before Laken Riley is murdered, this defendant goes to the door of apartment 114 6 times. Twice they can see on video that he attempts to open her door. And at one point you'll see in the video where he ducks down. And that is because at some point the student inside heard him at her door, and she approaches him at the door and says, "Excuse me." And she will testify to this court that when she said that, she's looking at her peephole, he ducks down. And you can actually see that on the video. And just here's a portion of her 911 call where she calls at 7:57.
And what's going on? I was in the shower and then I heard some noises and I came to check that someone was, I saw through the peephole. Someone was trying to open the door. And then I said, "Excuse me," and then they just ran away, and then now they kept trying to look through my window. Okay, and what's going on?
So she says she was in the shower and she heard her door jiggling. And she said that somebody was at her door. She says, "Excuse me," he ducks down and he tries to look through her back window and does look through her back window. This is her back window. This is the backside of Building S, and this is exactly how it was that morning. This is body cam footage of Officer Bridges, who's one of the officers that responded. Her blinds are open wide. They're open, not only open, but they're pulled up more than halfway. The right side is her living room. The left side window is her bedroom, wide open. Her blinds were that morning. She said that's how she kept it because it was kind of a dark place, and it was more comfortable for her to have some light in, and that's how her windows were. And she said when she turned around, she could see the person who she can't identify. We'll be the first to tell you she can't identify him. She didn't get a good look at his face. He had that hat over his face. He had a hood on. She describes the clothing: dark hat, dark jacket. Didn't get a look at his face because when she looked through the peephole, he ducked down, but she could see him peeping into her window, looking into her window. So the FBI CAS team is a specialized team with federal government that analyzes digital evidence. And they were brought in this case to look at data from the defendant's phone, the victim's phone, cell phone records, all of these things. And some of the data that they got from the defendant's cell Samsung, one of them, which is 1B7, which you'll hear a lot from, is called Rubin data. And Rubin data is something that's collected by Samsung, and the FBI CAS team analyzed the Rubin data, looked at the Rubin data in this case, and at the time of the peeping at Tasia Swee's apartment, the defendant's 1B7 phone is right over her house. And these are the digital points by the FBI. But also, there is a white styrofoam cup. In the video, you can see black gloves and the white styrofoam cup of the peeping. This cup was found by UGA-PD as they were coming onto the trail to come to Laken Riley's scene. They thought it was unusual because there's no trash out there usually, and it's just sitting there. They collected the cup, and you can see in this next image, if you see where the retaining pond is in the middle of the screen, the cup is near there. So in between Building S, where Tasia Sweet lived, and in between where Laken Riley's body was found, was this white cup. That white cup was collected and sent to the crime lab at the GBI, and it is the defendant's DNA on the straw of that white cup in between the two crime scenes. So also, out of his phone and out of his social media, the defendant, when he woke up that morning, kind of did us a huge favor and started taking pictures of himself. And here are the pictures that he took of himself and posted on Snap, and also can be found in his phone. And one was taken at 4:30 a.m., the second one was taken at 5:37 a.m., and you see in that one that he is wearing the black Adidas cap with the stickers on it, with the same jacket, with the hoodie. Also, he took pictures of himself wearing the same shirt that you see in the video of B32 and the bag that was never found that you see on the side of him in some of the videos taken on the day of Laken's murder. And also you can see from, again, D124 and D125, the day before the murder, he is wearing the evening before the murder, so this is the 21st at 9 p.m. He's wearing the same clothes. So in the end, Your Honor, that is a summary of the evidence that the state has in this case. You will hear forensic evidence. You will hear digital evidence. You will see videos, all pointing to the same conclusion, that this defendant murdered Laken Riley, and he also peeped Tasia Swee's apartment. At the close of all the evidence, we are going to ask that you find him guilty on every count of this indictment, because the state will be able to prove every bit of it. And we ask that with your verdict, the close of the evidence, that you bring justice to Laken, Tasia Sweet, and this community. Thank you.
All right. Jose, thank you for not being so aware of your surroundings. You're taking pictures. Sorry. You're taking pictures of yourself the day of, hours before. Thankfully, criminals or people that do things like this are what they are. You know, thankfully that they're, I don't know, I guess he thinks he's going to get away with it. I don't know. I just don't know. Anyway, so that was the state. Now here's the Here's his defense. And it's real short. It's only like 10 minutes if that. So this is defense opening. Statements. This is also from November 15th. November 15th of 2024. Defense opening statement. All right. All right, defense opening.
Judge, the evidence in this case is graphic and it's disturbing. What happened to Laken Riley is graphic and disturbing, and it is a tragedy. The loss of any life that young and apparently full of promise is a tragedy. And I'm sorry that the family is having to go through this and be here for the presentation of this evidence. People have used this case for their own personal gain, financial gain, political gain. And while this process has its place for testing evidence, it's very poorly suited to healing hearts and minds. So it's the evidence that we have to talk about. And the evidence in this case is very good that Laken Riley was murdered. The evidence that Jose Ibarra killed Laken Riley is circumstantial. The evidence that anyone had any intent or certainly committed any sexual assault is speculation. Most importantly, in this case, you'll hear no evidence that a sexual assault was committed. You'll hear nothing from the GBI, the FBI, UGAPD, ACCPD, that after looking at all of the evidence in this case, scouring for anything that could help prove this allegation in the state's indictment, that they found any biological evidence that would suggest that, any physical evidence that would suggest that. There's no injuries that are consistent with the sexual assault. And in this case, it's an effort to explain a tragedy. But it's not based on evidence. The evidence that Jose Ibarra killed anyone is circumstantial. The state's presentation in their opening had a lot of detail about information, again, that showed that this event happened. But upon a closer look at the evidence that links Mr. Ibarra to that event, it is lacking. You'll hear that his phone was in the area, and you'll hear that the cast team that ran the locations of this phone. And there is good evidence that the phone itself was in the area. What you'll also hear, though, is that when they looked into this phone, when they did a close examination of who was using this phone, it wasn't just Jose Ibarra. It was other people in that apartment who were using this phone. And that comes through an investigation into the accounts that were used through this phone, and also from people who met other people associated with this phone who had used the phone to message people. And so while the phone was there, that's true. It doesn't show that Mr. Ibarra was there. And you'll hear that Mr. Ibarra's fingerprint was on Laken Riley's phone. But you'll also hear that he was wearing gloves, supposedly. And that this hole that was supposedly in the gloves that they found would not have left that mark. You'll hear that someone in that video, in the so-called dumpster video, was wearing an Adidas hat. That's true. When they find that hat, and specifically the hat that was tested in this case, it was worn by Diego Ibarra, not Jose Ibarra, Diego Ibarra. And you'll also hear, and the state will ask you to consider different types of forensic evidence and to suspend your understanding of how that evidence is evaluated. Because while they will say that Mr. Ibarra's DNA was present at the scene, what they'll tell you is that without this software that we can't test, this proprietary software used by the GBI, without that, their expert wouldn't have been able to say whose DNA it was. She wouldn't have been qualified to testify about whose DNA that is. So they have to use a machine. And they're going to ask you to trust that machine where the human being isn't good enough. But with this fingerprint, they're going to ask you to trust a person because a machine isn't good enough. When they run those fingerprints through the database of fingerprints where they know Mr. Ibarra's fingerprint is, it doesn't come up. And so while a machine is good enough in one situation to try to convict Mr. Ibarra, it's not good enough in another. And it's this kind of gymnastics that it will take to tell the story with this circumstantial evidence. We waived a jury trial in this case with the hope and trust that despite the nature of this evidence, that you could come to a verdict that was not just a way of easing this family's suffering, but it was based on an impartial and honest assessment of the evidence in this case. If that happens and the presumption of innocence is respected, there should not be enough evidence to convince you beyond a reasonable doubt that Mr. Ibarra is guilty of the crimes charged.
Yes, Brat. Where? It's a beard stroker, Brat. Where else have we heard a defense say, "Your Honor, it's my client is guilty, or is not? My client is innocent because he was wearing gloves. There's no way his fingerprints could be there." Okay, all right. So now we're going to get to the body cam. So let's get to the body cam and his and him creeping around, because that is creepy. So let's get to this, because I remember watching this live and I'm like, oh boy, that is creepy. All right, hold on. So let's go back here. All right, so this is webcam. Let's see, this is from February 29th. All right, so this is testimony from November 29th of 2024. So yeah, he was definitely just he was just creeping around. Let me put myself over here. Yeah, he was just creeping around for sure. All right. Just looking, he was hunting, right? He was hunting, stalking, whatever you want to say.
We've got open the GBI Cyber folder. What is the date and time that we're looking at on the video? Can you show us?
It's February 22nd, 2024.
And before we talk about what we're about to see, let's get a little context. Is there a bus stop here?
There is.
Can you point to it with the pointer? There's a pointer right in front of you.
Right.
And in this frame, where's building S?
Building S is over here to the left.
And the road that we see that there's now a red line on, what road is that?
This part here is Village Avenue Extension. This is Rogers Road where they come connect at the bus stop.
She cannot hear you. I can tell by the way that she's shaking her head. You're going to have to say that one more time into the microphone. Just say it again.
The road on the right is Village Avenue Extension. The road on the left is Rogers Road, and they come together at the bus stop.
In this frame, do you see a pathway to the Celia at Azul apartment complex?
I do.
Where is the pathway? Is that where the individual is coming out of at this point that we see in the frame?
Yes.
And is there another pathway to that apartment complex?
There is.
Can you show us that one as well? Okay, so that's further back. And if a person were to continue walking down Rogers Road, where would you end up?
At the very end?
Yes.
It makes a turn to the right and it goes down to Village Avenue.
And is there a bigger road that is near here? Like, where's 10?
Loop 10 is back here.
Okay, thank you. This bus stop, is that a University of Georgia bus stop?
It is.
So one thing I that jumps into my mind, it's like, is this, and I would love to talk to somebody about this, is like, is this just like this urge that jumps into your mind? It's like you have to have this fix, right? It's like this addiction, right? Is he like addicted to, SA? Is he addicted to, he's got to scratch that itch, and he had to go do this. It's like this burning desire, like why else would you do this,
I am going to pause at 6:53. In this frame at 6:53, do you see apartment 114 in Building S?
I do.
Can you please point it out to the court? So it's the lit up door at the bottom floor of Building S.
It's the southernmost tip of the building.
actually surprised there's nobody around. It's 7 o'clock in the morning and nobody's around. Like, I would think there'd be more activity. I know it's a college dorm, but still, I would think there'd be more activity. It's like, right, it's 6:54. I would think there'd be more activity, but maybe not. So I'm just surprised that there's like nobody around.
I'm going to stop it at 6:54. First of all, in the entire hour that this individual is around this area, does he ever talk to anyone?
No.
Ever engage with any person?
No.
Do you see from 6:52 to 7:54 this individual go to the Building S door?
Yes.
In that time frame, how many times does that person go to the door? And we're going to see them each time.
6 times.
And can you see on your video of those 6 times how many times that person actually opens the screen door?
Twice.
And the nature of this footage, how would you describe this footage? Is it great, grainy? I mean, how would you describe this?
At times it is good quality, at other times it is a little grainy.
Why is that? Is that just a function of the camera?
Yeah, it's connected cellularly, so sometimes when there's motion, it the quality gets better, but then when there's no motion, the quality disappears a little bit.
And did you make screenshots of this still video at some point in your investigation?
Yes.
I'm going to hand you what's been marked for identification purposes. State's Exhibit 85, State's Exhibit 84. Do you recognize those items?
I do.
What are they?
There are pictures of the individual that was seen walking around the building.
And are those some of the screenshots that you made?
Yes.
The state would move to admit States 285 and 284.
Any objection? No, sir. They're admitted.
And were you all, or were you, in your investigation, attempting to identify the clothing and items that this person was wearing?
Yes.
And in your review of this video, were you able to see, first of all, gloves?
Yes.
Can you point to those? What color are they?
Black.
Were you able to see a cup?
Yes.
Can you point to that? And then were you able to see a bag? And it may not be best in this video at this point, but in one of your still shots, can you see a bag?
Yes, I can.
Can you please, I'm going to just show it to the court. Is it where my finger is?
Yes.
Okay, that just is the way to do it. Is that a better view of the bag now?
Yes, it is.
All right, at 6:54. At 6:58, what door did that individual just walk by?
114.
What are we seeing at 7:01?
We see him walking up to 114, and he's standing in front of the door. Now he's opening this outer screen door of the apartment. Now he walks back behind the building.
And now our next clip is at 7:06, so that's how Cyber just put it together. So we're not watching 5 minutes of dead video.
Correct.
But when you see him go to the back of the building, in the back of the building, are there windows in the back of the building?
There are.
And are there windows to 114 in the back of the building?
Correct, and it's on the ground floor, so it would be at, head level, chest level of an adult.
This 7:09 clip where I'm pausing, in what direction is now this individual going?
He's walking south.
Okay, and the IM fields from here, intramural fields, you're familiar with those, correct?
Correct.
Where are they in relation to where he's walking?
They're to the east of that, southeast of that, but you can access it by going south and then turning east.
Would this individual be walking in the direction of the IM fields?
Yes.
So now we're at 7:33. So between 7:09 and 7:33, do you see this individual on this trail cam?
No, I do not.
Okay. In what direction now at 7:34 is that individual walking?
He's walking north back towards Building S.
I'm going to pause it at 7:39. So at the last clip that we saw at 7:33, did that individual go back behind Building S again?
He did.
Okay. And I asked you about the windows in Building S, and is that, states 276 has already been admitted. Is that what the back windows look like in the back of that building?
It is.
And how they were also on that morning?
Correct.
Just publish again to the court, 276. So he leaves in that direction at 7:33 towards these back windows.
Correct. He's now standing in the cutout window in the stairwell.
What is that cutout window?
There's a stairwell inside there, and there's just the cutout that they have in there.
And that's at 7:40?
Yes.
What floor is he on now? 742?
He was on the second floor.
At 7:43, is that a UGA bus?
It is.
Does it pick up presumably students or the people that were waiting at the bus stop?
Correct.
Okay. $7:44. What door did he just walk by?
114.
And the direction, and now we're at 7:46. So hold on. So it goes from 7:44 then to 7:46. So 2 minutes are missing because we clipped it together, correct?
Yes.
But you watched all two minutes in between of 7:44 and 7:46.
I did.
All right. We see him disappear at 7:44. Does he go again around the back of Building S?
Correct. He does.
And how many minutes later does he come back again to the front?
2 minutes.
And that's what we're about to see here at 7:46?
Yes.
Does he touch the door at that time?
It appears he does.
All right. And again, it's now we're at 7:48. Again, we lost about 2 minutes.
Yes.
In between 7:46 and 7:48, where does he disappear to? In what direction?
To the back of the building, and then comes back again.
So 2 minutes later, he's back at the front door.
Correct.
And that's what we just saw.
Yes.
And now at 7:48, again, where does he go off to?
To the back of the building.
Now we're at 7:49.
He's back at the door at 114.
Does he touch the door at that time?
It appears, it's hard to tell because of the quality of the video, but he doesn't open the door.
7:51 now.
He's just standing in the area.
And when he left the frame at 7:49, which direction did he go?
Back towards the back of the building.
And then at 7:51, we now see him again in the screen?
Correct.
What do we see here at 7:54?
7:54, he had, from that 51, he had gone back behind the building and come back to the front of the building, and he was standing at the door.
And can you see him open the door here?
Yes.
At 7:54?
Yes.
And what does he do right there at 7:54?
He is ducking down.
What direction is he going now?
Back behind the building.
And we just lost 2 minutes. We're now at 7:56. So you described he ducks down at 7:54.
Correct.
He goes to the back of the building.
Correct.
And then you don't see him again until 7:56. Is that right? So there's 2 minutes that we don't see in this clip, because we're not going to sit here for all this time, where you don't see him on camera.
That's right.
So you see him again at 7:56. And in which direction is he going now?
He's going south.
Towards?
The IM fields. And here he disappears into the woods. There's no path there, just woods that he goes into.
Okay, and I'm going to stop it here. So in this time period from 6:52 to 7:54, we've just watched all of that. Do you see, first of all, is this person alone or with someone?
Alone.
And have you watched, in all of your hours of video review in this case, have you seen Diego Ibarra?
No.
Okay. In this time period?
No.
Okay. Have you seen him before?
Yes.
As a matter of fact, you swapped him, and we're going to talk about that, right?
Correct.
Do you know what Diego Ibarra looks like?
I do.
And have you looked for him in all of these videos that you have reviewed?
Yes.
And on the 22nd day of February 2024, you ever see Diego Ibarra on this trail cam?
No.
Now I want to move on to the other clips, and then we're going to go back to your last clip that you made, okay? So what time are we at now?
9:05 a.m.
What part of the trail are we on?
This is Millage Avenue Extension as it's coming towards the bus stop.
What time? You said 9:05 a.m.?
Yes.
And do you recognize that individual we see in the screen?
I do.
Who is that?
That is Laken Riley.
Do you see what, if anything, she has in her left hand?
She is holding her phone in her left hand.
What direction is she running?
She's running south.
And was that also in the direction of the IM fields?
It is. She now went east towards the IM fields and the railroad tracks.
At 9:06 and 49 seconds?
Yes.
And now we are at a different time period. What time period are we at?
11:36 a.m.
What part of the trail are we on?
This is Millage Avenue Extension.
And do you recognize those two individuals that we now see in the frame at 11:36 a.m.?
I do.
Have you met them before?
I have.
And what are their names?
Sophia Magana and Lily Steiner.
And the dog is?
Champ.
Okay. Is that Sophia's dog?
It is.
Which direction are they going?
They're going south.
Now what time are we at?
11:55 a.m.
And who do we see in the frame now at 11:56?
Sophia and Lily and the dog Champ.
Now that it's the sun has come up, how would you describe the lighting that day?
It was, I think, partly sunny that day. It was a little bit windy.
I have to load the Gen-Tech player for this. This may take one moment. This is why we decided not to play it this way. So you told us you watched, while we're waiting for the Gen-Tech player to load, that this trail cam for the entire day. What were you looking for?
Anybody that matched the description or anything that would have been suspicious activity.
I'm going to now play the part of your 279 that says Ibarra returned. First of all, I'm stopping here. At what time are we at?
9:41 a.m.
Is this still the same trail camera?
It is.
And in this frame, do you see the cut-throughs, for lack of a better term, to the Celia? How do you say it again? Celio at
Azuli.
Say it one more time.
Celio at Azuli.
Okay, was that the name of the apartment complex at the time?
It was.
Okay. Can you spell that for Madam Court Reporter?
Cielo-Azuluk.
Okay. Celio at Azuli. Show us where the two cut-throughs are to that apartment.
Could you make it bigger?
I can. One in the bottom screen and one in the middle of the screen.
Correct.
I'm going to play at 9:41. We see some red now coming through. Well, I just saw some red. Hold on, stop. I'll stop it. At 9:42 a.m., do you see the red?
Yes.
What's the red?
It's detecting motion, the camera.
And what, do you see an image?
I see a blob, appears to be a black blob.
Okay. And in what direction is that blob heading?
It's going west towards the Celio at Azuli apartments.
And during this time period, when you watched all of this trail cam video, did you see anything else suspicious or that got your attention, or any other people that got your attention?
No.
I want to ask you about a few other things that you did in this case, Detective. First of all, did you review the cell phone of Laken Riley?
I did.
And it was extracted by your department?
It was.
Could you toggle over, Your Honor? So since 177, the very first video that we're playing, is on mute, tell the court what we're looking at here.
I'm arriving on scene initially. I'm about to meet with Sergeant Tim Johnson, Matthews Park County Police Department.
That individual we see in the frame at 1337, who's that?
That is Sergeant Tim Johnson. I can't remember the name of the other officer in the background, and that is Diego in the red sweatshirt.
And what apartment number is Diego standing out front of?
D126.
Does Sergeant Johnson show you an image at some point in this encounter with him?
Yes, right now he's showing me a still frame image from video that they had recovered that I didn't have at that time.
And that still frame image, do we see it in your screen at 1337?
Yes, ma'am, on the phone.
And was that an image taken from a dumpster nearby?
Yes.
So he shows you that image, and then what do you do?
This is news to me. I was coming on shift roughly maybe an hour before this. So I relayed that to my superiors who were about to pull up, coincidentally, and then explained to them that, hey, they've got footage. At that time, I was not aware that they had already been aware of that footage.
The footage that was shown to you by Sergeant Johnson, what, if anything, was significant about it to you, and then what you were observing for yourself on Diego Ibarra?
At first, videoing it or reviewing the video, the still frame photo, Sergeant Johnson informs me that the image shows a male holding a hat or having a black Adidas hat, and then he informs me that I couldn't necessarily see from that distance till I get closer to Diego, but that Diego is wearing an identical hat, a black Adidas flat-bill hat.
Did you make any observations about the hat that Diego was wearing?
Once I got closer, yes. I noticed on the back what I believe to be dirt on the brim.
And was that significant to you?
Yes.
Why?
Because I was on scene when we located Laken the day prior. She did have a lot of dirt, mulch, and things like that on her body. And I felt that if an individual was wearing that hat and was touching Laken in that manner, dirt could have been transferred to the hat by moving the hat.
So I'm going to fast forward a little bit for the record. At some point, do you begin talking to Diego Ibarra through your interpreter?
Correct. Yes, ma'am.
And how would you describe Diego Ibarra's demeanor with you and with you?
He's compliant. He's not posing any issues. Obviously, there's a block there through communication. But based off his physical mannerisms, I'm not really getting any deceptive behavior per se. I was aware at this point he did provide a fake green card, so he was detained for that.
Right.
He seemed to understand that we were detaining him for an investigative purpose. There appeared to be good rapport between him and officers, especially with Officer Bridges there, who you see.
If you could, do you have the pointer in front of you?
I'm not sure if I do.
Oh, here we go.
Thank you.
Point out to the court at 1342 in your muted video that we're playing. Where's Officer Bridges?
He's right here in an identical uniform that I'm wearing.
All right. And the one closest to Diego in this frame?
Correct.
Okay. Go ahead. So you talk to him at some point. At some point, do you decide to obtain a search warrant for the apartment and to freeze the apartment?
Correct.
Tell us a little bit about that process.
Based on the fact that he was wearing that hat, the time frame that Tim Johnson encountered him was within 24 hours of the murder. He was walking back towards the general direction of campus, which was concerning as well. He somewhat matched the description of the male seen in that photo, discarding of what I later learned was evidence found in that dumpster.
And specific what evidence?
A sweater or a pullover of some sort with blood on it.
Okay.
And hair.
Okay. And did you ever see that evidence, or you were just informed of it?
No, it was picked up throughout the middle of the night. I was there all day the day before. They sent me home to get a sleep cycle, and I was the supervisor this day.
All right.
So I never saw the evidence throughout the night.
All right, go ahead.
And
what
then
about the proximity from the dumpster to Laken Riley's body?
The dumpster to Laken Riley's body, probably rough estimate 500 yards.
Okay. All right.
Yeah.
So at some point, when you're with Diego Ibarra and you decide to get the search warrant, how do you communicate that to get the search warrant?
I go and talk to my superiors and I ask them, because they're maybe 20, 30 yards away in the parking lot at another vehicle discussing. I think they were talking to some GBI agents and other agency partners. And I asked for clarification of, at this point I gained knowledge there were other individuals inside the apartment. I wanted to start getting resources in and confirming that yes, we are going to go ahead and surround it. A warrant's going to be sought. And I need other translators here because from what I'm gathering, no one else speaks English inside the apartment.
And how many other individuals did you believe to be inside the apartment?
At this time, 3.
And could you see them from where you're standing?
No, not without being intrusive of sticking my face up to that window, which we didn't do. One, for an officer safety standpoint, but also, I didn't have a warrant at that point yet.
Do you see the window? You said the window. Can you point the window out?
Yes.
And that's again 1342. Is that the window to D126?
Yes, ma'am.
All right. I'm going to roll a little more. At some point, do you start asking Diego questions about whether he has any injuries?
Eventually, yes, I did.
And do you take pictures of him? And do you see parts of his body?
Correct. Yes, I did.
Going to play the video first, and then show you some photos. First of all, did you? You mentioned to us that there was a fake ID, so you knew he had given a fake ID. Tell us a little bit of that process.
I didn't obtain it myself. It was provided to Sergeant Johnson when he located him and was identifying him. Sergeant Johnson provided it to me and stated, if you look at it, there's 2 different dates of birth listed. There was one vertically on the side and then one listed with the rest of his identification information.
So did you agree with Sergeant Johnson's assessment that this was not a valid form of government identification?
Correct. Yes, ma'am.
I'm going to go to, I'm still muted. Okay. About 1358 on State's Exhibit 177. What are we looking at here now at 1358?
I believe at this point my captain, Seth Robinson, was interested in seeing his hands.
And does he show you his hands?
Yes. So Captain Robinson, I believe, asked Officer Bridges to relay to him to please, show us your hands, and he complied. Okay. But put his hands out.
And did you see his hands?
I did.
Did you see any injuries to his hands?
No.
At 1359, what are we seeing Diego Ibarra do?
He was asked about, I believe they were asking this, if he could take his jacket off, and they were looking at tattoos as well as trying to make observations of any other potential injuries.
Go ahead.
And he takes his jacket off and becomes, I don't know exactly what he says, starts kind of ranting a little bit and pulls his shirt up and shows us his stomach and his side tattoo.
And do you see any injuries on his stomach?
From my vantage point, no, I did not.
And if you had seen any injuries, would you have documented them?
Yes.
Okay. So may we toggle over, Your Honor? States 178, what are we looking at there?
That is a picture of Diego.
And do we see the hat he's wearing in this image?
Yes.
Is that the black Adidas hat that you've already described?
Yes, ma'am.
States 179. Well, who is that?
That's Diego.
Okay, and on his face, does he have any tattoos?
He does. He has a teardrop tattoo on his right eye, kind of off to the side there. It's a little hard to see if you zoomed in, but we identified as potential gang affiliation tattoo.
Can you point to that on
Yes.
the right side for 179? Okay. So what that image is, or that mark on his face at States 179, was that an injury?
No, it's a tattoo.
All right, thank you. States 180.
Again, it's Diego.
And do you see a tattoo on his neck?
Yes, ma'am.
All right, please point to that. 182.
Diego again.
Okay, does he have tattoos on the back of his neck?
Yes, ma'am.
Could you please point to those? 183.
It's a close-up of the picture we just looked at.
And in 183, can you actually see the rest of the hat?
You can, yeah.
Okay. 184.
Rib cage tattoo. I'm not sure what the design was.
So tattoos, but did you observe any injuries?
No.
At some point while you are there, Sergeant, and approximately how long are you at this apartment complex that day?
All day, from 8:32 in the morning, and I don't think I was released till probably 8 or 9 o'clock at night.
All right, I'm going to go back to a different section of your video. And again, we are going to, it's played on mute. We are now at 14:34 in the top count for the record. So that would be 9:38 a.m. Am I right about that?
Yes, ma'am.
All right. At 9:38 a.m., we see an individual in a yellow shirt. Can you please point to that person first of all? And who is that person?
That is a brother Argenis, either Argenis or Argenis Ibarra.
And how did this person appear in this video? What happened?
He, while speaking with Diego and waiting for resources and other things, he walked out with a trash bag, like a 5-gallon plastic white trash bag that you would buy at Kroger.
Was he detained as well?
Yes.
And did you photograph him that day?
We did.
And I don't need to toggle over, but States 185, who is that?
That's Argenis.
At some point, did you obtain consent to enter the apartment from Argenis?
Yes.
And did you in fact enter the apartment?
I did.
What was your purpose of entering the apartment?
Well, he informed us that something was on the stove and that he was very adamant about going in to turn the stove off, I believe because of a fire hazard. So that was what we asked for consent to do.
Okay. And prior to going in, did you look to see if there are residents inside?
I did what we call a threshold evaluation, so I kind of peeked around from an angle because the door was already open. When Argenis left, he left the door open. So I could kind of see what the environment inside looked like. And when I didn't see any obvious threats, that's when I got closer to the doorway.
In States 177, we're now playing the second video for the record, and we're at 14:42. Could you show the court where the open door is?
Yes.
In the frame? All right. I'm going to fast forward a little bit to the time where you made entry. And at this point, I am going to play, so 14, we're at 14:55 for the record, and I am going to play this video with volume because there's no statements of individuals, but the officers, and there is no confrontation issue here. But now our video is not working, our audio is not working. There we go.
Back by the bedroom. I don't know if that's an exigency for me to go in there for a suit. Just a calm dude. I gotta go into the other. That's true. Yeah. I'll do it. There's a guy right here. There's a guy right here. Yeah, but Hola. 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 Policia. Hey. Policia, manos. He said he left something on the stove. John's going to try and cut it off. Hey, I need you to translate one at a time. Come here. Come to me. Come here. For you. I need to see his hands. I need to see his hands. Tell him to slowly get out. Ask him to get anybody else. That's a match, man. Alright, say it slowly. Camina acá, despacito. Ven para acá. ¿Tienes algo en tus bolsas? ¿Hay alguien más aquí dentro? No. For me. Ven para acá. There's nobody else in here? ¿Hay alguien más ahí dentro? No. He said no. Turn this bitch on.
Okay, I'm going to pause it at 14:58 for the record. Were there people inside the apartment?
Yes.
How many?
2.
What were they doing?
Laying in bed.
Could you see their hands or their bodies?
No.
You had Bridges translate for you at some point, and when you went in, we could see a light. Were you holding a flashlight in your hand?
Yes, ma'am.
All right. Were there, in fact, beans on the stove?
There were in a crock pot, the ceramic part of a crock pot.
All right. And you turned those off?
I tried.
The individual, first of all, the 2 individuals was one male and one was female.
Correct.
Okay. The female, what was her name?
Her name was Rosabelli, and I can't remember her last name at the moment.
The other male that was in the apartment, what is his name?
Jose Ibarra.
And do you see that person that you pulled out of the apartment at 14:58 in this screen?
Yes, you do.
And what color clothing is he wearing?
Red shirt, black shorts, and like black and red sandals.
And the person that you pulled out of the apartment on the 23rd day of February 2024, do you see him in the courtroom today?
I do.
Please point to him and describe an article of clothing that he's wearing for the record.
He's wearing a striped button-down shirt.
May the record reflect the witnesses identified the defendant. Did you, at some point, have the opportunity to observe Jose Ibarra, the defendant, on scene?
Yes.
How close were you at times to Jose Ibarra?
Your normal conversation distance, maybe a foot and a half.
Did you observe any injuries to Jose Ibarra?
I did.
What injuries did you observe?
While speaking to him, I noticed on his right arm, his bicep, there was a scratch, which I identified as a potential defensive wound. On his left arm, he had a forearm scratch that was very similar, which in my mind looked like fingernail scratches to me. While he was sitting there speaking to us, I also noticed on his left wrist, just below the palm, he had a puncture, maybe a half an inch wide, that through my experiences of playing sports in high school and receiving the same injury from fingernails in football, I could see like wet flesh, like almost like it was fresh. It wasn't very old, possibly still irritated. And as he moved his wrists, when I was looking at them closely, I could actually see the liquid, or I guess body fluids that would be in that cut, kind of reflecting with light.
Did you observe States 172 for the record? This is the first video on that thumb drive. Do you see the dumpster that you were at that night in States Exhibit 172 in this video?
I do.
Okay. Can you please point to it for the court using a pointer? There's a pointer right in front of you.
This?
No. It's old school.
Yes. Okay.
In the center of the screen?
Yes.
All right. Do you see in the UFI video a date and time at the top?
I do, yes.
What is the date and what is the time?
February 22nd, 2024 at 09:43 in the morning.
Is that complete playing the clip of the B32 UFI video from the 22nd day of February 2024 at 9:44 a.m.?
Yes.
All right, using this screen that's up is still 172 for the record. I want to ask you a series of questions about this exact location.
Okay.
And to do that, I have a map for you, which is already marked as States Exhibit 175. And I'm going to ask if you recognize Stage 175.
I do, yes.
What is it?
It is a overhead map of the immediate area surrounding the intramural fields and South Millage Avenue.
And with using States 175, aid you in your testimony today before the court regarding the locations surrounding this area?
Yes, it would.
State would move to admit States 175, request permission to publish for demonstrative purposes only.
No objection for this purpose, Judge. Very well. Submitted for that purpose.
I don't know if it's going to fit, so I think what we can do, I think we need to set it down because it's big enough. So what we're going to do is set it right here, and not use the easel because it's too big. And If you could, Detective Norris, first of all, I need to make sure that His Honor can see. Can you see?
I can. I'll stand up as I need to.
And that counsel can see. Can y'all see? Yes. And if you could, step down with the court's permission, but you have to keep your voice to Madam Court Reporter, and you have to keep your voice up so that she can hear you. Show the court what we're looking at here in State 175. I want to start with, use your pointer. Where'd the pointer go? I want to start with the apartment complex that we see here in this video, the UFI video. It's at States 172. Where is that in this diagram?
The complex is right here in this area.
Okay. And where was Laken Riley's body discovered?
Right here in the intramural.
Okay. And there's an incident that we're going to talk about a little later, which is Building S. Where is that located in here?
This building right here.
Okay, with an S on it for the record. And then is Laken Riley's residence also depicted in here?
It is, yes.
Could you show us that?
It's 1686 Millage Avenue Extension.
All right. So distance-wise, did you measure all of these distances?
Yes.
Okay. So I'd like you to tell us, for the record, the distance between Laken Riley's body and that dumpster that we see in this UFI video. What is that distance?
Roughly 450 yards.
The distance between Building S and Laken Riley's body, what is that distance?
I believe it was roughly 400 yards.
The distance between Building S and that dumpster is what?
150 yards.
Okay.
Roughly.
All right. Is there a camera, a trail cam, or was there at the time? Did the University of Georgia Police Department have a trail cam up near Building S?
Yes, we had a trailer cam set up in front of Building S at the time, around this area.
Okay, right next to where the pedestrian is depicted in this
Yes,
exhibit?
there's a bus stop that was here, and it was right in front of the bus stop in that area.
What is a trailer cam? And you can go ahead and resume your seat so Madam Court Reporter can hear you really well. What is a trailer cam?
So we have two of them in our department. You've probably seen them at department stores like Lowe's or Walmart. It's basically a set of cameras that are attached to a trailer that you can. It's a portable trailer that has cameras attached to the top of it. They usually have them at Lowe's or Walmart to prevent shoplifting.
I'm going to show you a few other state exhibits. These are 156, 155, and 157. I ask if you recognize those.
I do, yes.
Let's take them one at a time. Let's first go with 156. What is States 156?
This is a overhead of the Argo apartment complex.
The apartment complex that we see in this UFI video?
That's correct.
All right. The state would move to admit States 156. State would move to admit 156.
No objection. 156 is admitted.
While I'm up here, 155, what is that?
This is an overhead of the intramural fields, specifically the Oconee Forest Park area.
State would move to admit 155.
No objection.
All right, and then the state would move to admit 157 as well.
All right, they're admitted without objection.
I want to first start with 155 or 156. Would the court be able to toggle back over? Tell us 156, which apartment complex this is.
This is the Argo apartment complex.
And I'm going to try to zoom in a little more. If I can. I don't know how this Zoom works here. No. Anyway, in this exhibit 156, can you see the dumpster that we had seen in the prior UFI video?
Can't really see the dumpster, but you can see the concrete pad that it sits on, yes.
Okay, can you point that out for the court?
It is between building B and C here. This white area is the concrete pad that the dumpster is sitting at.
How many different buildings are in this apartment complex?
5.
Okay. And what are their numbers or letters? Excuse me.
It is A through E.
Do you did you eventually learn in this case of where Jose Ibarra was living at this time?
Yes.
Where was he living?
Delta 126.
So show us building D in this video, or in this photograph.
It's the one labeled D right here at the top of the picture.
Okay, and before I go back to the Eufy video, well, in the Eufy video, we see the individual dump the jacket and then walk towards the bushes and then walk away.
Yes.
In what direction was that person walking?
Walking towards building E in the northeast area of the dumpster.
Okay. Would that be towards building D?
Yes. Building D is also in that direction.
All right. Are there cut-throughs, or sometimes called cuts, between the apartment complex and the road that we see on the edge of 156?
Yes, there are two main cut-throughs.
Tell us, first of all, what is the road that we see?
Millage Avenue Extension.
Okay. And is that the same road that Laken Riley lived on?
Yes.
All right. How do you get from the apartment complex onto Millage Avenue Extension?
The easiest way would be through one of the two cut-throughs.
Show us the cut-throughs.
The first one is between building C and D. Right here, there's a little cut-through area here. And then the second is between B and C where the dumpster is. That's another cut-through.
Where's building S in this photograph, and what direction?
It's up here.
All right, at the very top?
Yes.
All right, thank you. And when I say building S, I mean building S of the University of Georgia housing.
Yes.
All right, thank you. State's Exhibit. Oh, I'm going to go on that for a minute. I want to go to Building D. So you said that he lived in D126.
Yes.
Did you meet the neighbors, his neighbors, at D125 and 124?
I did, yes.
Will you tell the court when you met them, how you met them?
I met them on February 26th. That is when I met Bethany Paisley, the resident of 124, and I gathered her ring video that was captured on the 21st, the 22nd, and the 23rd. And then I also met with the resident of 125. He also had a camera that captured photographs in the window of his apartment, so I also met with him and obtained some photos from him.
Did you obtain those photos from him in the same manner in which you obtained the ring video and the Eufy video?
Yes.
Did you stand in his apartment, look at the camera, and take the photos?
Yes.
I'll get to the photos in a minute. The Eufy video that we just saw, was it sent to the GBI Cyber Center for enhancement?
It was, yes.
And is there one image that they were able to do is enhance it and slow down parts of that video?
Yes.
Okay. Your Honor, if you could toggle back over, I'm going back to 172. Okay. 1 minute. It started too fast. I'm back it up. What are we looking at here in 172?
This is the GBI Cyber Forensics slowed down and enhanced version of the same video we watched earlier.
From B1 or from B32?
That's correct.
So going back to States 172, you had a folder in there, ring videos from D124.
Yes.
That would be the neighbor, Bethany, that you've already told us about. I'm going to publish some of her videos, but I'm going to do it one at a time. So this ring.com video, do you see the date and time in the corner of it?
I do, yes.
And could you please tell us that for the record?
February 22nd, 2024 at 10:21 a.m. And that is Eastern Standard Time.
In what direction was that person walking in that video that we just saw?
It'd be south in the apartment complex towards a dumpster.
Okay. And that dumpster that they were walking in the direction of, did you all search that dumpster?
Yes, we did.
And did you find anything related to this crime in that dumpster?
We did not. We later learned that it had been dumped approximately 45 minutes after this video was taken.
Okay.
It had been picked up by the trash service.
Next ring on D124. What's the date and time of this one?
This one is February 19th, 2024 at 02:02 a.m.
And this is what, the next video, what is this date?
This is February 21st, 2024, around midnight 21.
Okay, do you recognize the person in this video, this clip?
Yes, that is Diego Ibarra.
Okay. The next one, I'm going to pause it real quick while it's running. What is the date and time of this one?
February 21st, 2024 at midnight 31.
And do you recognize the person in this video?
That is Jose Ibarra. And that is Diego Ibarra.
All right, now stop this one. This is the 5th video. What's the date and time of this one?
February 21st, 2024 at 7:02 p.m.
All right, do you see the shirt in that video?
I do, yes.
And have you seen that shirt before?
Yes, I have.
And where did you see that shirt?
This is the shirt that Jose Ibarra was wearing in the B-32 video that captured him discarding the jacket in the dumpster.
Is he also wearing a hat in this video?
Yes, he is.
And what type of hat is it?
It is a flat bill style hat.
And stopping the next video, what's the date and time of this one?
February 21st, 2024 at 9:04 p.m.
What is in his hand?
I believe it's a cell phone.
And does he have a bag on in this video?
Yes, a crossbody sling bag.
Okay, can you point that bag out for the court, please?
This bag is right here across his body.
And in your investigation into this case and the searches that you all conducted, did you ever find that bag?
We did not.
The shirt that he's wearing in this video, did you ever find that shirt?
We did not.
Date and time of this, I believe, our 5th clip?
February 21st, 2024, 9:07 p.m.
And who is this person?
Jose Ibarra.
And now what is he wearing?
That is the blue jacket that we wound up finding in the B-32 dumpster that had been discarded.
And the last clip?
February 22nd, 2024, 1:35 a.m.
And I may have to back it up for this, but what's he wearing in this video?
The blue jacket, the flat bill hat, pants and slides.
When you say slides, what do you mean by slides?
Slide on basketball shoes.
All right, so that concludes our testimony. So now I want to we're going to get to closings, and then the verdict, and then his sentencing, and then we're going to get to his hearing. So let's get to closings.
His rapist gear.
So this is closings. Let me just pin this here. All right, so this is from November 20th. All right, so this is state closing from November 20th. Short trial, it was only 4 days. It was only 4 days long. All right.
May it please the court and counsel. Your Honor, Laken Riley herself has given you all the evidence you need alone to find this man guilty of every single count in this indictment. And as I said in my opening, and what the evidence has shown in this case, is that she did fight. And it is a direct result of that fight that gives you all the physical evidence you need to convict him. And if you only had that physical evidence, you would have enough to convict him. But what you have heard in the last few days in this trial is video evidence laid on top of the physical evidence that corroborates it. Digital evidence laid on top of the physical evidence and the video evidence that all corroborate one another. And the three forms of that evidence in this case, the physical evidence, the video evidence, and the digital evidence, combined twist this very powerful knot that this defendant cannot get out of. There is no way out for him. The evidence in this case has been overwhelming. And the evidence in this case has spoken loud and clear that he is Laken Riley's killer, and that he killed her because she would not let him rape her. And look no further, you have to look no further to his actions 73 minutes before he encountered her on the trail to know what he was up to that day. And so not only does the physical evidence identify him, the video evidence identifies him. His own brother identifies him. His roommate, Rosebelly, identifies him. The people who he was living with condemn him. But his digital evidence of posting selfies of himself wearing what is basically his rapist gear an hour before he leaves his house, that condemns him. He has condemned himself. And what I'm going to do in the time that I have before this court is review the evidence that this court has heard and ask that you find him guilty on every single count of this indictment. Not because you feel sorry for anyone, but because he earned it, because he deserves it, and because we have proven it beyond a reasonable doubt. Let's start with the physical evidence. The defendant's DNA is under the right fingernails of Laken Riley. And it is only Laken and this defendant in that sample, and no one else. It was first done at True Allele, and because Arhenis and this defendant are blood brothers, he couldn't be excluded under YSTR. And then it was Diego who could be excluded by YSTR because he has a genetic mutation. But True Allele, when looked further in at the sample, eliminated both Diego and Arhenis. So the evidence in this case has been, and is, that it is only the defendant and Laken Riley underneath her right nails. And how did that happen? Because she, in her fight, marked him, scratched him. And the testimony from Ms. Hinkle yesterday, when asked, well, how do you get a person's DNA underneath your fingernails? One of the first things she says is scratches or bodily fluid. Casual contact is not enough, and wearing an item is not enough. And how do we know that? The black Adidas hat that we all see for our own eyes on Diego's head doesn't have his DNA on it. I mean, contact DNA isn't the magic bullet that everybody likes to pretend it is in front of a jury. But we know Diego was wearing that hat. You can see it for your own eyes. And I'm going to talk a lot more about that hat and why and how Diego was wearing that hat a little later. It is the defendant's thumbprint on Laken's phone. And this was from the Daubert hearing. This is, first of all, the digital image of Special Agent Daniela Stewart, and that is digital image 597, which is in evidence on one of the thumb drives. And the court heard the testimony that we adopted from the Daubert hearing, and I have here States 28 from the Daubert hearing of October 11th, where Sergeant Stewart of the ACC Police Department, who has been a latent print examiner since 1994, has looked at thousands of prints, compared that image that Special Agent Stewart took on the night of Laken Riley's murder when they finally found her phone after dark away from her body, and he compared it to the known fingerprints of Jose Ibarra, and he did it twice. And he found and explained to the court at the Daubert hearing, which we have adopted as part of this transcript, 15 points of comparison and similarities between the latent print left on Laken Riley's phone and Jose Ibarra's fingerprints. So in order to find this defendant not guilty of killing Laken Riley, you would have to disbelieve DNA. You would have to disbelieve fingerprint evidence. And even if you did that, you would still have this. Quite frankly, she got him. She scratched him. And you heard the testimony from Sergeant Epps and from Corporal Sayan. The left wrist was still oozing. Both of them saw that. And when asked, what's with these injuries? By Corporal Sayan, and we played that part of the body cam video for the court to see. Corporal Sayan wasn't coming at him hot. It was super calm and casual. They're out there laughing. They're laughing in those videos. Smoking, talking on their phones, talking to one another, all four of those people inside that residence, chillaxing. And Sayan's like, my friend, do me a favor, show me your hands. My friend, how did you get those injuries? And his first response is that of a monstrously guilty individual. What scratches? Y'all don't see any scratches. We don't see any scratches. So in order to find him not guilty, you would have to disbelieve your own eyes. What scratches, he says? All of those scratches. And there were more scratches than that, because when Daniela Stewart, and those photos are in evidence to you, when she photographed him and made him take his shirt off, there are scratches on his back. His back. And you know what that's consistent with? That is consistent with him asphyxiating her, being on top of her, compressing her chest, and smashing her head in with that rock. That's what that's consistent with. How do you get scratches on the back of your neck? How do you get scratches on your back? Laken left those scratches, and the physical evidence says that she left those scratches because that is why his DNA is underneath her right fingernails. She marked him. She marked him for everyone to see. She marked him for you to see. And the digital evidence that she wore that day also corroborates everything, all the physical evidence and the video evidence. We will never know. We will never know what he did to her on that trail and in what order. And we'll never know what he did to make her stop. Because quite frankly, I am certain she could outrun him if she wanted to. But she didn't. And he did something to her where she knew immediately she was in trouble. And how do we know that? From the Garmin and her phone. Simultaneously, if you put those two things together, which is what this graph is that you saw and that's in evidence, at 9:10 a.m., and there's some seconds in between them that really only matter if you're an Olympian swimmer or a track runner. It's so close together in time, it doesn't matter. It is simultaneous. Simultaneously, she enacts or tries to call 911 from her phone using the SOS function of her iPhone. And we know that from her phone. And simultaneously at that same time, she comes to a dead stop. She stops in her tracks. And we know that that is the time she meets him on the trail. And how do we know that? Well, we know that from the FBI. Because there is a chart that I'll show you a little later in my closing argument, where at 9:10 a.m., their digital profiles overlap one another. They have met in that woods. His from his timing advance data from his phone, and remember the moment he enters the forest, his Wi-Fi is no longer active, and so there's no Reuben data from about 8:55 to about 9:40 a.m., and that is evidence of his guilt too. The fact that he's in that forest, that means he's in the forest. And we know he's in the forest because he has no Reuben data, and we know he's in the forest because his timing advance data puts him there. And they meet simultaneously, digitally, on that trail at about 9:10 a.m. And so something happened, and this is her Garmin watch, and we know there was a fight because the way that it looks, look at this, on the trail, she's still on the trail till about 9:14 a.m. And then her Garmin starts moving off the trail, and he takes her off that trail 65 feet. 64 feet and 11 inches to be exact, 65, close enough. And he does that for only one purpose, and that is to isolate her so that he can victimize her. And that is exactly what he did. But the true allele under her nails, as damning as it is, isn't all that you have. And you could put that aside and the fingerprint aside, although there's no reason to. On the jacket that he is seen throwing away about 12 minutes or 14 minutes after her heart stops beating. And it is no coincidence that he is in that forest until her heart stops beating at 9:28 a.m. And it isn't until around 9:40 that he emerges. He is with her that entire time. But about 14 minutes afterwards, he is seen on video dumping a jacket that you have here in evidence that you've seen a lot, so I'm not going to show it to you again, that has a mixture, and this is traditional DNA. This is not true allele. This is not probabilistic genotyping. This is traditional DNA, and it is a mixture between only two people, Laken Riley and this defendant. And it's no mistake that it is blood, a mixture of their blood on that jacket. And on that jacket also are 29 hairs that are consistent with Laken Riley that all have been not all of them, but several of them have been forcibly removed from her head. And they were wrapped around the button that you see in some of the photographs when Officer Davis testified the way that he saw it. And it is a rare day that as a prosecutor we ever get such great evidence of tampering with evidence, but the defendant himself is on video, and here it is. And now I guess the defense will have you believe he just threw away that jacket right at this moment just because he just didn't want it anymore. That's not reasonable. He threw away that jacket because he knew exactly what was on it. He knew it was his blood, he knew it was her blood, and he knew he had to get rid of it. And he also knew that he had to get rid of his gloves, and so what he does further on in this frame is you can see him take them out of his pocket and throw it in the bushes. And on those gloves is Laken Riley's blood. He threw away the gloves because he knew what he had done. He knew her DNA or her blood would be on that, and he got rid of it. That is what we call consciousness of guilt in our business. He threw away those items because he knew he had killed her, and he threw them away because he didn't want anyone to find them. That's why he did it. And what's so fascinating about this video is the part where he looks at the hat. Let's talk about that. Guess what he didn't throw away? The hat. It's his brother's hat. Diego said it in the interview. That's my hat. He wears his own brother's hat to go kill someone. And he looks at it, oh, no blood on that. He didn't see any blood on it, although there is her blood on it. Puts it back on his head, doesn't throw that away. And then lets his own brother walk around with it the next day. And the fact is, if Diego had not been wearing that hat, we may have never caught these people. We may have never caught him. But Diego was wearing that hat. You think for 1 minute, Diego would have to be the dumbest killer on the face of the planet if he killed Laken Riley and was still wearing that hat around. Because what Laken Riley's killer did was he got rid of all the evidence. At least he thought he did. And that hat right there, he couldn't see her blood. And he gives it back to his brother. And luckily for all of us, his brother decides to wear that hat that next day. And we know his brother wasn't wearing the hat on that day because you got to see the video for yourself where Diego goes to work on the day of Laken Riley's killing. He's at work and he's wearing a completely different hat. And each day that we have of the videos of where he's going to work, he's wearing a completely different hat. So this defendant, this killer, gives a hat back to his own brother that he was wearing when he killed Laken Riley. And I have to take a moment. You know, the officers in this case have done a lot of things. They dived into dumpsters. Daniela Stewart told you she was on her hands and knees on that crime scene looking for rocks that were similar. Couldn't find any rocks around where Laken Riley was murdered. A lot of it, you know, Sergeant Timothy Johnson, whose testimony we adopted from the hearing in October, you know, just hitting the streets looking for things. Zach Davis, dumpster diving. It was a combination of good police work and, quite frankly, just luck. We were lucky that Diego decided to wear that hat. And do you think for 1 minute if Diego had killed her, he would have put that hat on? No. And looking in the video that you see, and you saw slowed down versions of it, Diego has tattoos on the back of his neck. They are not in that video. Rosebelly herself, who knows both of these two, identified this defendant in that video. And if you're concerned about whether she's right about that, well, the FBI's digital profile of this defendant's device hovers over that dumpster at 9:40 a.m. It's him, and there is no doubt that it's him. Here is the FBI profile, digital profile from the CAS team of the defendant's device now over the dumpster. In the center of this is D1, 9:40 a.m. He's at the dumpster that we just saw him at, dumping bloody clothes. And how do we also know he's back at his apartment at that time? Because Special Agent Hipkiss, who extracted 1B7, said at 9:58 a.m. the device is plugged back in and charging, which means he's back home. But he's not done. And before I go on to the other videos, these are all the selfies of this defendant on his phone 1B7. And I understand and I suspect maybe the defense will argue, well, Judge, you know, other people used his phone. Yeah, they did in October. And then the other 2 months that they want to talk about are other 2 accounts. Oh yes, Diego has a Google account that has been accessed from 1B7. Both of those accounts that they talked about, one a Facebook, one a Google, I can't remember exactly, but there were 2 of them. Rosebelly had one and Diego had one. One of the accounts was closed in January, and the other one of Rosebelly was closed in February of February 12th of that year. So on the day in question, on February 22nd of 2024, there is zero evidence, no evidence that anyone other than this defendant was using that phone. And any attempt to argue that someone else was is just pure speculation, because the only activity on the phone prior to leaving is him taking that selfie at 5:30 in the morning. That's it. There's no one texting, no one WhatsApping, no one calling in the time that he's out hunting and killing, because he's holding the phone and he's a little busy because he's looking for victims. He's looking for females. Nobody else is using that phone. And the FBI said, and the phone tracks his own video. You could put the video of him at the bus stop, which I'll show, and put it with the digital profile of the phone, and they track one another. So the videos and the digital profiles track one another because he's holding the phone at the time. And this is what he does when he gets back. His phone is plugged in at 9:58 a.m., but he's not done destroying evidence. That shirt that he's seen wearing with the black and white pattern in the video, the dumpster video, a few minutes later when he comes out of his house at 10:21, he's changed. And now he's wearing the clothes that he's actually arrested in. This is him, 10:21 a.m., and he's got a bag in his hand. I really wonder what's in that bag. Never found that bag. And he didn't want anyone to find that bag. And how do we know that? Because he's walking towards a dumpster. And Sergeant Norris said that that dumpster and that part of the apartment complex had been picked up about 45 minutes later that day. So they weren't able to get and see what was in that bag. And no one ever found what was in that bag. But you know what was also never found? The striped bag that he's wearing over his, that sling bag that he's wearing in both the dumpster video and in the bus stop video. That bag was never found, ever. And I suspect it's because it was in that bag that we just see. And here he is coming back 3 minutes later, and there is nothing in his hand. He's gotten rid of the rest of the evidence, because that's what guilty people do. So the digital evidence that I have talked about, in summary, from Special Agent Jay Burney of the CAS team, it is his opinion that he left that house at 6:52 a.m. and that he returned around 9:50 a.m. And that there is no Rubin data on that phone from 8:55 to 9:40, which is consistent with him being in the forest. This is the slide from, and this is what summarized Special Agent Burney's testimony, that at the time at 9:10 a.m., so on this slide here that was before the court, page 29 of his exhibit, at 9:09 a.m. to 9:12 a.m. is where on the trail Laken Riley and this defendant meet, digitally and in person. And so that is pretty much the evidence. His DNA is there, his thumbprint is there, and he's on video dumping evidence associated with the crime shortly thereafter. I want to talk to you about the charges in the case, and this is usually when I would go on much longer with a jury, but I don't think there's a need to do that with this court. These are slides that I use in murder cases where I close all the time in front of juries. The court is aware that in the state of Georgia we have malice murder. The defendant is charged in count 1 of this indictment with malice murder. Malice can be proven in 2 ways, as you know, but we really don't even need to talk about implied malice in this case. This is express malice. Everything this defendant did to Laken Riley on that trail showed his intent to murder her. And what express malice is simply the intent to kill. And so what evidence is there that when he interacted with her on that trail and he drug her off that trail that he intended to kill her? Well, look no further than the evidence of the medical examiner in this case. He put huge holes in her head with a rock, and he did it more than once. And there could be no other reason to do that other than to silence her forever, so that she could not call Sergeant Maxwell or anyone from the University of Georgia Police Department and report that he tried to rape her. Because guess who did call the police on him? Tejaswi. And we're going to talk about that county indictment. And he ran away after she confronted him at the door. So he had a motive to kill Laken Riley, but you don't even have to go that far. All you have to do is look at his actions and look at the state's exhibits that we admitted through the medical examiner, and look at those 9 holes in the left side of Laken Riley's head. That's intent to kill. And the rock sure is a deadly weapon, especially when used that way. He used a rock like it was a hammer. And that's what he did to her. That's intent to kill. The petechia, also, because these are concurrent causes of death. Asphyxia. He asphyxiated her in some manner. Again, we'll never know everything he did, how he did it. But he asphyxiated her, we know enough, that caused petechia in both of her eyes and even at her lips. That is a tremendous amount of petechia that she has there from a compression or a strangulation injury. He was depriving her body of oxygen long enough to form those wounds on her. He intended to kill her. There is no other reasonable explanation for that conduct. We have also charged 3 counts of felony murder in this indictment. I'm not even going to define it for the court because I know you know what it means, so I'm just going to go straight to the felonies. And they are kidnapping with bodily injury, aggravated assault with intent to rape, and aggravated battery. First, with the kidnapping with bodily injury, that is exactly what happened in this case. And that actual felony precedes the murder in time, because he didn't murder her on the trail. He took her 64 feet and 11 inches off the trail for the purpose of victimizing her. That is asportation, that is recognized under our law, and it is what permitted him to do the things to her that he wanted to do all along. And if he hadn't had asportated her off that trail, he would have been interrupted. So it is a kidnapping with bodily injury. And I have a crime scene photo here from, again, Daniela Stewart, where she shows marker 1, which is Laken Riley's other AirPod, and that's how we also know there was a struggle on the trail. Sophia and Lily find, and we know Laken was listening to music when she was running, they find her AirPod, one of them, in the middle of the trail, and there's a photograph in there. A little towards the side, but still on the trail. AirPod number 2 is found by Daniela Stewart, where marker 1 is, off the trail. So there was some kind of struggle between the two of them on that trail, and it's also shown on her Garmin, where she loses her AirPods on the trail. And he takes her off that trail. And we'll never know exactly how he took her off the trail. Did he pick her up and carry her? Did he somewhat drag her off the trail? Did he somewhat push her off the trail? We know that he took her 65 feet because we know that's where her body was found. And also Daniela Stewart saw like a leaf. She called it a displacement of the leaves, and she marked it with those orange flags, but no real dragging marks. So that's a kidnapping with bodily injury. Taking her off that trail, and in the commission of that crime, he kills her. He is guilty of felony murder, with the underlying felony being kidnapping with bodily injury. It's not contested that she has bodily injury. But the aggravated assault with intent to rape, there are a lot of questions about, well, could her shirt be up from dragging her? I suppose the defense might be, well, I killed her, but I didn't intend to rape her. Well, that makes no sense. Because the only thing that makes sense about why these two individuals who don't know each other, never met each other, had this encounter on this trail at this moment while Laken is out for her morning jog, is because he wanted to sexually assault her. What evidence do we have of that? What has been left behind from this struggle that we can discern that? What circumstantial evidence? Well, her clothes are in 2 different directions. And it is important to talk about her clothes. And we're not talking about her clothes in order to shame her as a female. No. It's evidence on how she wears her clothes. She would wear running tights when she ran because that's what's comfortable. And that's how you run. And she would wear them over her navel because when you're running, you want your clothes to stay put. And she wore a Lululemon jacket, and she wore 3 layers of clothes that day. And it's important to talk about that from an evidentiary perspective because these are tight running clothes that are designed not to move. Not to move. And if they want to say dragging may have caused one of the layer of clothes to come up, all right, I'll give you 1. But I can't give you 3, and I can't give you the clothes going in 2 different directions. Her shirt was up. Her running bra up. Her jacket up, and her breasts were exposed in a way that you saw in Sergeant Maxwell's body cam video, and in a way that Special Agent Beyer testified to the court, and he photographed them. They were twisted all together in a knot almost above, and like almost tying down or pinning down her shoulders. That is not an accident, and that is not from dragging. And if you even want to think that that was from dragging, then how do you explain how her tights are down below her navel, and she never wore them that way? Her underwear is pulled up, and you can see it in the body cam video, and you can see it in the photos from Special Agent Beyer, and her underwear has been torn. He did that to her. He did that to her after he drug her off the trail. And he did that to her because he wanted to try to rape her. And we don't have to prove a completed rape, and thankfully she wasn't raped. But he tried to do it, and he was unable to complete it for some reason that we will never know. Maybe he didn't like the fight. Maybe somebody ran by. Who knows? But he didn't complete it, and we don't have to prove that he completed it. Injury to Laken's pubic bone, State's Exhibit 316, that also corroborates that he attempted to rape her. Why is that injury so low? All these injuries to her stomach, these linear injuries, that means her shirt was up when he's on top of her. Could it have been the bag? Possibly. It's consistent with a metal object. Never found the bag, don't know. But there's no reason for her to be exposed that way unless he was trying to sexually assault her. That is the evidence of aggravated assault with intent to rape. It's the only thing that makes sense about the encounter, but there's all that physical evidence that supports and corroborates that that's exactly what he did out there. Aggravated battery. I could talk forever about aggravated battery and disfiguring her skull. Just look at State's Exhibits 305 and 307. I really don't need to say anything else. Look at those two exhibits. That is the very definition of aggravated battery under Georgia law. He is guilty of aggravated battery and felony murder, with the underlying felony being aggravated battery. Obstruction of a 911 call. The SOS call was made, no doubt about that. We got that from not only Laken's phone, but we also got that from Kevin McCreevy from the 911 call center. She made a call. She made a call, it was answered. You heard the call. Kevin McCreevy testified. The caller hung up on the 911 center. That was his testimony. The 911 center called Laken back twice, and that you could see that in her phone. And neither call was answered. Who hung up the phone? Well, he did. How do we know that? State's Exhibit 28. It is no coincidence that his thumbprint is on her phone where you would go to hang up an iPhone. And also on that call, that was about a minute call, you hear him say, "Yo, Tango." I have. Yeah, you do. You do have. You had her phone. And he hung it up. And when 911 called back twice, no one answered. And her phone is separated from her body. So her body is in, she was murdered by the tree. She was moved and hidden and put leaves over her, and it worked because it took Sergeant Maxwell 20 minutes to find her, and he had her digital profile. And we didn't play the whole thing, but he testified it took him 20 minutes. And because he hid her, because he didn't want anyone to find her. We were lucky there too. But he separated her from her phone. Her phone was so far away from her, it took them hours to find it. You heard Sergeant Norris, I was walking through shining a flashlight. I almost stepped on it. You saw the video of his body cam. You saw how dark it was out there when they found his phone, her phone. He separated her from her phone because he didn't want her to complete that 911 call. And she didn't. He's guilty of that. Tampering with evidence. I've already covered this. It is rare we get this on video, but we got it on video. He's throwing away the bloody jacket. He's throwing away the bloody gloves. That's how it is alleged in the indictment. He's guilty of that. And I've already covered this. There he is, no tattoos, been identified, looking at the hat that he decides to keep. Here he is on social media. If you have any doubt that that's him wearing the hoodie and the black Adidas hat, did you a huge favor there as the fact finder. It's 5:37 a.m. on the day of the murder. He's about to go out, and that's how he's dressed. He is alone in all of these times. Trail cam video, Tejaswi and Sally, the other female runner that encountered him at 8:24 a.m. where he is what? In the woods. And how do we know that? Because when Tasia Sweet calls the police on him at about 8 o'clock in the morning, he vanishes and disappears into the back, and Sergeant Rabu testified in the direction of the IM fields. And he stays there. What's he doing there? What's he doing there? Well, he isn't running. I doubt he's bird watching. He's sitting there waiting for someone to come by, because his first intended target, he wasn't able to get. And I'm going to ask if there are any cameras up. I want to show a portion of something that I don't want the peeping victim to be seen, the TJC.
So I will direct media to not publish this as well as.
All right. So are we good? We're good. Okay. I'll let you know when it can come back up.
Hey, I'm sorry. Hey, can I come in or are you already? So I'm just gonna get one thing over the radio. 6427. I believe it's gonna be the north facing at the end of the building. Hey, sir, you okay? I'm okay. Oh gosh, I understand it might be a little bit scary. I'm just going to be asking a couple questions, get some clarifying information, okay? So, you were taking a shower, correct? And you heard something going on?
Yeah, I heard like something was moving, and I just heard someone from upstairs. I usually hear that. And then when I actually came out, I heard it coming from the door.
Oh, you heard it coming from this door?
Yes.
Okay.
So I went to see through the people, and then I saw actually someone was like crouched down and then trying to I guess open it. Okay. And then I thought it was just maintenance. I thought of opening, but then why would they do that kind of first knock? Yeah. So, and then I said, excuse me, and as soon as I said that, they tried to duck down, but I could see them ducking. Mm-hmm. And then they went away, and then after that I tried to get the phone. Then when I was standing by the door, then I could see them peeping, trying to peep and take a look.
They're trying to look into that. So at no point did they ever enter your door? Okay, good.
In this frame, you can see, as some people would say, clear as a country mile to the back of Building S from Tasia Sweet's apartment. She absolutely saw him looking in her apartment. And when she said he was ducking, you can see that for yourself in the trail cam video. And the peeping Tom, and I'm gonna, okay, y'all can come back up now. Are we good? Okay. Is important as a charge. And you could see how scared she was and frightened in that video. She was unnerved about what happened to her. She's in the shower. And that's when he decides to try to open her door. Again, he had been outside her apartment for an hour. The testimony from Sergeant Rabu, and you saw this video yesterday from GBI Cyber, he first appears on the trail at 6:52 a.m. according to that trail cam video. Guess what that coincides with? His digital profile from the FBI. His phone is moving at the exact same time that you see him on this video for the first time. And what this does is, it is a crime, and he is guilty of that crime, but it shows his state of mind. You watched the video yesterday. He's there for an hour. You see students kind of mulling around, some of them waiting for the bus, a lot of them on their phones. He is not pressed. He doesn't care. He talks to no one, he interacts with no one, and he keeps circling back and forth from Tasia Sweet's door to the back of her apartment, Tasia Sweet's door to the back of her apartment, and he does it 6 times. And he tries to open her door at least twice that we can see. And when she says he is ducking, there's her window. You've seen that image as well. Here is the part of the video at 7:54 a.m. You see him ducking. She is absolutely correct. And what's he wearing? He's wearing the hoodie, a black hat, black gloves, and carrying a cup. His digital profile puts him right over her apartment at these pertinent times. His Reuben data is collecting at this point because he's not in the forest. And so it's him because of that as well. His digital profile puts him there. He's wearing the same clothes. But if you have any residual doubt that that's him in the video, boom. His DNA is on the cup. The white cup that you can see him carrying in that video was found smack in between Tasia Swee's apartment and Laken Riley's body, and it is his DNA on that straw. And yes, it's a mixture. It's not Diego's, it's not Argenis's, it's not anyone related to him. It's him and some other male, and there's alcohol in that cup. He's drinking alcohol at 7 o'clock in the morning while he's out prowling and hunting females. It's him. No doubt that it's him. And I want to talk about the gloves, because the gloves that he chose to wear that day, you heard from Alexander Coven of the crime lab. Luckily again for us, they were cheap. They're not latex. They're some kind of polyethylene, like plastic gloves that tear easily, is what he said. That was his scientific testimony. And those gloves were torn. And you saw photographs of them where Katrina photographed them at the crime lab. And because those gloves were torn, he was able, and maybe they were not torn when he was holding the cup, maybe they got torn when he's holding these rocks and murdering Laken Riley when she is fighting him. But at some point they were torn, and we know that because after they're recovered in the bushes, they go to the crime lab and they are photographed and they are examined. And the first person who sees them at the crime lab is Valencia Johnson, and she says they were damaged. The second person who sees them is Katrina, and she photographs them, and you have the photographs and evidence to use. You can see for yourself that they were damaged. So what in the world is he doing outside a co-ed's apartment, wearing plastic kitchen gloves, a hoodie, covering up his face, and skulking around? He is trying to get her. And when he couldn't get her, he ran away into the forest, and he stayed there until he encountered Laken Riley about 73 minutes later. And then he did all of the things that we've already covered in the indictment. And I want to talk to you a little bit about circumstantial evidence, but not in a way that I would talk to a jury about it. There is no legal difference between circumstantial evidence and direct evidence. It's not bad, it's just different. And in this case, it is powerful. And it is layered upon layer upon layer. And there is no way out for him. He is guilty of everything in the indictment. I want to talk to you about the defense case. And this is actually something that a scientist said yesterday. It's amazing how trials are, how people say things you never expect it, and they just have a life of their own. Trials. Ashley Hinkle yesterday, I think it was on Cross. The absence of evidence is not evidence of absence. I couldn't say it better myself. I suppose their defense is Diego did it, because that's all we've been talking about is Diego. And yeah, Diego was a suspect because he's wearing the hat that they saw. But eventually, you know what the officers didn't do in this case? They did not turn a blind eye. They got Diego's phone, they got Diego's DNA, they interviewed Diego, and they followed it to its natural end. They looked through hundreds of hours of video. You saw the chart that Detective Norris put in on Friday of all the videos around the IM fields. And there were multiple cameras. He and Sergeant Rabu and Special Agent Lucas Beyer, they watched hundreds and hundreds of hours of videos. Guess who's not anywhere near the IM fields at the time and on this day? Diego. He is nowhere to be found. And the only way that Diego could have done this crime, and the only way that it could be even like a reasonable hypothesis that he could have done this crime, is if he had two things. Number one, magic pixie dust. He would need the magic pixie dust to put his brother's thumbprint on her phone. He would need the magic pixie dust to put his brother's DNA underneath Laken Riley's fingernails. And he would also, in addition to that, because of the video evidence, he would need one other thing. And that would be Harry Potter's invisible cloak. He would have to put that on and go to the IM fields and do these things because nobody sees him. And I want to talk about Stephanie, because what your decision is today is it's Stephanie versus science. Stephanie, who wants to invoke the fifth when asked about whether she had a sexual relationship with Diego, which goes to her motive for being here. And the conversation, which is so interesting, that she said she had with Diego on the night of the 22nd, after the police were in her apartment, and we know it had to be the night of the 22nd because it was after Laken Riley's body was found, which was noon on the 22nd. But before 8 a.m. in the morning, when Sergeant Johnson sees Diego wearing that hat that his brother left in the apartment after killing her, and she says between that time she had a conversation with him at some point. Well, guess where Diego was that day on the 22nd? You saw it for yourself. He was at work. And he was at work until about 11 p.m. And it was Stephanie's birthday, and she was out drinking. And she drank so much, Judge, that she even said, and the GBI, Annie Mormon, confirmed, she was drunk when she was talking to the GBI the next day still. And maybe she did have some semi kind of conversation with him. And even then, if you take her at her word, it's not a confession. There is no evidence that he did anything except be a brother to him. And it's pretty low down that you're going to take the killing hat and then let your brother wear it around in the apartment complex the next day. But that's just what a killer would do. So to believe her, you would have to disbelieve all of that. And then today we heard some unreliable inmate hearsay. Not reliable. And cannot weigh anything against the mountain of forensic evidence, video evidence, and digital evidence that you've heard in this case. And yes, here is Diego wearing that hat. You think he'd have worn that if he had known what was on it? He didn't know. Glad he wore it. He didn't know. And so that completes my portion of this closing argument, and I will see to defense and see Your Honor at rebuttal. Thank you.
Respect.
All right. Let's get over to the defense. Let's see what the defense has to say. And I'm not going to play her rebuttal. We're going to go straight into, well, you know what? Do you guys want to hear the defense, or do you want to go straight to the appeal? Because the appeal is like 3 hours. Defense is 25 minutes. Do you care about the defense, or do you want to just go into the appeal? What do you guys want to do? Hear the defense or go straight to the appeal? What do you guys want to do? Hear the defense or just go straight to the appeal? You do want to hear the defense, appeal, 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 appeal. Yeah, appeal. All right. Yep, let's get to the appeal. The defense is 25 minutes. I mean, we already heard it was 9 minutes for the appeal. Yeah, all right. Let's just get straight to the appeal. All right. Only because it's 3 hours, and I don't want to be streaming like till 10 o'clock tonight. All right, let me get to the appeal. Looks like the appeals have it. All right. Yeah, it's 3.5 hours, and already it's 3 o'clock. I don't want to get too far in the weeds here with this. All right, let's get to the appeal. This was like 4 or 5 days ago. I think 4 days ago now. Ooh, yes, it is. Okay, so it is Sheila Ross. So she's doing this as well. All right. So this is his appeal. Appeal hearing from the 30th, from January 30th. Okay. She's probably thinking, are you kidding me? You want? She's probably saying, are you kidding me? I thought I put you away. Wait, hold on. I thought I put you away. So, all right. So here she is again. Sheila Ross. She is fierce. All right. All right, here we go.
And I have marked as State's Exhibit 1 an evaluation that is dated November 17th, 2025, signed by Dr. Bailey and Dr. Garrett.
Oh, you're right. What about the sentencing and verdict? Dang it. You guys keep me honest. You guys are keeping me honest. Thank you, Janet. So sorry about that. Nope. My bad. All right. My bad. Yes, let's get to the verdict. Nope. So sorry about that, you guys. All right. Yes, let's get to the verdict. Sorry. All right, let's get to the verdict. Sorry, totally my bad. So this is the verdict. Verdict and sentencing, because, we all know he was guilty or found guilty. So this is from November 20th, 2024. Totally my bad. Dope. All right, this is the verdict.
I'll now announce the verdict. In the state of Georgia versus Jose Antonio Ibarra, case SU 24CR0323, count 1, malice murder. I find the defendant guilty. Count 2, felony murder. I find the defendant guilty. Count 3, felony murder. I find the defendant guilty. Count 4, felony murder. I find the defendant guilty. Count 5, kidnapping with bodily injury. I find the defendant guilty. Count 6, aggravated assault with intent to rape. I find the defendant guilty. Count 7, aggravated battery. I find the defendant guilty. Count 8, obstructing or hindering a 911 call. I find the defendant guilty. Count 9, tampering with evidence. I find the defendant guilty. Count 10, peeping Tom. I find the defendant guilty. I certainly will allow both sides to look at this if you want to do it.
All right, so there's that. All right, let's get to sentencing. I'm not going to play the victim impact statements because they're a little bit too long. So we're just going to get to his sentencing, and then I want to get to his appeal because that's kind of why we're here.
Mr. Ibarra, if you'll please stand.
That's kind of why we're here. All right, so this is his. Let me put myself over here. This is his actual sentencing.
Count 1, malice murder. I sentence you to life without the possibility of parole. Count 2 will be vacated as a matter of operation of law. Count 3, vacated by operation of law. Count 4, vacated by operation of law. Count 5, life in prison consecutive to count 1. Count 6, 20 years to serve consecutive to count 5. Count 7 will merge with count 1. Count 8, 12 months consecutive to count 6. Strike that. 12 months, but I don't want it to 6. It's just going to be consecutive. Count 9, 12 months consecutive. Count 10, 5 years consecutive to count 6. So that would mean the misdemeanors would come after the felonies. That will be the sentence. Mr. Ibarra, I will advise you that you have 30 days from today to seek any post-judgment relief in the form of a motion for a new trial or appealing this case directly. If you make a motion for a new trial and that is denied, you have 30 days from that date to file your first appeal, first level of appeal. Court will appoint a lawyer to represent you if you cannot afford one. I'll also advise you that you have 4 years from the date that your conviction becomes final in order to file a habeas corpus petition. Mr. Donnelly, can you tell me, are you all going to be involved in the next stage?
That remains to be seen, but my understanding is that we will remain on at the court's appointment until unless relieved by conflict counsel.
All right, and you'll make those arrangements.
We will communicate that with Mr. Ibarra and with the court.
Okay.
Yes, sir.
All right.
All right. So now let's get to the appeal. Let's see what his lawyers are saying. I'm not sure which lawyers. We just heard Mr. Donnelly. I'm not sure if he's going to be at this or not. So let's get to his appeal, because I'm interested to see what. I mean, I kind of know what he's fighting. He's fighting like the DNA and the cell phone, but let's see how it all plays out. Plus, I'm excited that we have a chance to see Miss Ross again, because she was so good. All right, so now we're going to get to the appeal. Appeal hearing from January 30th, 2026. All right, so now we get here. Because a chance for me to watch Sheila Ross again is worth it for me. I'm all down with that. I'm going to put myself over here. I'm all down with watching her talk some more. Okay. Appeal hearing, January 30th, 2026.
Also ordered the evaluation, and I have marked as State's Exhibit 1 an evaluation that is dated November 17th, 2025, signed by Dr. Bailey and Dr. Garrett, so Doctors Bailey and Dr. Garrett at DBHDD. It is a 15-page report. I know Your Honor has seen it because it is addressed to you, and it finds no issues to proceed on competency. I'm going to seal it and ask that it be admitted as State's Exhibit 1 and just preserved for posterity at this point. And considering they've not raised a special plea of incompetency, I don't know if the court wants to make any kind of finding beyond that. But may I approach and hand the court State's Exhibit 1, which is in it.
You might. Okay, go ahead.
Your Honor, if I could just add real quick, I think technically just because there's been the order to conduct the evaluation in the first place, there's technically supposed to be an adequate hearing finding Mr. Ibarra competent to proceed. This is that hearing. We stipulate to the report. I think the court just has to find him competent, which we have no objection to.
There is certainly a factual basis for this court to find him not only competent at this time, but competent at the time of his trial. And that factual basis is not only an absence of evidence that he was incompetent, but the factual basis is the report that I have submitted to Your Honor that has now been filed as State's Exhibit 1 or admitted as State's Exhibit 1. I disagree with defense counsel's interpretation of 17-7-130, especially as it has been recently amended by the Georgia legislature in July of last year. Both the Uniform Superior Court rules and our statute requires them to file a special plea of incompetency. When that happens, then the rules are triggered where we have a trial. What is contemplated in our statute is a bench trial, but either party would have the right to a jury trial on that issue, and it's a quasi-civil or civil criminal proceeding. I think based on our record at this point, it doesn't really matter I just don't agree that they filed a special plea of incompetency requiring that finding, but you certainly have a factual basis to make that finding, and it seems to me that that's what they want you to do. So I would have no objection to you making that finding. I just don't think it is required by our statutes or the Uniform Superior Court rules.
I agree in reviewing the pleadings. There was no special plea filed by the defense. However, the evaluation was done. That has been admitted. That has been reviewed by me. I will sign an order that finds the defendant is competent at this time and was indeed competent as well at the time of trial based upon the report and the other matters that are of record that the court has participated in, including Mr. Ibarra.
Thank you, Your Honor. No objection.
All right. Does either side want to be heard about whether or not this evaluation should be placed under seal?
We would request it be placed under seal.
State have a position?
I won't oppose it, Your Honor, and defer to the court.
Okay. I will place that under seal. But it will be part of the record.
Thank you, Judge.
All right. Does that take us then to the amended motion?
To the amended motion for new trial, which you are ready. We do have one witness, Dr. Susan Ballard, who would be testifying via WebEx.
Okay.
Dr. Ruth Ballard, I apologize. Dr. Ruth Ballard.
That's all right. Do you want anything preliminarily before?
Just preliminary. Preliminary for the court, we've raised 3 enumeration of errors. The first error was this honorable court's order denying a continuance violated Mr. Ibarra's 6th Amendment rights to counsel and his 14th Amendment right to due process. Enumeration 2 is the court's order denying a continuance constituted an abuse of discretion. And count 3, the court erred when it denied Mr. Ibarra's motion to suppress that was heard prior to trial on the cell phone evidence. Today we are just we have Dr. Ballard who will be here to testify, and that her testimony goes to the first 2 enumerations of error. We're ready to proceed with testimony at this time.
All right. Anything from the state?
I do have some documents that I'd like to use to supplement the record as it pertains to enumeration of errors 1 and 2. I can do that when we're doing argument on the case because they are self-authenticating documents, or I could just do it now and then we'll take the testimony from Dr. Ballard and then we'll have argument. I'm assuming we're arguing after testimony.
We would be requesting a briefing schedule. What we would ask for is after the transcript has been filed of Dr. Ballard's testimony to have a briefing schedule so we could submit a written brief.
Okay, well, permitting your order on that, Judge, if I could then just go ahead so I don't forget, and it's just part of the record, should we brief it or argue it today, of the documents that I've shown to defense counsel. It was State's Exhibit 2 and 3. One's already been admitted.
No objection.
And for the record, State's Exhibit 2 is just a GBI record certification that shows how and when the raw data in this case was distributed to trial counsel and when they accessed said data. And then State's Exhibit 3 is just my letter dated September 17, 2024 to the GBI requesting the raw data on behalf of the defense. And I should note for the record that State's Exhibit 2 is a composite exhibit. It has 3 documents. May I hand it to the court?
That's fine. You put it in the court report.
Thank you.
Claims 2 and 3 are admitted. All right. You want me to give him his Dr. Ballard?
Yes. Your Honor, would it be better for us to question her at table or use the podium?
That is good if you can do that, because there's a microphone there. I understand you might be using the podium for a display.
Yes. I can just go up there when I need to use it.
That sounds
only
fine.
one part
That
of
sounds
it, and
fine.
it's kind of, that would be fine.
Let's see. Dr. Ballard, can you hear?
I can.
Okay.
All right. And you see Mr. Luttrell here? Do you see Mr. Luttrell? Counsel?
I believe so. Can you raise your hand? Yeah, okay. Yes, I do.
All right. Dr. Ballard, can you hear me?
Yes, I can.
Okay.
You may proceed.
All right, Dr. Ballard, if you could please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide the court in this matter is the truth and the whole truth? You so swear or affirm?
I do.
All right. Dr. Okay. All right. Dr. Ballard, could you please state your educational background?
Yes, I have a Bachelor's of Science in Biological Sciences from Sacramento State, and then I have a master's degree in genetics with an emphasis in human genetics from UC Davis, and also a PhD in genetics with an emphasis in human genetics from UC Davis.
Thank you. And what kind of work do you do, Dr. Ballard?
Well, currently, I'm working full-time as a forensic DNA consultant, but my primary career from about 1996 to 2024 was as a professor at California State University, Sacramento, where I taught the program in forensic biology and DNA, and I developed and taught it and did research in that discipline.
Okay. What were the duties of your job as a professor when you were a professor, doctor?
Well, there were 4 general duties. One was teaching, and that was primary at that particular university. So I did a lot of curriculum development and working with students in the classroom. And the primary thrust of what I was doing was to train students that wanted to become crime lab workers when they graduated from college. So the second part of that, and the important part, was research. So I ran a research lab both there, and actually I ran one for 5 years at UC Davis as well in their forensic biology or forensic science graduate program. And we studied various questions in forensic serology and DNA in the laboratory using the same technologies and approaches that are used at modern crime labs. We also got, professors are required to be involved in committees and university governance, and then I also did community service as well as part of my job.
What are your duties in your role as a forensic serology and DNA consultant?
So primarily what I do is that I do case reviews. And what those consist of is I get contacted by an attorney, usually a defense attorney. Those are the ones that contact me. And they say, you know, I've just been given some legal discovery around DNA evidence in my case, and I don't have a background in that, and I need an expert to look at it and tell me what the strengths and weaknesses of the prosecution's case are in terms of the DNA. Make sure the work was done correctly, that you don't have any issues with that, and then help me understand and interpret how this plays out, you know, in the particular, given the particular context of the case. So that's essentially what I do. That usually includes a review of any crime lab reports, the analyst bench notes associated with those reports, electronic DNA data files associated with those reports, and then these days especially I look closely at probabilistic genotyping. Statistics is usually what people are using, so I'm looking at those reports and so forth. And then once I have gone through all of that, I then usually meet with the attorney and discuss my findings. And then beyond that, I will also look at the context of the case. So what are the charges against the client? Read the police reports, look at sexual assault examinations if it's a sexual assault case, or autopsy or things like that if they're relevant. So all of that I look at, and anything else. Sometimes there's body cam video that I look at. So anything else that's pertinent to understanding the DNA in context.
What's the difference between forensic serology and forensic DNA?
Well, forensic serology is a lot older to begin with, and that is the detection of body fluids. And so these are tests that look for the presence of, for example, is this red stain likely to be blood? Is this clear stain saliva? Could it be semen? And then looking under the microscope, looking for spermatozoa. Those are typically the tests that we do. And the reason we do it is you could imagine if you had, say, a bed sheet and it had some stains on it, maybe they're clear in color, and you really don't know where to go to find stains that would likely have DNA from either the victim or the perpetrator or both. And so we use these screening tools to locate these stains, body fluid stains, and then the cells and the DNA that they contain, ultimately to get DNA profiles from that evidence. So it's largely a way of finding evidence, but it also tells you something about how the evidence got there. So obviously, if you have spermatozoa and you get a single source male DNA profile from that sample, then you know that the source of that, the bodily source of that DNA was sperm. So it tells us something about also the transfer that happened.
Okay. Are there different software programs or tests which can be used for forensic DNA analysis?
Yeah, I mean, there's, so basically a forensic DNA analysis usually starts with DNA extraction after the serology is completed. And this involves taking whatever substrate you have, which might be a swab or it might be a cutting, say, from a piece of clothing, and soaking it in some buffer and a little bit of detergent and an enzyme called proteinase K, and that helps the cells come off of the substrate if there are any cells there, and then pop open and release their contents. After that, there's DNA extraction or purification, which purifies the DNA out of all the other cell contents, like proteins and lipids and other molecules that we don't want in our preparation. And that's typically done on robots these days, so there are robotic instruments that do that with various chemistries involved in that. A very popular one is the Easy Run, and it uses a sort of what we call silica bead preparation to do its purification. But anyway, there's different techniques. There's a variety of them out there on the market. Once we have a purified DNA extract, the next step is to figure out how much human DNA we have, if any, and if any of that human DNA is male in origin. So try to get a sense of whether or not we have a mixture of female and male DNA, whether it looks like it might be all male DNA or whether it's all female. And that's really important, especially in sexual assault cases, because if you're screening sexual assault evidence and you don't find any male DNA, and the allegation is a female victim with a male perpetrator, you're probably not going to take that sample forward for analysis. So it's a very important step. It also informs us about how to set up our DNA profiling downstream, how to set up that reaction. So there's a lot of information. It also tells us information about whether or not the sample is degraded. So there's a lot of good information in that quantitation step. And that's done by a procedure called qPCR. And that uses real-time qPCR instruments, and it uses one of many types of chemistries that are available on the market to do that.
Thank you.
And then finally, there's also DNA profiling. That's where we actually amplify short regions of DNA that are different in different people in the population. Those are called short tandem repeats. And we amplify those. We create millions of copies of them. And we do that on an instrument called a PCR instrument or thermocycler for the amplification. And then we move that over to a capillary electrophoresis instrument, which separates and detects the fragments. and produces a DNA profile. And then we use computer software. GMAP or IDX is the most common one for analyzing the DNA profiles and making our interpretations. And then once that's completed, we may or may not use one of these probabilistic genotyping programs that allows us to do a more sophisticated deconvolution and analysis, especially if we get a complex low-level mixture of DNA. So all of those are used. There's also a bunch of kits on the market for doing DNA profiling. There's options out there for different labs, and different labs use different ones, but they're all operating on sort of the same technology.
Okay. What is your understanding of the TrueAllele software, so the TrueAllele program?
So TrueAllele is a probabilistic genotyping program. And just to give just a little bit of background, when our chemistries and instruments started getting really sensitive, what we realized was that if we went and started swatting doorknobs and steering wheels and items like that, that people had merely touched, that we would oftentimes get very low amount of DNA, but we would be able to detect it, and complex mixtures, so mixtures of 3 or 4 different people. And at the time that we started to begin to detect it, we didn't have these probabilistic genotyping tools to assist us as analysts in our interpretation. And so it was really difficult. We had to do what are called manual interpretations, and different laboratories around the country were doing them differently and coming up with actually different answers to the same profiles, which we found out when NIST started sending around a whole bunch of profiles to different labs and asked if they could get the right answer. So we knew there were some issues with our manual interpretations that we needed some help with it. And some of these big data companies got involved, and they used biological modeling, sophisticated biological modeling of how these profiles behave, and then also computer algorithms to deconvolute complex DNA mixtures into their component parts, and then compare persons of interest, victims, suspects, whoever, against those deconvoluted profiles to see whether people were included or excluded, and with what statistical weights or confidence we could say that. And so these tools have really been a big change to our profession. Most labs had them on board around 2020. Some labs are still adopting them, but one program that's out there is called StarMix. That's the most popular around the country. It's used more often than other programs, but TrueAllele is also well regarded, and it's used by I don't know how many labs in the country now. Not as many as StarMix, but it's used around the country as well.
How long has TrueAllele been in existence?
I think it's been around quite a while, in sort of beta format. So, I think some of the papers started coming out maybe as early as 2000 from Mark Perlin and others, he's a major developer of it. But in terms of adopting it, most labs weren't adopting those kinds of probabilistic genotyping programs until around 2015, 2016, something like that. Okay.
Now, the companies that design the DNA software for comparison, did they provide training for, open training for experts such as yourself to review how they collect and analyze the data?
Well, so StarMix does. StarMix has 2 trainings. They have an introductory training, which is a week-long training, and they also have a virtual advanced training, and I've taken both of those. And as an independent DNA expert, I was permitted to sit in on those and participate as a full participant. And I was able to purchase the software, and I was able to use it in my own laboratory at Sacramento State, and then I also use it in my work as an expert. TrueAllele is a little bit different. Cybergenetics, and I'm not saying there's anything wrong with the company. I'm not saying anything bad about them, but they don't have an open training for analysts like myself. Now, that being said, they've been helpful to me when I've had questions. It's just that when I asked if I could purchase the software and if I could become fully trained, they're not doing that yet for independent experts, at least at the time that I inquired about it, which was fairly recently, within the last year. So, I'm not, I admit today, I'm not I do not consider myself to be a top expert on true allele. I have done a research study with a student at UC Davis and a colleague named Dr. Ruth Dickover, who used to run the Kern County Crime Lab. She was the DNA technical lead there, and they use true allele. So I learned a lot about true allele from her, and during the course of that project where we compared the performance of true allele and star mix, but I have not taken any formal training from cybergenetics for true allele. And when I have a case that involves true allele, I usually contact them and get advice on reading the reports and things like that, just to make sure I'm getting it right. I do consider myself to be a good expert on star mix, which is the other probabilistic genotyping program, and they operate under similar guidelines, but there are a number of substantial differences as well.
All right. And have you testified as an expert in forensic serology and DNA?
Yes.
Okay. And how many times have you testified as an expert?
I think as of today about 53 or 54.
Okay. And in those cases, and have some of those cases involved true allele?
Yes, they have.
Okay. And let me ask you, do you only testify for the defense? Do you ever testify for the state?
Rarely. I have testified for the state, but and I'll say also, when we're talking about criminal matters for the state versus the defense, it's the defense attorneys that contact me because the prosecutors use the criminals at the crime labs as their experts. So that's the reason. It's just sort of the way it's set up, the system's set up. When I'm doing civil litigation, I'm about equally between plaintiff and defendant in terms of who contacts me. But in criminal cases, it's almost always the defense.
Okay. And what jurisdictions have you testified in?
Oh my goodness. Well, I've testified in, I think, 25 counties in California. I've testified in Arizona. I've testified in Nevada, Washington State several times. I've been to Illinois, Wisconsin, Georgia. That's something I'm thinking about. But yeah, Idaho. The recent was in Idaho. So yeah, all over the place.
All right. Your Honor, at this time we would move to admit Dr. Ballard as an expert in forensic serology and forensic DNA.
Any objection, Ms. Ross?
I guess, Your Honor, at this time I need to, I guess, ask defense counsel, is she going to be offering any opinions on true allele or just forensic DNA in general?
Her primarily is going to be testifying as to forensic DNA in general, but she may have some comments about the true allele.
Okay, if I may just voir dire a little bit then, Your Honor, and then the best way to do this probably is for me to make a contemporaneous objection if I believe she has strayed outside of her expertise, which I will do. Just for background for the record, because none of this is on the record, at 4:15 p.m. last night, I got her expert report, which is 6 pages long. Had we not been in this posture, I would have, one, reached out to the doctor and, hello, Dr. Ballard, we've never met. Hope you're feeling better, which was not able to happen under the circumstances that I was put in. And also, I may have, after speaking with her, potentially filed a Daubert on this issue. Because we are not before a jury, and Your Honor would be hearing the Daubert anyway, and Your Honor will be the fact finder, I'm putting this on the record to let you know I'm not waiving any Daubert issues. I may actually supplement the record after this testimony in regards to the reliability, repeatability, Daubert factors. But I need to explore some things that I normally would have done in a Daubert hearing that we were just unable to do so because of the timing. So with that, if I may just voir dire a little bit, and then I'll probably just make an extemporaneous objection if I believe she's strayed outside the expertise. Thank you. Do I need to stand or sit? What's the best way to do this? It's kind of hard to stand and talk to the microphone. May I be seated? I may be seated? May. Thank you. Good afternoon, Dr. Ballard.
Hello.
I just have a few quick questions for you about your training and experience. It seems to me, based on your CV, your predominant career has been in academia. Is that correct?
That's correct.
Okay. And from about 1996, I didn't really memorize it, but like 24, you worked for basically the University of California system. Is that right?
Well, I worked for the California State University system as my primary job, but I also worked, as I said, as the forensic DNA and biology consultant for the forensic science graduate program at the UC Davis system. So that's University of California. Those are two different systems, but I've worked in both.
And when you talk about, well, let me just ask you this. Have you ever worked in a forensic crime lab?
Not as an employee. I did in a sabbatical there, and I visit crime labs frequently, but I've never been employed by a crime lab. That hasn't been my career.
Have you been a forensic serologist where it is your job to process items of evidence for biological materials?
Well, what I do is I do all of those things within the context of research. So we would collect and we would process in the same way, screen, do all the DNA typing and all of that using the same approaches and tools and chemistries and technologies that are used in modern crime labs. We're just using it for a different purpose.
Okay. Do you testify to those results in a court of law, the things that you do for research?
Sometimes, yes.
And when you're doing your things for research, the place that you're doing it, are they QAS or ASCLD accredited laboratories?
Well, that's not an appropriate thing for a research laboratory. So we're not issuing reports on crime scene evidence and things like that. So we're accredited through the university's accreditation process.
And could you explain for me then a little more why that wouldn't, well, first of all, what is QAS for the record?
Well, it's quality assurance, and the idea is that anytime you have a product going out the door, like a report, for example, or a product that you make in a company, it goes through some type of a QC process as it goes out the door, and you establish various techniques and protocols within the laboratory to assure that most of those, hopefully, are going to pass muster as they go out the door. In other words, you have training in place for your employees and all these kinds of things to assure that, that everything that you produce and it's being purchased, etc., or in this case, in the case of a crime lab, a report that goes out is accurate. We don't do that in academics. It's just not how we do things. We don't do ASCLD accreditation. There's no requirement for it, and there's no, people just don't do that in research. That's not the way we do things.
Okay. You would agree with me. Are you familiar with the Georgia Bureau of Investigation?
Well, I reviewed things a couple of times for them, yes.
And they are a QAS accredited laboratory by the FBI? They comply with QAS?
I believe so. I don't remember looking at their accreditation certificate when I looked through here, so I'm guessing that that's probably true.
Okay. Outside an academic setting, you have not worked then in a forensic laboratory that is required to be accredited by either ASCLD or QAS, FBI, and produce reports?
Yeah, only when I was doing my sabbatical in the crime lab.
And when did you do your sabbatical, and in what crime lab did you do your sabbatical?
I did it in the Sacramento County DA crime lab, and I don't remember the year. I'm thinking it was probably around 2006 or 7, something like that.
And you were there for the year?
I was there for 6 months.
6 months, okay.
Yes.
All right. How many times have you amplified DNA?
Thousands.
Okay. And all of those thousands of times have been in the academic setting?
Yes. I have done it in crime lab setting, but like you said, that's not been the primary focus at all. It's been academics.
Same question I have for you for quantification and amplifying. Have you ever done that? Go ahead.
Yeah, so DNA quantification is qPCR, and I've done that thousands of times also.
In an academic setting or in a forensic lab?
Both, but primarily academic.
Okay. Have you ever testified in a court of law to DNA results that you obtained yourself? You did the extraction?
Yes, I have. Yes, I have.
And approximately
yes.
How many times?
I don't know. I would have to look back at my CV and my cases. It's unusual. I mean, it's not the normal thing. Usually I'm doing a case review that's work done by another laboratory. I mean, by a laboratory, a crime lab, like I did in this case. But there are times when I will do an experiment in my laboratory that is pertaining to a particular case that there isn't a good body of research literature about that topic. And so in order to investigate it, I'll do the work in my lab and then I testify to that in court.
You testify to your experiment?
Yes.
Okay. And you don't know, sitting here today, how many times you've done that?
No.
All right. Have you ever I think I know the answer to this when you start talking about true allele. Have you ever operated the true allele probabilistic genotyping software?
I have been involved in it because like I said, I did a research project where we compared star mix and true allele. So I've been involved in that. Like I said, I do not consider myself to be an expert in true allele in the same way that I am with star mix. And I usually get some outside assistance when I have a true allele case for that reason.
Okay. So you would not consider yourself an expert in true allele?
I'm an expert, I would say I'm an expert in how probabilistic genotyping works, what it is, and I understand the differences between true allele and star mix. I'm not completely ignorant. But because I haven't run thousands of samples through true allele the way I have star mix, I don't feel as confident on it. And so, yes, I would say that I don't consider myself to be an expert in that particular probabilistic genotyping software.
Well, that's what I'm trying to get to the bottom of. How many times have you ran true allele?
Well, in our research project, we ran it hundreds of times. I think I can't remember the sample size. There's probably 300 samples, something like that, where we ran star mix and we ran true allele. So it's not that I haven't seen it and done it, and it's not that I haven't read about it, and it's not that I don't understand how it works. I think I have actually a better understanding of true allele than most experts in the country that are coming to court, because most of us are experts in star mix. True allele is not used by very many laboratories, and so to be experts in both would be a very unusual thing.
Okay, so 300 times. Were you running the program or your graduate students?
I was running it with them.
Okay, so together.
Yeah.
Right. And you know Jennifer Bracamontes from Cybergenetics?
Sounds familiar, yes.
Okay. Is she possibly one of the persons that you might talk to at Cybergenetics if you have a question about true allele?
Usually I talk to Bill Allen.
Okay. And you know Dr. Perlin as well? Mark Perlin?
I don't know Mark personally, no.
All right. All right. Your Honor, that'll complete my voir dire as for her expertise. I'm not going to object to just serology and DNA, and if she strays outside of that in a manner that I find problematic, I'll lodge a contemporaneous objection.
And for the record, we're asking that she be qualified as expert in forensic serology and forensic DNA.
I'll allow the witness to testify as an expert in the area of forensic serology and forensic DNA.
All right. So when you get involved in a case review, how does that process normally start?
Well, typically I get contacted either by email or phone by the attorney who needs my help. And so if I'm available, they'll first ask me if I'm available, if I have time to take the case, and if I do, I'll say yes, and then we usually talk about it either in a Zoom meeting or over the phone to discuss sort of, what the case is about, so I make sure that it's a good fit for my particular skill set. And then once we've established that it sounds like it is, then we talk about, okay, where are you in the process? Do you have a trial coming? Do you have a hearing coming? What's going on with that? So then we begin the conversation about retaining me and how we're going to share the discovery and things like that.
Okay. And so where do you get the materials for case review?
I typically get them from the defense attorney that I'm consulting with, who gets them from the DA, who gets them from the crime lab. So in terms of the DNA discovery, that's usually how it comes to me.
Okay. And you're not collecting the samples yourself when you're doing these case reviews. You're getting the material from the defense attorney. Do you ever get them directly from the state?
Not usually. I have sometimes gotten them directly from the crime lab, but it's always with the permission of the DA to release them to me. Sometimes when the files copy over, they don't copy over right, and so it's just more expedient to have the crime lab actually send them directly to me.
All right. And generally, you're involved post-arrest. Is that correct?
That is correct.
All right. And are you compensated for your time?
Yes, I am.
All right. And how are you compensated?
Well, I charge $300 an hour for a case review, and typically I can finish a review in about 15 hours. So that's about $4,500 for the pretrial work. If I end up traveling for testimony, I require a $1,200 flat fee for court testimony, but when I come on Zoom, I just charge by the hour at that same rate.
All right. And is this standard in the community of expert witnesses who testify in this area of forensic DNA? Is this a standard practice?
To charge?
Yes, charge fees.
Yes. Yes, and I also work a lot for public defenders' offices who have tight budgets, so I'm within their budget for experts in terms of my $300 an hour.
Okay. Do you always testify in cases?
No, I don't. So if you look at my CV, I think I've done about 350-something case reviews at this point, and I've testified in a little over 50. That's about 1 in 6 or so. So it's it's less than 20%, I would say, at this point that I testify in.
Okay. And you charge for your time, not for specifics of your testimony. Would that be fair to say, or correct?
Yes. So yes, so my job is to look at the crime lab work with an independent set of eyes, and to give an honest opinion to the attorney. The attorney then makes a decision, a legal decision, whether to bring me in or not as an expert and to testify. So that's out of my hands. I'm just there to give an independent, honest opinion.
And just so we're all clear, you were hired in this case by Georgia Public Defender Standard Counsel, correct?
Correct.
All right. Now, I'm going to talk a little bit generally about DNA. What role does DNA play in criminal cases?
Well, it kind of harks back to a major concept or founding concept in our discipline, which is called Locard's principle. And this is the idea that every contact leaves a trace. So if you think about a hit and run accident, somebody gets hit by a car on the road and the car speeds off, you might find, windshield glass embedded in the t-shirt of the victim that's lying on the road. That's a transfer from the car to the victim. And if you were able to find the car later, you might find blood from the victim on the windshield of that car. Okay? So that is the idea that when two things come into contact, there'll be some type of exchange. And the idea behind Locard is that holds out in forensic investigations. And so it's a very old concept. It's been around a long time. In terms of DNA, it's just extending that concept to understand that DNA can also be transferred. It can be transferred in a crime or even innocuous situations like a household or whatever, but it can be transferred between people. It can be cells in their DNA can be transferred between people. It can be transferred from, say, a victim to a crime scene. Maybe they bleed on the carpet. It can be transferred from a perpetrator to a crime scene. Maybe they get cut as they're knifing a victim, and when they leave, they're dripping off blood, a blood trail away from the scene. It can be left on a weapon, the victim's blood on a weapon, or say touch DNA from the perpetrator on the handle of that weapon, and so forth. So it can be transferred in ways that can help us assist us in understanding what might have happened and who might have been involved.
Can I stop you for a moment, please, Dr. Ballard? Keeping in mind that this is not a jury, and that while I'm certainly not an expert, I've heard of this many times. Perhaps we could narrow this, not only the questions, but also the responses. If you would just be responsive to the question, and if he needs to follow up, Dr. Ballard, he will, because of the purpose of this particular hearing. We're not in a trial. This is a motion hearing. So, thank you.
All right, Your Honor.
All right.
Proceed. Could we take 3 minutes, just so I can use the restroom?
If you need to, but I'm not dispersing everybody. If you need to step away for a minute, I'll allow you to do that. And are you asking that we stop while you do that?
Yes.
Then we will.
Thank you.
Somebody needs a bathroom break there, comfort break.
Just different now. I cannot.
Just going to fast forward here. Okay.
Before I go on to more, I did want to touch on one thing. I wanted to ask you about a concept transfer of DNA, direct and indirect. Can you tell us a little bit about that concept of transfer of DNA, direct contact, direct and indirect transfers?
Sure. I'll give you an example of body fluids, and I'll do one with touch DNA or skin DNA. So let's say that I bleed onto a Band-Aid. That's direct transfer of my blood onto that Band-Aid. Say I take the Band-Aid off and I put it on a counter, and my husband comes by, picks up the Band-Aid, and gets some of my blood on his fingers. That's indirect transfer. So the blood is now on his fingers, even though he never touched my wound directly. The Band-Aid was the vector for the transfer of that blood and its DNA. Similar things happen, if I touch a microwave handle and open and close it, and then somebody else comes into the room and does the same thing, they could pick up some of my skin DNA on their hands without having touched me directly. So again, in that case, the microwave handle would be the vector for indirect transfer. So when I touch the microwave handle and leave my skin cells and DNA behind, that's direct. And then if somebody comes in and touches the microwave handle and then picks up my DNA as a result of that, after I've handled that handle, that would be indirect.
Okay. So if I want to make sure I get this right so I understand. So I'm holding a pen in my hand. I don't know if you could see me with the pen. If you pick up my pen, you could leave your DNA on the pen?
Yes.
Okay. And if I touch the same item, then my DNA would be on there as well, correct?
Correct. It could be.
And then if I've been handling this pen all day and I went home and I opened the door to my house, could your DNA be on the doorknob as I opened the door?
It could be.
Okay. Even if you've not been to my house, you've never been there, your DNA could still be on that doorknob.
That's correct.
All right. And have you done research in this area, the transfer?
Yeah, about the last, I would say, 10 years at Sacramento State, most of my research was focused on DNA transfer, particularly of skin DNA. So 2 recent studies, if you want an example of studies, I can give you a couple of recent studies that I've done. I want to be responsive to your question.
Okay,
so.
yes. What recent studies have you done, just so we're briefly?
Okay, well, one study we did was of cell phones. So we collected 55 cell phones from volunteers. They had to fill out a questionnaire specifying that they don't share their cell phone with other people. So they're the primary user, only user of the phone, and that they don't wash their phone. And that was the things we had to screen them for. And then they gave us their phones, and we swabbed those phones. Then we collected reference DNA samples from them, so we knew what their DNA profiles were. And then we went back to the lab and ran the DNA profiles off of the swabs we took from the cell phones and ran the reference samples for the people who owned the phones. And so what we were interested in is we wanted to know whether or not there would be mixtures of DNA from more than one person on a person's cell phone. We also wanted to get a sense of how much DNA was present. Human DNA was typically present on cell phones. What was the average amount on those 55 phones? And we also wanted to know whether or not the person who owned the phone was always the major contributor, if it was a mixture, or or if they were sometimes in the minor slot, one of the minor slots. In other words, they contributed less DNA to the phone than someone else who doesn't even own the phone. And so the answers to those questions were, on average, in our study, it was about 2.5 people of DNA, 2.5 people contributing DNA onto cell phones. So we definitely had mixtures. We did have some single source, but we also had some very complex mixtures, up to 5 people in a mixture. We also found that the primary user of the phone was typically the primary contributor in those mixtures, but we did see a couple of cases where they actually were a secondary contributor. And so we also got a sense of the amount of DNA, and it's actually quite remarkable that we accumulate quite a bit of DNA onto cell phones. We had cell phones that had 10 nanograms of DNA on them, for example, which is a lot of DNA when we're talking about something that has been handled. Now, we also talk into our phones, so we're spitting spittle on them too, and that has more DNA than skin cells. So, but anyway, that was one study that we did. And another study we did was on cats and dogs. So we were interested in whether people shed their skin DNA onto their animals, their domestic pets. And so we went in and swabbed domestic pets, and we also swabbed their owners to see whether the owner's DNA was present on the pets. We also wanted to know whether there was DNA from unknown people.
Suggestion or direction was taken.
Okay.
Do you want me to control it, or are you going to?
I'll move on to the next question, Judge. If that, I get. Let me just. Can DNA tell us when something when does DNA analysis tell you when DNA gets on an item?
It can.
Okay. How can you determine that?
All right, I'll give you an example, specific example. So let's say that you have seminal fluid with sperm in it inside of a female, inside of her vaginal cavity. We know that spermatozoa don't survive inside the vagina cavity for more than about 7 days. And usually they're gone by maybe 3 or 4 days. So if you find sperm inside a vagina cavity, then you know that it was deposited within about the last week. That's why with sexual assault exams, we want victims to come in quickly. So there are conditions in forensics where we can actually say something about the timing. But if we're talking about an inanimate surface, like, for example, I swab a piece of clothing and I find DNA, then it's very difficult to know. I mean, there really isn't any way of knowing exactly how long that DNA has been there. We don't have a good way of doing that yet. So it could have been deposited there, months, weeks, days, even in some cases decades. I've seen contact DNA or touch DNA actually recovered from items even decades after they've been touched. So we don't know in those types of items.
Okay, let me ask you, can you tell how it got on, when you're talking about contact DNA, touch DNA, can you tell us, can DNA analysis tell us this, can it tell us how it got on that item?
It can tell you, so I do consider the amount of DNA we're talking about. I like to do DNA yield calculations in all of my case reviews, because I want to see whether we're talking about a few cells worth of DNA, which, could get there almost in so many different pathways, both indirect and direct, or whether we're talking about hundreds or thousands of cells worth of DNA, in which case, if I got that, say, from the collar of a shirt, I would think it very unlikely to be indirect transfer of that DNA. So even with contact DNA, if we're sort of talking about amounts, and we're talking about extremely large amounts versus extremely small amounts, you still can say something about how it might have gotten there.
All right. I want to talk about going back in time from about October of 2024. Were you contacted by Mr. Ibarra's trial defense team?
Yes, I was.
Okay. And do you know, how did they contact you?
As I recall, they contacted me by email. and wanted to know whether I was available to work on this case.
Okay. And when you have dialogue with attorneys, and would you have told the trial team what you would need, what you would need to in order to complete your review of the evidence?
Yes, I usually send them a complete list of DNA discovery to request from the DA, because most attorneys don't know what to ask for. And then I'll also give them a time frame for my review.
All right. And so what is your time frame for review?
Typically, from the time I receive the full discovery to issuing a report is about 6 weeks.
Okay. Now, back in October 2024, did you have other cases that you were working on at that time?
Yes, many.
Okay. Can you give us a couple, a couple cases that we might have heard of?
Well, I was working on the University of Idaho student murder case at that time. I can tell you that. That was taking up quite a bit of my time. But there were numerous other cases that I was working on that very week when Mr. Donnelly contacted me.
Okay. At that time, did Mr. Donnelly talk to you about specifics about what scheduling order for the trial and motions? Did he talk to you about that?
I don't remember specifically. I know that he asked me about my time frame, and I explained that to him. I have email correspondence on that. I don't recall if he actually said, any particular dates to me and asked me if I could be ready by that date. I don't remember that.
Okay. So you weren't aware that there was a motions hearing held on November 1st, 2024 on the issue of, the challenging the true allele and on the DNA?
No, if I had known that, I would have told him there's no way that I can, I don't even have the discovery yet, much less have time to do a review in that period of time. Yeah.
And given that you would not have been ready for the November 1st motions hearing. If you were even if retained, you would not been able to complete your review within a week. Fair to say?
No, that is fair to say.
And I believe this trial started November 15th, about 2 weeks later. Time period of November 15th through 18th. Would you have been able and ready to, with that, given the cases that you had at that time, would you have been able to do a full review?
It would have been very difficult for me to do that, and I didn't even have the discovery at that point. So the 6 week time frame is coming from the day that I get full discovery. And part of what I do immediately when I get discovery is to go through it and see what's missing. And once I realize what's missing, there can be additional time required for me to get what I'm missing, and then to get the lab to respond to that and give it to me. And so the clock keeps moving. So the answer is that unless every star aligned and all of that came to me, and I was able to push everything aside, I would not have been able to do it. No.
And you were like the Idaho student killing, you were already retained on that case, so you already had deadlines and work that you were having to do on that case.
Yes, and many other cases too. Yes.
All right.
Yes.
All right, Your Honor, if I may move to the podium to introduce them.
Right. And while you're doing that, I'm going to take care of another quick matter. Come on. While you're getting set up.
From the elements, okay.
Yeah.
Thank you. That's fine. Yeah,
Okay, I just wanted
I just didn't know how you would explain it.
I told you Steve.
He'll hit the judge. I'll switch. I was 2 and 3. That's probably different than your certification.
Okay.
Yeah, do yours too.
All right, hold on.
No, because mine might.
Okay, that's fine. We'll do that.
Because mine also is really defense.
Okay.
All right, you may proceed.
All right, Dr. Ballard, I want to make sure. Can you see what I've got on the Elmo?
I can see that you have something on the Elmo. I can't read any of it.
Okay. All right. I don't know how we can. Can you change your view setting from where you are, Dr. Ballard?
Let me see what I can do here. I can get the layout, do a full screen, see if that does it.
If you do stack view. If you do stack view, you should be able to see it.
Okay, I'll try stack view. Yeah, if I'm on stack view, it's a little better. Good afternoon, Dr. Ballard. I can see I have gotten access to the data. Okay, I can read it now.
Okay. I'm going to show you what's marked as Defense Exhibit 1. Do you recognize this email addressed to yourself?
The state would have no objection to the admission of Defense Exhibit 1.
All right. Once admitted.
Once admitted. All right, with that, I'm going to show you what's marked as Defense Exhibit 2. From that email, were you able to go to access the information? Well, let me ask you, do you recognize this screenshot?
Yeah, it looks like it's the links to the various folders from the crime lab.
No objection to Defense 2.
All right. 2's admitted.
Thank you. I'm going to show you D3, the record certification. Did you pull this?
Yes, that was part of that.
No objection to D3.
3's admitted.
All right. Now, I'm holding, there's a USB that can, and did you download, there was 3 zip drives. Did you download those drives?
Yes.
Okay. Your Honor, at this time, I've had some discussions with the state as far as D4, 5, and 6. These are the zip drives which we have downloaded that was accessed from the State Defense Exhibit 2, downloaded. We've given it to the state for them to review. We'd ask that be admitted at this time.
Just D4?
D4, 5, and 6.
What's 5 and 6?
Each one. D4 is zip file 1, 5 is zip file 2.
Oh, are they all on the same thumb drive?
They're all on the same thumb drive.
Can we just have D4 for the...
We can do that.
It's one thumb drive, so it'd be very confusing if it has 3 different numbers.
We can... D4. We'll ask that you do D4, Judge.
And Judge, I have no objection to the admission of D4 with this caveat. So this is the conundrum we find ourselves in with virtual witnesses, which is why I rarely waive my right to cross them in person, but I'm doing it in this case, and I did willingly once I got the report. Usually we would have the witness authenticate it, and we can go through it that way, but she can't do it where she's at. So I've made an agreement with the defense attorneys that I will agree that D4 is what they gave their witness from the GDI. I can't verify whether it's exactly what I have, and we don't have time for that, but I am happy to stipulate that D4, based on defense attorney's recommendation, or not recommendation, but their assertion, that D4 is the data that this witness was able to access from the GBI server, and it was downloaded onto a thumb drive, which is D4.
And I'll state my place, that's what happened.
Yeah, and I can't tell if she downloaded it all. I don't know. I wasn't there. She can't see it, but I'm okay with that stipulation.
I will admit D4 with the reservation stated by the state.
Thank you. And based on the review, did you review those files?
Yes, I did.
All right. Just a couple other things. Did you prepare a report in this case?
Yes.
I'm going to show you, and this is now marked D5.
No objection to the report, D5.
5's admitted.
Okay. And this will be, this will now be Exhibit D6. Did you create a spreadsheet?
Yes, I did.
Okay.
No objection to D6.
6 is admitted.
Thank you, Judge. With that, if I may, you want me to present this to your court reporter?
That'd be fine.
Thank you, Judge. Let me just do that, and I can go back to the table. That completes our portion of evidence that we are admitting. Dr. Ballard, do you have the ability to screen share where you are? Can you screen share? Because I think you have the spreadsheet with you.
I don't think she can hear you from where you're located.
Sorry, Dr. Ballard. I think I was just talking while I was walking through the courtroom. Do you have the ability to screen share where you are? Can you share?
I should be able to if you give me permission.
Judge, we would ask for permission to screen share.
She may.
Okay, let me see if I can pull up the spreadsheet here. I want to make sure I get the right one. See if that's the right one. No, that's the wrong one, so sorry. I've got to pull up the right file, so if I could just give me a second here.
And while she's doing that, Judge, we can we've already prepared. We've given a copy to the state. If Your Honor, we could give you a courtesy copy as well.
Thank you. That in mind, if I've got this, you've got yours, she's got hers in front of her. I don't know that we need to. Do we need to screen share?
Well, Your Honor,
I think I can read mine. The problem is that I can't figure out how to get out of the screen to open up what I need on my desktop to make sure I can access it. This is a program I'm not used to using, so the layout, it doesn't help any.
Dr. Ballard, when you're testifying about the spreadsheet, could you just note for us, for the record, which row and column you're referencing, and then we can follow?
Sure, I can do that, yeah.
All right.
And if they're doing that, Judge, I would just like to make sure that the record is clear, number one, that Mr. Ibarra can see and hear the witness based on where he's seated in the courtroom, and that he is able to follow along with defense counsel with that exhibit.
Can you confirm that with your client? Ms. Smith will come over.
Yeah, I can. All right. So just tell me a little bit. Let's start first. Talk about how you set up your spreadsheet, Dr. Ballard.
Okay, well, the spreadsheet's designed to give me an overview of everything that was tested in the case, what tests were performed, and what the crime lab results were. So it starts on the left-hand side with the first column, which is the lab item number that was assigned to the evidence when it arrived at the crime lab. And then the next column is the description of that item. And this is all taken from the analyst's bench notes. And then if there were any sub-items and what their descriptions were and so forth. And then if they did any body fluid identification, serology, I indicate what tests they used and what the results were. And then this lab also did a little bit of male DNA screening on a few items, and so I have a column for that. And then I go into the regular sampling that they did for DNA. There's a bunch of blank spaces on the spreadsheet because I was unable to obtain the information I needed from the bench notes that were provided to me to fill that in. So I couldn't calculate how much DNA they found. I would normally do that in a case. And then after that is information about the profiles that they got, the DNA profiles they got, and the interpretation of those profiles in the report.
All right.
And then on the very far right-hand side is whether or not there was any DNA that could be reasonably assigned to any of the persons of interest in this case.
All right. So what was let's just start with the first item. What was the first item that you looked at?
So it was lab item 2, and it was a sealed package that contained disposable black gloves that was submitted to the lab for trace evidence, forensic biology, and latent prints. Of course, I only looked at the forensic biology part of this. So the first glove is assigned as 2A, the second one is 2B, the third one is 2C. Then they went into serology. So they actually did test these gloves for the presence of blood. And this laboratory uses 2 different tests for doing that as sort of backup, I guess, to make sure that the results they're getting are correct. This is what we call a screening test, so it doesn't say it's human blood, it doesn't say for sure it's blood, but it's a well-regarded set of screening tools for determining whether a stain might be blood.
Was there blood stains found?
Yeah, so there was blood found on all of the gloves. Those swabs were then, those stains were then swabbed. There was also what they called contact swabbing of the gloves. Of the glove, the first glove and the third glove, there was contact swabbing, which means that usually what that means, and the analyst would have to, explain how they use it in their lab, but usually what that means is that they're avoiding the stained areas and looking for skin cell DNA rather than looking for who's the source of the blood.
Okay. Then what was the next thing you looked at as far as the gloves?
Well, then we looked at the DNA. So they did not continue on with DNA typing with the second glove or the stain on the third glove, but they did do the stain that they found on the first glove and the contact swabbing from that glove, and they also did DNA typing on the contact swabbing from the third glove. And when they did that, they got complex DNA profiles. That means that there's a mixture of DNA, and they felt that the profiles were going to be better analyzed if they went into their True Allele software, and so that's what they did. And when they did that with the first stain, the stain on the first glove, that was a stain, remember, that tested positive for blood. They got a mixture of at least 2 contributors with a major and minor component, and they had a DNA match to the victim on the major component, and then the minor component was too limited in genetic information for them to do anything with TrueAllele. The contact swabbing was also 2 contributors with a major and minor component, and again came back to a match to the victim, and the minor component was too limited for comparisons. And then the contact swabbing on the 3rd glove gave the same exact result. So all of the DNA that they obtained on the gloves came back to coming from almost with a very high degree of scientific certainty, coming back to the victim with a contribution, a very low contribution from at least one other person.
Was Mr. Ibarra's DNA found on the gloves?
No, like I said, the major component came back to the victim, and the minor component was so limited that comparisons couldn't be made. So we have no idea who contributed that minor portion.
So that could be anybody?
Correct.
All right. What was the next item that you evaluated?
Should say it could be anybody but the victim. Because it was somebody foreign to the victim.
All right.
Correct.
Fair enough. Actually, just to be clear, because that wasn't a very clear question I asked, and I'm going to clarify. It could be anybody as far as the minor contributor, the contributor of the minor profile. We can't determine who that person is.
Correct. Right. It can't be the victim, though.
Okay.
Because there's 2 contributors to these profiles. So we know that the victim is the major contributor with a very high degree of scientific certainty. We just don't know who the minor contributor is, but it's not the victim.
Okay, what was the next item that you looked at?
The next item was the blue jacket, which was item 8. And on the blue jacket, they did test a stain. Looked like, I guess, like a blood stain on the jacket. And it was also positive in those 2 screening tests for blood. But they didn't take that one forward for DNA testing, so we don't know whose blood that is. They did do also contact swabbings of the jacket. So again, I'm assuming that this is areas of the jacket that were unstained. So trying to get information about possible skin DNA transfer, for example. When they did that again, they got a complex profile, which is very common off clothing. The analyst decided that this was best analyzed by TrueAllele, not a manual interpretation that she could have done. And the result of that was at least 3 contributors to this profile. And there was a DNA match via TrueAllele to the defendant as well as to the victim. And the other people of interest that were tested here, Diego Ibarra, and I can't remember the name of the other Ibarra, begins with an A.
Arianis
Ibarra. They were both excluded as contributors to the major component. So basically what this had was it had a major component that had 2 people in it, and then it had a minor component that they couldn't do anything with, they couldn't make any comparisons. But they were able to exclude both of those other 2 individuals as contributors to the major component. So this major component was a mixture of 2 people, including both the victim and the defendant.
Okay.
And I also did look at the DNA electrophoregram for this one and determined that the mixture ratio between the 2 of them was approximately equal, with slightly more DNA coming from the victim. And that was also borne out by the TrueAllele analysis too. So I looked at the electrophoregram to make sure that it looked as if it was being interpreted properly by TrueAllele, and it looked like it was.
All right. Does the minor profile, does it rule out Diego or Arianis?
No.
It does not?
No. It's, again, one of these ones that is too low in information for them to make any comparisons.
Okay.
So they're only ruled out as belonging, having contributed DNA to this major mixture.
Okay. So, and I'm keep mispronouncing his name, but Arenas and Diego cannot be ruled out. Is that correct?
That's correct. Nobody can.
Okay. And can you tell from, so we know that from your review, you see that DNA from Mr. Ibarra and Ms. Riley is present on the jacket. Does that result in and of itself, does that tell you when and how the DNA got there?
No.
Okay. And like for when could have the jacket for Mr. Ibarra, when could it have happened? Do you know? Can we tell?
Well, it's hard for me to tell for two reasons. I mean, one is fundamentally it's very difficult to say that. No, you can't say. I mean, he could have been wearing the jacket months, weeks, days, or at the time of the crime, before it was collected by the police. So in this particular case, it's we don't know when it got shed on there. The same thing for the victim's DNA. It could be possibly that when the analyst swabbed this, she was actually picking up some of the victim's blood without realizing it, like tiny spatters or something that she didn't see visually.
I'm going to have
so maybe that's the source of the blood.
at this point.
There's an objection, Dr. Ballard.
Objection, speculation.
Judge, she's testifying as an expert, giving her opinion based on what she reviewed.
Allow it. You may continue.
Okay. Or it could be she wore the jacket at some time. It could be that she grabbed the jacket. There's really no way of knowing how her DNA got there. No. I also don't know exactly where the jacket was swabbed. That wasn't clear in the analyst's bench notes. Whether she swabbed the entire jacket with a swab and kind of tried to pick up as much contact DNA as she could, or if she swabbed, say, the inside collar or something like that.
Okay. Is there any other findings that you, or opinions you have based on the findings as it pertains to the jacket?
No, I don't think so.
Okay. Let me ask you, for a hypothetical, does the findings of the DNA, does that exclude the possibility that maybe, if, for a hypothetical, that Mr. Ibarra may have just simply moved the body and not had anything further to do with it except for moving the body? Does it exclude that?
It doesn't exclude that if, I mean, he could have been wearing the jacket when he moved the body and gotten some of the victim's DNA on it during that process, or some blood, whatever. Yeah. I don't see that it excludes it, no.
Okay. And it also doesn't exclude that one of the minor profile, one of the persons that contributed to the minor profile was wearing the jacket beforehand.
Correct.
They were wearing it when the jacket had contact with Miss Riley.
Correct.
All right. What was the next item that you reviewed?
The next item was item 14, which was a sealed sexual assault evidence kit from the victim. It contained some vaginal swabs, anal, perianal swabs, and oral cavity swabs. And what they did was the analyst screened those for male DNA to see if there was any male DNA present, and did not find any, and so there was no further testing of those items.
Okay. So no male DNA found, correct?
Correct.
All right. We'll move on then to the next item. What was the next item that you reviewed?
Item 15, which was a sealed package containing a blood stain from the victim, which was taken in order to obtain her reference DNA profile for comparison purposes.
Okay. So it's just like a control sample. Would that be fair to say?
Well, we wouldn't call it that. We call it a reference sample. But the idea is that, when we're making these comparisons with TrueAllele, we're asking TrueAllele, is this person a potential contributor? Is this person a potential contributor? And to do that, TrueAllele needs to know what the profile of that person is, right? So that's what that was taken for.
Okay. So I don't think we need to ask anything further on that. What was the next item that you reviewed?
The next item was item 18, which was a sealed package that contained the fingernail clippings, a collection kit taken from the victim. And there were two sub-items there. There was fingernail clippings from the right hand. There, in the bench notes, it appeared that the analyst noted there was some red-brown staining on those. And there were also some fingernail clippings from the left hand, which also appeared to have a little bit of red-brown staining of some kind. And that those were assigned as 18A and 18B. 18A, the analyst took a wet and a dry swab, it's called the wet-dry technique or double swab technique. It's very common to collect evidence from the clippings. She assigned that as item 42. And then she also did the same procedure with the left-hand clippings, and she assigned that as item 43. So going forward into DNA, those were items 42 from the right hand and 43 from the left hand.
And what were your next? Based on that, what was your review on that? What was the next thing you reviewed?
Right. So the laboratory actually did two different types of DNA profiling on the sample. One of them is the normal DNA profiling that we do. This lab uses a kit called GlobalFiler, and it amplifies and types short tandem repeat markers from both males and females. And it's the one that has this very high level of discrimination when you get a good profile. There was also another kit called Y-Filer Plus that was used by the lab that looks at the same types of markers present only on the Y chromosome, which is found only in males. And so there were two different types of profiles to review and that are in my spreadsheet. When they did the Y-specific or male-specific testing, they got what appeared to be one male haplotype, which is what we call a profile off the Y chromosome. And what the lab was able to say was that it was consistent with the Y profile of the defendant and also the RNS, Ibarra. And just for context, in a family, the Y chromosome is passed intact from fathers to sons. So if two people are biological brothers, or if they are male biological cousins whose relatedness is through the paternal line, they're all going to have the same Y chromosome, and they're going to carry these same markers, so they're going to have the same haplotype. So anybody in that male line could be the contributor of the DNA, including these two particular individuals of interest in this case. So that's what the Y-Filer Plus told us. They then went into the regular GlobalFiler test and produced a profile there. Again, due to its complexity, they decided to use TrueAllele as a tool to deconvolute the mixture. TrueAllele came back with at least two contributors, where the victim was actually assumed as a contributor in some of their calculations, so she was assumed to be present. And there was a DNA match also to the defendant. And then both of the other persons of interest were excluded as contributors. So what we learned is there are two people of interest in the case who were included by the Y-Filer testing, but when they went into GlobalFiler, the other one dropped out, and it's just the defendant here that's included as a potential contributor. I also looked at the DNA profile associated with this and calculated an approximate mixture ratio of 20:1, where the victim was the 20 and the 1 was, with a high level of scientific certainty, was the defendant. There was at least one male in the sample. but the male part was partial and very low level. I then confirmed that by looking at the true allele mass table, and they had a ratio of about 95:5, which is 1:20. So all of that matched up, and I felt very confident that that was a good deconvolution of this mixture.
When you say it's a low contribution, what significance of that is that when you find that the mixture is 20-1 and the amount of DNA from Mr. Ibarra is likely very low? What's the significance of that?
Well, I think here, in this particular sample, when we're talking about DNA transfer, and again, I don't have all the numbers here because the bench notes were incomplete with regard to that, and so once I do those calculations, I'll have a much better idea of what's going on here. But if this turns out to be a few cells worth of DNA, for example, from the defendant, when there's very low DNA like that, the possible ways it might have gotten there are much greater than if there's a lot of DNA. Hundreds of thousands of cells worth of DNA, we're talking about a scratch. We're talking about somebody scratching somebody else and getting under their nails. Unless they shared a cigarette when they were smoking or something and they got saliva under there somehow, we're really talking about something that is probably drawn blood or there's some kind of body fluid involved. If it's only a few cells, you could get that by, carrying someone. You could get it by shaking their hand, potentially. So that, because it's so low, we're within the realm of being able to transfer pretty easily through, non-criminal types of activities or whatever. So it does matter to me that it's, it's a very low, looks like it's probably a very low amount. I base that on the fact that it's only 5% out of the mixture, according to true allele, and also according to my manual interpretation of the electropherogram. So I think that that's about right. And also, the likelihood ratio here that included him, although it was 10 billion, and that sounds really high, in the world of DNA typing, that's actually a fairly low number these days if you have a lot of DNA. You get numbers up in the septillions and octillions and 1 millions when you have a lot of DNA in terms of inclusionary likelihood ratios. So from my perspective here, I'm thinking it's probably a fairly low amount of DNA from him, but I'll know more once I get the data that I need from the lab.
And just for the you were retained earlier this month, January 6th, correct? That's when you were formally retained on this? That was when I was formally retained, and I believe I received the discovery on January 14th. Thank you. All right. Does the DNA results tell you, as far as the fingernail clippings, does the result tell you when and how the DNA got there? I know with Miss. Okay. We know Miss Riley, it's her DNA because it's her fingernails, but as far as... Correct. In terms of her, I was thinking more about how the defendant's DNA got there, which is the matter of interest here. And I can't tell when or how it got there. All right. Now, that being said, if I did get data from the lab that showed that it was hundreds to thousands of cells, which I don't think is the case given other things that are looked at on the sample, but if that was the case, then my opinion on that would be that it's more likely that that was some type of a scratch or direct contact type of situation, because, getting that amount of DNA into your fingernails would be very unlikely just by, say, moving a body or touching somebody, shaking their hand or something like that. All right. Unless, like I said, a body fluid is involved. All right. What was the next item that you looked at? All right. The next item was a sealed package containing a rock that was identified as collected from the scene. And that was item 22. And what were your findings as to that rock? Okay, well, the analyst saw a stain on the rock and tested it, and it was positive in the 2 tests that they used for screening for blood, and also took some contact swabbings, which again I'm assuming are from unstained areas of the rock, to try to find skin DNA for whoever was holding the rock. That would be the idea.
Move to strike
all of
any
that.
assumptions, Your Honor. Objection to her assumptions. If she's testifying from the lab notes, that's fine, but I object to any assumptions she might be making.
They're based on her review as provided. She's reviewing the materials and testifying as an expert based on her. She's giving her opinion as to. I'm going to sustain the objection. All right. Was there any Mr. Ibarra's DNA found on the rock?
No. So all of that DNA on item 22, which was the rock, all of that was a single source DNA profile that matched the profile of the victim.
All right. Next item. What was the next item that you reviewed?
This was item 23, which was also a rock. And they did the exact same thing with this rock. They swabbed a stain, and they also did what they called contact swabbings. And again, both of those came back single source DNA profile matching that of the victim.
All right. Next item that you reviewed, Dr. Ballard?
This was item 24. It was described as a cutting from a tree. They tested that for blood using the two tests they used, and they were both positive. And then a swab was taken from that stain, and it came back single source sample, single source profile matching that of the victim.
All right. Mr. Ibarra's DNA, was that found on the tree?
No, it was just DNA entirely from her.
All right. What was the next item that you reviewed?
The next item was this was item 25. It was a sealed package containing clothing identified as coming from the victim. And that included 25A was a black jacket, 25B was a black shirt, and 25C was a piece of black bra. The laboratory did a couple of things with this. They used something called an alternative light source, which is also called a crime light. This is a narrow wavelength of light that is shined at an object and excites fluorescence in some materials. And there are biological fluids, particularly semen, saliva, and urine, that will respond to this light. And so she screened and found a bunch of stains on all of these items. However, lots and lots of things. It's a very non-specific screen, this ALS or crime light. It picks up a lot of different things. So it's not unusual to just look at somebody's shirt and find multiple stains with this thing. It doesn't mean they're body fluids. So appropriately, she followed up with a test for seminal fluid, is what she wanted to know, if there was any seminal fluid. Apparently that was her question. And so she did something called an acid phosphatase test, which is an enzyme found at high levels in semen. And all of that was negative on all the items. And so she didn't take any of those forward for any further testing.
Okay. So no additional tests?
Correct.
All right.
No DNA testing.
All right. What was the next item that you reviewed?
The next item was item 26, and that was a sealed package containing another piece of the bra. And again, she did the same techniques, the ALS, the alternative light source, and tested those stains, all those stains for seminal fluid, and it was negative using the acid phosphatase test, and so she didn't do any further testing on the bra either, on that piece of bra.
And the next item you looked at?
The next item was item 35. And that was a sealed package containing buccal or cheek cell swabs from the defendant that was used to establish his reference DNA profile.
Okay. So just the reference source, correct?
Correct.
And what was the next item that you looked at?
This would be item 39. It was a sealed package containing a black ball cap that was submitted to the lab for trace evidence, forensic biology, and latent prints. She did do serology on this. She tested 9 stains on this item, and she got a weak positive result for blood on one stain only. That was stain number 9. So she took that one forward for DNA testing, and again used true allele as an assistance, and got a DNA mixture with at least 3 contributors, with a match to the victim, and then due to limited data, the rest of the profile could not be interpreted, and so we don't know who were the other 2 contributors.
Okay. And all right, I'm going to come. What was the next item you looked at?
That was item 41. It was a sealed package containing evidence identified as collected from the apartment of the defendant. It included an airsoft pistol, which was assigned as 41A. The analyst did test that for blood. It was negative in both of those tests, and she swabbed it for DNA. She got a DNA mixture with at least 2 contributors. This one was very heavily weighted in terms of it being one person. There was a match contained with that was made with Diego Ibarra, which was very high likelihood ratio, so very strong scientific certainty that that's his DNA. And they were able to exclude from this the victim, the other person of interest, and the defendant. They were all excluded.
Okay. Next item that you reviewed?
The next item was item 44, and that was a sealed package containing clothing that was identified as being from the victim. There was a pair of black pants, that was 44A, gray panties, 44B, white shoes, 44C, socks, gray socks, 44D, a sealed package containing a black hair tie, that was E, and then F was a sealed package containing a black bra strap. The analyst looked at all those items, again, used an ALS, alternative light source, crime light, to look for body fluid stains, and then followed up on any positive stains, looking for acid phosphatase. All of those results were negative. For the panties, she did one step further and did a test for another enzyme found in semen, which is called P30. That test was negative, and she also looked under the microscope for spermatozoa and did not see any. None of those items were taken, none of the swabs from those items were taken forward for any DNA testing.
All right. So no DNA located on Mr. Ibarra's DNA was not located on any of those items, correct?
Well, she didn't test it for DNA.
Okay.
So we have no information about the DNA.
Thank you.
We just know that there was no indication of seminal fluid.
Okay. All right. I think the next 2 items are, we're talking, looks like it's from Arenas and Diego Ibarra. Is that correct?
Yes, those are reference samples from them that were again used to establish their DNA profiles so they could be compared, their profiles could be compared against the evidence.
All right. And what was the next item you looked at?
After that, it was item 52. This was a sealed package identified as containing slides for trace evidence in biology. I wasn't sure at first what the slides were, but it turned out it sounds like they're shoes, because 52A was described as one black and red slide, left foot, and the other one, 52B, was one black and red slide, right foot. These were both inconclusive for blood because one of the tests for blood was positive and the other one was negative. Neither of those were taken forward for DNA testing.
Okay. So because you got it at the early stage that it was one of the tests was inconclusive, there was no further tests. Would that be fair to say?
Well, It was inconclusive because one of the tests was positive and the other was negative. And in this lab, that is what they would call it an inconclusive result.
Okay. And that's generally typical for labs. Would that be fair to say?
I would say that I was actually impressed that this lab used two different tests to screen for blood and uses that as a sort of a way of confirming their results. I thought that was actually a very good way to do things. Most labs use just one test.
All right. And what was the next item that you looked at?
So that was item 53. Also contained slides. There was one black and red slide left foot, one black and red slide right foot. Again, testing for blood. In this case, both tests were negative.
Okay.
And so there was no DNA testing done on those.
All right, and I think, is there one more item that you looked at?
It looks like there is, there's actually a couple more. Okay. So this item 54 was the clothing of the defendant, and 54A was a red shirt, and 54B was a pair of red, white, and black shorts. And the shirt was inconclusive for blood because the two tests did not give the same results. Same thing happened with the shorts, and neither of those was taken forward for DNA.
All right. And then the last item.
So there was a sealed package containing evidence that was found somewhere near or within some distance of the crime scene, I think near some type of pond. It was a foam cup with a lid, and there was a straw. So 64A was the foam cup, and 64B was the straw. They tested the foam cup for an enzyme called amylase, which is found in saliva, and that was negative. They didn't take that sample forward for any more testing. The other one, the straw, actually tested positive for this enzyme that's found in saliva. And so they went forward with DNA testing on that one. And they ended up getting a DNA mixture with at least two contributors. And one of those contributors was, with a high degree of scientific certainty, the defendant. And there was also DNA from another person. It was a fairly equal mix of the two of them. So there wasn't like 95-5. It was much closer to 50-50 between the two of them. And they were able to exclude the victim, Diego, and the other person of interest as contributors to this. So whoever it is that's the other contributor to this is not one of those three.
But there's another contributor who's at least drinking something out of that cup.
Well, yes, it would appear so. I mean, like I said, I don't have all of the DNA quantitation values, so it's hard for me to say is this amount of DNA consistent with saliva, but they did find amylase there, so it suggests that at least some of this DNA was delivered as saliva. So, and there was, like I said, it wasn't like, a whole lot of DNA from one person and a little bit of DNA from the other. It was a fairly equal distribution, and that was also borne out by the true allele data.
All right. In working and your business now as doing these analysis for defense counsel, do most defense attorneys understand what you have systematically gone through with us and your findings? Do you find that, this in your observation, would an attorney, do they generally understand what's going on before talking with you?
Objection to speculation and relevance.
Give us that.
Is it possible for a person to come up with these results?
Okay. Dr. Ballard, is it possible for a lay person to come up with these results on their own, looking at the raw data?
No.
Do you know what that means?
Is it possible for a lay person to interpret the raw data?
Is it possible for a lay person to interpret the raw data?
No.
Taking. Okay. Does your analysis cover all of the raw data that was provided to you?
Yes.
Okay. And do the scientific findings exclude the hypothesis that Mr. Ibarra's DNA could be on these items through indirect contact or indirect transfer?
No, not that I'm looking at, except I would say with the straw, because there appears to be, and again, I want to confirm this by calculating DNA yields, but it appears that there was a very robust profile obtained from the straw. It wasn't a partial profile, and that most likely at least some of that came from saliva. And so, there's that, and I would take that into consideration, especially if I had the DNA yield data. That would not be a form of indirect contact. And certainly, when you test a blood stain and it comes back to a particular person, or that person is by far the major contributor to that, that looks like it came from blood. So that would potentially be more likely to be direct, although it could be indirect. But in a lot of these cases, I cannot tell whether it would be direct or indirect. And like I said, getting the DNA yield data will really help me with that.
And generally, when you do your, is it common for you when you have the time and to be able to reach out to state's experts and talk with them, and you have dialogue with them and tell them, hey, this is what I'm missing? Is that something that has happened in your practice in doing?
Yes. Yes.
Your Honor, I think I am finished. I just want to make sure, confer with co-counsel, and we might just have. Did I answer already? Okay. What is in there? What is not there? Okay, so. Would they be able to realize that it's not there? Oh, you're talking about a layperson? Yeah. Okay. All right. So would it be possible for a layperson to know what data is there and what data is not there?
No, they wouldn't know what to look for, and so they wouldn't be able to assess if something was missing.
Okay, so they wouldn't. All right. I think that's all the questions I have.
Okay, this is probably an appropriate time to take 15 minutes. Dr. Ballard, you're fine where you are, or you can step away for 15 minutes. All right? Thank you.
All right, thank you.
All right, 15 minutes.
Judge. I was just going to say, Judge, I could get a weekend on Monday. So, for small favors.
Yeah. Hey, take.
I can think about one thing at a time.
Hey, Madam Court, maybe go back there. Yeah, well, it's up to.
There's something uniquely human about asking for the bathroom in front of God and everybody. It's like, I can't focus on your testimony right now.
Well, hey, that's.
Okay.
Thank you.
15 minutes.
Oh, it's locked. Sir.
Back.
Proceed.
Thank you. And I, with the court's permission, may I stay seated for cross-examination for the microphone? Thank you. Good afternoon, Dr. Ballard. Can you hear me?
I can.
Okay, great. Please just let me know at any time if you cannot hear me. First of all, I want to go back a little bit to where we started. Your 6-month sabbatical at the Sacramento County District Attorney's Office, did that qualify you under FBI QAS standards as a DNA analyst?
No, that's not what that was about.
Okay. Have you ever been qualified as a DNA analyst?
Not in the way that you're suggesting. So you're suggesting, working in a crime lab, doing evidence, all of that stuff. I've never worked in a crime lab in that way, no.
I want to talk to you a little bit about the timeline. So it appears to me, based on what I've been able to read, and please correct me if I'm wrong, you were formally retained on January 6th of 2026 by appellate counsel in this case. Is that right?
That sounds correct, yes.
On January 14th of 2026, you note in your report that the discovery was given to you. Is that correct?
Yes.
And I know that some of the discovery is what's contained in Defense Exhibit 4, which is predominantly the raw data from the GBI. But I noted, or you noted in your report, that you reviewed some other sources, correct?
I'm not sure what you mean.
Well, on page 3 of your report, you say you reviewed the map of the crime scene, States Exhibit 154. Did you do that?
Yes, I did.
Okay. Number 3, trial transcript, volume 1, page 257, the examination of Preston Norris. Did you review that?
Yes.
And then 4, selected police reports for information and background only. Did you review that?
Yes, to get the case background so I understood what the crime was about. Yes.
All right. And then on January 29th of 2026, which was just yesterday, you produced a 6-page report. Is that correct?
Yes.
And between January 6th of 2026, when you were retained, and until yesterday when you produced this report, how many hours did you spend?
Well, I didn't start spending any hours until I believe it was the 14th when I had a meeting with the attorneys. That's sometime.
Yeah.
But I didn't start really spending any time on it until I got the discovery.
All right. I don't care when you spent the time. I'm just trying to get a total time. Total time.
I would say by this time, I'm just looking, I keep a record of these kinds of things, so I'm looking at it. It's probably been maybe 12 or 13 hours.
Okay. Now, I want to talk to you about your chart, which has been admitted as Defense Exhibit 8. And I heard you say that this was a chart of everything tested in this case. That was what you testified to on direct. Do you mean all the serology and DNA, or did you mean everything actually tested in this case?
No, my focus is just what the lab received for biology testing and the tests, the serology and DNA they did on that. I didn't look at latent prints, I didn't look at ballistics, I didn't look at any of the other things that could have been submitted as evidence.
So for that we're clear on the record, did you read any of the trace evidence reports produced by the Georgia Bureau of Investigation in this case?
No.
Did you read any fingerprint reports, either from GBI or from what is called the Athens-Clarke County Police Department? Did you read any fingerprint reports?
No.
And did you consider any of those things in forming the opinion that we heard you testify here today?
No.
Did you see any videos of the defendant wearing the Adidas hat that was tested for blood? Did you see those videos?
No.
Did you see any videos of the defendant carrying the blue jacket that you have discussed the testing on?
No.
Did you see any videos of the defendant discarding those bloody gloves that you have discussed?
No.
Okay. So you form your opinion based solely on the things that you've told us about already, correct?
Correct.
And you told us there are some things that you didn't have, and I noticed when reading over Defense Exhibit 8, you don't have the global filer data on the blue jacket and the gloves. And as a matter of fact, if you look at, if everybody can follow along, page 1, item 2, you first talk about the gloves, and you say in there, if I go down to the third line, you say 2B, black glove, and then you go all the way over, and in the end you say no further testing. Is that correct?
For the middle glove?
Yes, for 2B, you say no further testing.
Correct.
And going underneath that, for item 3, the jacket, item 20 is the cutting of the stain, which you've talked about. There was blood on the jacket, right?
Oh, yeah, it was presumptively positive in those 2 tests.
And you write no further testing, correct?
Correct.
Would it surprise you to know that you are wrong about that?
Well, in my review, I did not see that testing reported.
Well, you had the opportunity to review the trial transcript, correct?
I have not reviewed the trial transcript except one thing on the trial transcript.
Okay, your DNA. Go ahead.
Yeah. So that no, I have not looked at that yet.
Okay.
I have not done a complete review of this case yet. I don't have all the materials, and I have not had time to look at everything. So that's why I make a list of all of the things that I relied upon to come at my opinion at this time.
If you had read the trial transcript, Ashley Hinkle, the DNA analyst, testified in the trial. Would it surprise you to know that she testified at trial?
No, not at all.
And she testifies at trial to the results, global filer results. And just so we're clear, global filer means traditional DNA testing, right? We're not talking true allele, right?
Correct.
Okay. And that Ms. Hinkle testified to global filer results of both the gloves and the jacket, and that those results are that the blood on the jacket, or that stain, which was blood, went on to DNA. It's global filer results, and it's both Laken Riley and Jose Ibarra on that jacket. And I'm going to show you, and maybe they are also part of the record already, but let me just show you for the record. I'm going to have to move, right, Your Honor? Can you toggle over? Can you hear me now that I'm over here?
I can hear you. I can't really read that report, but I have a copy of it somewhere. What's the date on it?
Well, this report is dated February 29th of 2024, and it is, and I have had it marked for State's Exhibit 4 for the record, but it's already part of the record because it is attached to the Daubert transcript, Your Honor, which is November 1st of 2024. This is State's Exhibit 4, and so that everybody knows, it's already attached to the record. But have you read this report?
Okay, so I have a report dated 2/26/2024 that was a blood report. Mm-hmm. I'm just looking to see the first DNA report and what the date on that was. So just give me a second. The first DNA report that I reviewed was on, I believe, 3/14/24. So is that this one?
No, this is 2/29. So if you could look back at the screen, and just for the record, I'm going to go ahead and move to Admit States 4 so that we can all follow along, but it is already, again, part of the record because it's part of the Daubert transcript.
Any objection to 4?
No objection. It's already been admitted in previous hearings.
Stage 4 is admitted in this proceeding.
I'm showing you page 2 of 4 on State's Exhibit 4, which talks about the major profile obtained from the cutting of the blue jacket. Item 3 matches the profile of Laken Riley. The frequency in which the major profile, and it goes on. But those are global filer results. And you had not seen those prior to me showing you these today?
Correct. I don't have that report as far as I can tell.
And below that, there's also global filer results from the black glove on that same report, and you do not have that as well, correct?
Well, I have some global filer data on the gloves. So which specific one are you talking about?
Well, you can read it.
Is it 2B or 3B? I can't read it from there, honestly.
It's 2A.
Okay, 2A. Yes, I have that. That's in my report.
Okay.
It's in my spreadsheet as well.
The global filer results and the traditional trio allele results on the traditional DNA results on the gloves.
On glove A, on 2A?
Yes.
Yeah, I have that in my spreadsheet.
So you have that in your spreadsheet, but you do not, and you would agree with me, you do not have the global filer results of the jacket, the cutting from the jacket of the blood, which is both
correct.
Laken, Riley, and Jose Ibarra.
Right, I have the contact swabbing that was taken, and that was also a mixture of the two of them.
Okay.
Yeah.
Okay.
So it doesn't surprise me, but I did have that from the contact swabbing.
Did you, for the record, read the November 1st, 2024 Daubert hearing that was done in this case on the DNA?
No.
I'm going to show you now, or do you have, let me just ask you this, do you have a crime lab report dated 3/14/2024?
I do.
And on that, is that safe for me to say that is the YSTR results of the fingernail clippings of Laken Riley, correct? Both left and right?
Yes, and also there's also some global filer testing on that as well.
And I did not see this in your report, and I want to know if you saw this on State's Exhibit 5. And again, State's Exhibit 5 is already part of the record because it's part of the Daubert. I would like to move to admit State's Exhibit 5, which is a crime lab report, which she has, just so we can be clear on the record.
Any objection, Mr.?
No objection. It's already part of the record in this case.
Five's admitted.
Showing you page 2 of 3 on State's Exhibit 5, which is the YSTR haplotype results, right? You follow me there?
Yes.
Did you see in the
yes,
highlighted? Okay. So in that report, it clearly states that Diego Ibarra, even though he is a male paternal relative of the defendant, was excluded as the donor of the DNA underneath Laken Riley's fingernails, correct?
Well, he was excluded. First of all, they did not include him in the Y haplotype, so I don't know whether he's just not related, and he thinks he is. My reading of it was that there were two people that could be included under the Y haplotype, and that was the other person of interest and the defendant. But then the other person of interest was eliminated in the global filer testing.
Yes. So Diego Ibarra was eliminated. Are you talking about Diego when you say the other person of interest? Because that's confusing.
No, I'm talking about I can't remember his name.
You're talking about Argenis. Right.
Argenis. I'm going to write it down so that I remember.
Okay. Well, in the global filer data and in the true allele results, both Argenis and Diego were eliminated as the source of the DNA underneath Laken Riley's fingernails, correct?
Let me just look at it so I'm saying it correctly, okay? Yes, that is, let's see, I'm looking at that, hold on. Fingernail clippings, right hand, at least two contributors, and then DNA match to defendant and exclusion of both of those individuals.
I think I can go back to my seat for now, Judge, and I'll go back when I can because it's a little awkward. Right, so for both true allele and YSTR, Diego Ibarra was eliminated, correct?
Correct.
Okay. And in your data that you put, you say on this is Defense 8, the first page, item 18, the nails. You talk about the YSTR results, AI, which is presumably Argenis, and defendant, JAI, I guess that's Jose Antonio Ibarra, and male relatives and their paternal line. And then you cite the frequency. But what you don't say in that line is what is in the result on State's Exhibit 5 that I just showed you, is that Diego Ibarra was eliminated as a donor on the YSTR, right?
Correct. They did not include him as that, so I'm assuming that his haplotype is different.
Well, if you read the trial transcript, would it surprise you to know that the DNA analysts in this case testified that Diego Ibarra has a genetic mutation which excluded him in the YSTR results?
Okay, that seems reasonable.
Okay.
Yeah, that can happen sometimes.
All right. Yes.
They can be related, but then he has a unique mutation that was not carried by the rest of the family, and that can happen. It's rare, but it can happen.
Okay, so if I hear you correctly, and looking at the DNA results in this case, on the jacket, the blue jacket, Jose Ibarra and Laken Riley's DNA from contact swabs, it's on the jacket. You were not privy to the blood results, correct?
That is correct.
That under Laken Riley's right and left fingernails for the YSTR results, it is a Jose Ibarra, or it could be Argenis Ibarra, but we know it's not Diego Ibarra, correct?
Correct. Now that I understand he has mutation, I thought maybe he wasn't, actually related to the family in some way, which can happen also.
Okay.
But now I know it's mutation. Okay, fine. So under the left hand, he was also eliminated by YSTR testing.
Okay. So we have either, Jose or Argenis' DNA under both her left and right fingernails, correct? Under YSTR.
Well, we have either them or somebody in their paternal line. Yes,
correct.
Just to be very clear. Yes.
Well, that's the YSTR results. But then when you go to true allele, true allele could only get results from the right hand, correct?
That is correct.
And under Laken Riley's right fingernails, according to the true allele results, it is Jose Ibarra's DNA, correct?
Correct.
And both Argenis and Diego were excluded, correct?
Correct.
Okay. And I noticed that you did read Preston Norris's transcript at trial, and I'm wondering what that testimony did in order to form your opinion in this case.
I believe, if I'm remembering correctly, I believe it had to do with where a particular item is located.
Okay.
And if I remember correctly, it had to do with the foam cup and the straw.
Okay.
Because there was some confusion about where that was actually located with respect to the crime scene.
Okay.
That's what I'm remembering.
Okay. I want to talk to you about your conclusion first, because I heard you testify on direct about half of your conclusion, but I want to talk about the whole conclusion, and I'm not blaming you for that, by the way, Dr. Ballard. You did not question yourself, so please don't take that wrong. I'm looking at page 5, the bottom of your report, and it's the last bullet point. Are you with me?
I'm going to get there in just a second.
I'll wait till you get there.
Okay.
At the original trial, the prosecutor argued that the defendant's DNA got onto the items when he murdered the victim. You have to flip the page, page 6 at the top. The original trial defense team argued that it got there when he helped his brother, Diego, who they hypothesized was the real killer, move the body after the fact, and that the defendant was not involved in the murder. Your conclusion, tell me if I'm wrong, I'm going to read it verbatim. Both hypotheses are reasonable explanations for the crime lab, serology, and DNA findings, and I can come to no informed opinion at this time as to which scenario is more likely, correct?
Right, and I'm just talking about, what I'm talking about there is what the DNA, serology, and DNA evidence are telling us in the case. Okay. I'm not talking about anything else,
so
just that.
You're not talking about his right thumbprint on Laken Riley's cell phone that was found 8 feet away from her body. You did not consider that in reaching this hypothesis.
That is outside my area of expertise, so no, I did not.
And you did not read the trace evidence report, so you did not consider the fact that on that blue jacket, there were 26 hairs from Laken that had been forcibly removed, according to Trace, and wrapped around a button on his jacket. Did you consider that?
No.
You already told us you did not see any of the videos, so I'm not going to go over that again. But let me ask you this. Did you see any photographs in this case?
I saw some photographs of the crime scene evidence at the crime lab.
Okay.
I have not looked at anything but I think an aerial view of the crime scene. I remember that photograph. But I didn't look at any autopsy photos. I didn't look at any other types of materials yet.
So I want to ask you, did you see any photographs that were taken by the GBI, and this would be a different GBI, it's the field office, not the crime lab people, and crime scene specialists, that were taken of the defendant the very next day after the murder where he had scratches on his body? Did you see those photographs?
I do recall seeing something like that. That is outside of my area of expertise, whether those are scratches or not. I'd have to leave that to somebody who does wound analysis.
Okay.
So, but I remember seeing some photographs that were in the stuff that I had available to review.
Do you agree with me, Dr. Ballard, that, hypothetically speaking, a victim who is fighting off her attacker and scratches him, that could be a reason for that person's DNA underneath her fingernails, correct?
Correct.
That can happen, right?
Yes.
And that's real. The science supports that, correct?
Correct.
Okay. And you didn't look at the photographs, or did you look at the photographs and forming any of your opinions that you just told us about?
Which photographs?
Of the defendant's body the day after the murder.
I remember seeing some, but like I said, I'm not a person that can look at those types of wounds and come to any conclusions about them. So you'd have to get a wound expert to talk about whether those are scratch marks or what. Okay. I don't know.
Okay. And you told us also that you would need some quant data. And what do I mean by that? The quantitative data, can you explain that for the record? You would need the quant data on the DNA to perhaps reach more meaningful conclusions, correct?
That's correct, yes.
And your testimony was that you did not see that data and the stuff that was provided to you on Defense Exhibit 4. Is that correct?
So, so for the reports, the first two DNA reports, and those were the ones dated, just for the record, I'm not going to worry about the male screening report. I don't care about that one. But the DNA report it was dated 3/14/24, and the DNA report for 5/16/24. I did not have the full quantitation data provided. I did have the full quantitation provided for the report that did the straw, which was on 8/26/24, and in none of them did I have an indication of the amount, the actual amount of DNA in microliters that the laboratory had from these samples immediately prior to the DNA quantitation step. And so I need all of that in order to do a full analysis.
Right, and the DNA quant data could be, well, I've looked through I had a little time this morning, we had a little delay, and so I had some time to go through Defense Exhibit 4 this morning while we were waiting. And would it surprise you to know that I found the quantitative data, at least on the fingernails, in Defense Exhibit 4 this morning?
I would.
Okay, let me show you something.
Please, I'd love to see it.
I'm going to go back to this microphone. And the quant data and the way that the files were presented on Defense 4, they were TIFFed files. Do you know what I mean by a TIFFed file?
Yes, it's an image file.
Okay, when you opened the image file, were you getting multiple pages of that image or just one?
Multiple.
Okay, so State's Exhibit, what I'm going to go ahead and mark, and I'm going to go ahead and mark and move to admit State's Exhibit 7, 8, 9, and 10 for the record.
Any objection?
I think it's already in evidence. It'd just be a demonstrative at this point. But
7, 8, 9, and 10 are admitted.
Okay. This came from Defense 4. Do you see State's 10? Can you read it?
I can sort of read it, and it's what I need. It looks like exactly what I need if that's for items 42 and 43.
Right. What I've highlighted, is that the quantitative data that you were looking for?
Yes, it is. It is. I don't have it. So I don't know if it didn't download when the files came over, when I downloaded on my computer, or what happened, but I do not have it.
State's Exhibit 9. I'll put my finger over there. You see where it says quantity? Or my finger, my pencil, pen.
And that's for items which? I'm sorry. 45 and 46. I think those were reference samples. What the ones I was interested in was, I believe, 42 and 43. Those were the fingernails.
Okay.
And then the jacket, which was, I have the quantitative data for the straw.
Okay. Yeah.
I got that.
Okay.
And the jacket, which was item, I believe, 8. That one was item 21, and you're telling me that they also did item 20, which I don't have, even in my spreadsheet, because I don't have that report, but I did not have the quantitation for data for that one either. And I looked at the multiple pages.
Okay. So if you had the quantitative data, that's what I want to move to. Is it your testimony that you can use the quantitative data to determine how or when DNA was deposited on a certain item?
I don't think when. Okay, I think that would be, I can't time it. What I can say is, let's say that under those fingernails, there was thousands of cells worth of DNA that could be attributed to the defendant. That to me is out of the range if he moved a body, okay? That's out of the range of, somehow getting there some other way through a different type of activity than scratching, right? On the other hand, if there's 8 cells worth of DNA on those fingernails, I have good papers that support the fact, research that supports the fact that DNA can get transferred under the fingernails of people, and actually if you take people and you swab their fingernails, about 30% of them have DNA from unknown people under them. Well, so it's not this transfer can happen. So that's what I'm saying. So that's why the quant data is important to me, because it tells me what world we're in. Are we in a world where there's a possible explanation that this could have happened due, say, moving the body, just one example, shaking somebody's hand, those kinds of activities? Or is this something that really can't be explained by that? Okay. And I'm absolutely open to both possibilities. Okay. I don't know which it is at this point, because I didn't have the quant data when I put my spreadsheet together. Now that if I can get a copy of it, I will incorporate that into my spreadsheet, and that will inform my decision further.
Okay. And your decision is made solely on serology and DNA results, correct?
Yes.
And you absolutely don't even consider trace evidence, fingerprint evidence, video evidence. You don't consider any of those things informing your opinion?
No.
Okay. And you said there's papers on it. This is what I want to ask you. What is this type of analysis called? What is it referred to in your field where you use quant data and you try to attribute how it got there?
Yeah, so it's typically called TPPR.
Yeah.
So it's basically transfer, prevalence, persistence, and recovery.
Okay. And how many times have you testified in a court of law as to TPPR results?
Many times.
Okay. And had you had any Daubert hearings in those many times? Or I know you testified in California, Kelly Fry, you're familiar with that standard?
Yes.
Okay. So have you had any hearings on that?
No, I have not had any hearings on that particular thing.
Okay. So your opinion on that went unchallenged?
I guess so, yes. I don't think it went challenged. I've had other things that I've out, but not that.
All right. I want to know what scientific, well, first of all, are your results peer-reviewed?
Are my results for what?
But your conclusion in this case, was it peer-reviewed?
No.
What is peer review?
Well, peer review is when you write an article for a journal and you've done research, and then other people review the research that you did and suggest things like, did you think to put this control in? Did you think to add this kind of sample? Blah, 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 blah. And then it goes through another, you go back and do some experiments in the lab, and then you come back and it goes out for another peer review. And eventually, hopefully enough people believe it and feel it was well done that it gets published. Well, that's what we call the peer review process.
Okay, sorry. That's in the academic standard. What I want to know is crime lab. So, for example, if you read the trial transcript in this case, the DNA analyst, Ashley Hinkle, who testified that her results in this case, that means every result that she reported, every DNA result from the nails to true allele to the global file or traditional DNA results on the jacket, all of her results were peer reviewed by another certified DNA analyst. That's what I'm talking about. Their work being checked by other professionals in the field.
Right, and I'm part of that. Sorry, I am part of that peer review process.
Okay.
I am a peer reviewer for their work. That's what I'm doing here.
My question is, who's peer reviewing your work?
Peer reviewers don't get peer reviewed.
Okay.
I'm a peer reviewer. I didn't do the actual work myself.
So the answer to my question is no one peer reviewed this report that I read.
I have people that go through my reports. I have people that look at my spreadsheets and make sure the calculations are correct when I do yield calculations and like that. I have that kind of thing. But in terms of my opinion, I'm coming to it as an expert, and I'm peer reviewing the work at the lab, and then I'm contextualizing it for the attorney. That's my job.
Okay. So
would my peer reviewer need to be peer reviewed also?
Well,
I mean, I don't know when that process is supposed to start and stop.
Okay. So you feel as an expert you don't need to be peer reviewed?
Well, I feel like my work needs to be checked to make sure it's accurate, but my opinion is my opinion.
Okay.
That's that from all my years of experience and keeping up with the literature in the field and everything else. And other experts might disagree with me, okay? They might not agree, and that's okay.
And what I want to ask you then, just based on the science, because we've already established you're looking at the DNA reports and the serology, and you formed the opinion that we've already talked about. Is there any peer-reviewed journals that approve the use of TPPR in forensic U.S. criminal cases?
So they're not, the articles are not going to make that assessment, okay? The articles, they do work in that area, and they publish the article. These are peer-reviewed articles. There are over 2,000 of them now on this topic, okay, that are out there in the literature, looking at various aspects. How does this DNA get transferred? All of those kinds of things, okay? So experts like myself read that literature, stay up with it, and then use that literature where appropriate to come to court and make assessments.
I want to separate my questions up a little bit. I understand LOCAR and the theory of transfer, and that every contact has a trace. That's been around since the early 1900s or 1800s or something. He's French. I get it. But there is a difference between talking about DNA transfers, just that DNA can be transferred, and attaching the significance of saying exactly how it was transferred based on quantitative data. So my question for you is this. Peer-reviewed journals on drawing a conclusion on how DNA was put on a certain thing, like fingernails, based on quantitative data alone. Where is the peer-reviewed scientific journals that approve that practice?
Well, I don't know of any particular scientific review paper that looked at that, but what you do is you look at the scientific literature. For example, one paper I looked at in this case is called Prevalence and Persistence of Foreign DNA Beneath Fingernails, okay? You look at how much DNA did they find, okay? Was there foreign DNA under it? They looked at cases of different types of crimes, homicides included, and they also looked at, sampling people from the general population and looking at, how many people have foreign DNA in their fingernails, did they figure out where it's from? That's relevant to this case. And I'm not going to, I would be doing, in my opinion, I would be remiss in coming to court and not talking about these things. Okay? I would be remiss coming to court and saying, oh, they found thousands of cells worth of DNA under this victim's fingernails. Could have gotten there anyway. Throw up my hands, no opinion. Okay? I would be remiss because I wouldn't be telling the jury what they need to hear about evidence like that.
Who is SWGDAM?
SWGDAM is the scientific working group that is looking at recommendations to the forensics community regarding issues involving DNA evidence, including DNA mixtures.
Have you read the December 1st, 2025 report from SWGDAM and their position statement on just what you're talking about here today, which is using quant values to determine how DNA got on something?
Did you provide that to the attorney beforehand?
I did. I provided it to him this morning.
Then I did read it.
Okay.
I'm making sure that we're talking about the same document.
Yeah.
So what that document talked about is called formal activity level propositions. Okay? I did not do formal activity level propositions in this case.
Okay.
SWGDAM does not have a position on what I did in this case, okay? There is a formal process that involves Bayesian networks, and And I have gone to presentations on those. And I also think that experts that use those kinds of things at this point are stepping outside their area of expertise to provide probabilities of certain things happening, and those being prior probabilities to what is the case here, and then opining on how probable it would that this would happen or this would happen, and taking that into account when coming up with a specific probability, like it's 40 times more likely or 30 times more likely. I don't do that, and I don't feel comfortable going to court on that at all.
Okay, but
what I do...
Go ahead.
Okay, what I do is that I look at the relevant scientific literature and I ask myself, is there a possible or reasonable alternative explanation for how that DNA might have gotten there? That's what I ask myself. I don't say it's 40 times more likely. I'm not taking into account anything else. I'm looking at it and going, based on what we know about DNA transfer, is that a possible or reasonable type of explanation, or is it impossible? Is it so unlikely that it's essentially impossible? And that's what I come to court and testify on. That is not a formal activity level proposition, and that's what that entire thing you sent to me was about.
Okay, well, I'm going to move to admit State's Exhibit 6 at this point, which is the Swigdam position paper.
No objection.
6 is admitted.
If you could, Doctor, going to page 2 of that Swigdam working group paper.
Yeah, I've got to put my hands back on it. Yes.
Okay. I mean, we could read the whole thing. It's in evidence. I'm not going to read it all because I'm not going to waste the judge's time. He doesn't like us to read to him, but I have to read one thing to you. It says the overall effect of TPPR testimony. You see where I'm at?
Yes, I do at the top. Yeah.
All right. Which is what you said you call this, TPPR, may, when taken together with other evidence in the case, tend to make the positions of the parties more or less likely. The weight that a judge or jury gives to the DNA analyst TPPR testimony may be a deciding factor in the outcome of trial. And they go on to give a formal statement that says formal ALR or TPPR in its present form is not suitable for use in the United States criminal justice system. Do you see that? And do you agree with that?
Well, yeah, I actually do, and I didn't do that.
Okay.
But that's what I'm telling you. I did not do formal ALR in this case.
But you did just look at DNA and serology reports and just said, well, based on those things, both of these hypotheses are reasonable, right?
That's right. That's right. But that's not formal ALR. It's a completely different thing. If you look at the last page of this, it says, since analysts will continue to face questions related to TPPR, the Swigdam chair will task an existing Swigdam committee or working group with exploring alternatives to the formal ALR approach. So they're still working on this, okay? Right. There are analysts at labs that will not make any statement about what this data tells you about how it might have gotten there. I feel, I would say that there are a lot of people, a lot of experts who are in my camp who would say I would feel I was remiss if I didn't give the jury that information. There's over 2,000 papers on these types of things now. It's not like we don't have any data.
Okay.
So that's what I'm saying. This Swigdam thing really doesn't have anything to do with what I did.
And is that because that the formal TPPR signs like a legit, a statistical probability, right? But you did not.
Well, yes, and it also uses Bayesian networks, and I did not.
Okay.
So it's taking into consideration a bunch of prior probabilities of something that can step outside what I feel when I've seen people perform this and show their process, steps outside of the area of the DNA expert or serology and DNA expert. They might be opining on something that is really not, you know, what percent of times when people are smoking marijuana in their backyard with other people, do they share it? They'll come up with a probability of that and take that into account in coming up with some probability of DNA. They don't have any basis for that. And so that when I've seen it done, I feel very uncomfortable with it.
Because that's not Generally accepted in your relevant scientific community, correct?
What, formal ALR?
Yes.
It is accepted in Australia and New Zealand pretty widely.
Are we
And
in
they do a lot of
Australia
it.
or New Zealand?
But here in the United States, there are some people doing it, okay? There's even training courses you can go through for this.
Right.
But I would say that, SWGDAN, I agree with them. I come down on the side of this with SWGDAN. SWGDAN is not mandatory. It doesn't tell everybody what to do. It's a recommendation to the community. Some experts disagree with SWGDAN. So it's not, it's not like everybody says, oh, SWGDAN said it's got to be true. But on this particular issue, I can say not about necessarily as much about formal ALR, which is not done as much in the United States. It's pretty rare. But the type of thing that I'm doing is not that. Okay, it is coming in and saying, based on the literature, these types of things have been shown to happen and are reasonable for certain circumstances. And if you scratch someone, okay, and all of that, if I saw lots and lots of DNA in the fingernails from a perpetrator or a suspect or whatever, I'm going to be weighing that differently. I'm probably going to say it's not reasonable to say that got there in an innocent way, or in a way that's another hypothesis given by the other side. And if I didn't tell the jury that, I think it'd be remiss.
Did you look at the length of Laken Riley's fingernails?
No, I don't know what the length was.
Okay. And wouldn't it matter whether someone had long fingernails versus short fingernails in your transfer DNA theory? Isn't that a consideration?
It could be. I don't know of any papers that specifically address that.
Is that why you didn't look at them?
Look at what?
Her fingernails.
No, I didn't look at the fingernails because I didn't have any photographs of them.
Right.
I just have a description of what the analyst did with those nails, which said she swabbed them, so I don't even know how she swabbed them.
Okay. And just so that I can go and research this a little more, then, what papers are you relying upon if you're not doing TPPR formally, because you're not getting a percentage or probability number out there, that supports your hypothesis in this case?
Well, I have a whole stack of ones that I rely on. Like I said, in this case, one of the main ones I relied on, because it's relevant to the particular issue of the fingernails in this case, is called Prevalence and Persistence of Foreign DNA Beneath Fingernails. And it's from Forensic Science International Genetics. I'm happy to provide the link or a copy to you, so your analyst can look at it too.
I'm sorry, is that the one that was footnoted in your report?
No, that's a different one, which is actually a very good review article by Van Oorschot regarding the transfer of DNA and the dynamics of that.
So am I wrong when I say that only one scientific journal is in your report, and it's that one that's dropped at footnote 1, correct?
The reason I put that one in is because it does a review. It's a review paper, and it references a lot of the papers that I also rely on.
Okay.
So rather than giving a list of 22 papers or something like that, I list a very good recent review article that goes through all of those things. And that's why you oftentimes do just the review article. But I rely on other papers as well in coming to these conclusions, and some of them are much more, they're quite well aligned with what is said to have happened. Like, you don't want to use DNA transfer papers that, if you're looking at fingernails, for example, that have nothing to do with fingernails. So you want to look at something relevant to the case at hand as close as you can get.
I appreciate that explanation, but the answer to my question is the only one in your report is the one that you dropped as footnote 1, correct?
Correct.
Okay.
I was just trying to tell you why.
Okay. I think that's all I have, Your Honor.
Just a few follow-up. All right, Dr. Ballard, your job in this case was to review the raw data that was used to do this DNA comparison. Is that correct?
Well, I don't know raw data. I was to review the crime lab reports, the analyst bench notes, the electronic DNA file, which we often call raw data, and the true allele material.
Okay. And all materials you received in this case, did that come from that download?
Yes.
And this, did you download it directly from the GBI?
Yes, I did.
Okay. So everything, and you looked at everything that was provided in that download, is that correct?
That's correct. However, I will say that sometimes during downloads, in my experience, I've been doing this a long time, sometimes during downloads, particular files do not download. Oftentimes, it's because they have a very long path name. And so I have had things happen before where a particular file does not reach me. And because I'm downloading it from a server or whatever. That's why I oftentimes prefer to get everything on a thumb drive, because I typically don't have those problems. I can just go straight to the thumb drive and not have to download it. So I tried to go into this material without downloading, and I couldn't get in there. I had to download it in order to actually look at it.
So just so we're clear, these were zip files that you were opening, correct? Were they zip?
Correct.
All right. Now, in your role, you're not hired as, you're not an expert in fingerprints, correct?
Correct.
Or trace fiber, you're not an expert in fiber evidence or anything like that?
No.
So you don't look at things that are outside your expertise?
Correct. I figure you'll have other experts that'll come in and talk about those.
Okay. And so you're just when your opinions are just based solely on the evidence that you look, the DNA evidence that was provided or presented in this case, and the evidence that the crime lab looked at in this case.
Correct.
And you're looking at what tests they did and what they did to reach their results.
Correct.
All right. And you did not have an opportunity to have this conversation with trial counsel, correct? You did not have a chance to look at all this data and go through it with them.
No, I wish I had, because if I had had a chance to explain, look, this is what I'm missing, and then they said, well, actually it's here, and I went in and looked, no, it's not there. What happened during the download? That would have been great, because I would much prefer to testify to having seen everything. Okay. But I think it's clear now what it is that I don't have, and it looks like there's an entire report I don't have. So I want to get all of those materials now.
All right. If I could just have 1 minute, Judge. All right, that's all the questions I have.
Anything else, Ms. Ross?
No, Your Honor.
All right. Can the witness be excused?
She may be excused. Thank you.
Any objections, Ms. Ross?
No, Your Honor.
Dr. Ballard, you are excused.
Thank you. Have a good day.
Thank you, Dr. Ballard. Thank you, Dr. Ballard.
Any other evidence?
No other evidence, Judge. We rest.
The only thing, just to clear up the record, Your Honor, is that for State's Exhibits 7 through 10, I said it in my questioning, but I want to make it clear. During our unexpected and unanticipated break this morning, I had the time to go through Defense 4, which is the thumb drive that they say, is the documents that she got. And the states 7, 8, 9, and 10 were printed by the state from Defense 4 today. So just so that is clear for the record.
Anything else on the DNA issue that you are here to talk about?
No other evidence on the DNA issue that we're here to talk about.
Okay. Do you want to go ahead and proceed on the other items that I think the other was the cell phone?
Judge, I think as we put in our brief, I think we mostly incorporate previous arguments. Your Honor heard that. We just put that in our motion for new trial just to preserve so there's not any issue of waiver. But I think that was litigated pre-trial by previous counsel, and we would just submit on that, Judge. We don't have anything additional at this time. We may address arguments, but I don't have any arguments today on that. We just, except for incorporating what was previously argued.
Ms. Ross?
I need to tender states 6 through 10 to Madam Court Reporter before I walk off with them. And Your Honor, the state would only have argument as to their enumeration of error, and it won't even be that long, but it's their burden, so it's a weird position for me to be in when I don't have a burden, but I would like to be heard orally before briefing, and I know they're going to request briefing, so I don't know how the court wishes to proceed.
We'll talk about that, but I'm going to go ahead and give you an opportunity to give me a summation if you want to do that. If you're saying you don't want to do that, then we can talk about the other options.
If I could just have, Judge, if I could just have like 5 minutes, and because we were going to submit we were going to submit to a briefing schedule and submit our arguments in brief after having a chance to review the transcript of Dr. Ballard's testimony.
So let me tell you, I'm probably not going to be willing to wait until there's a transcript of Dr. Ballard's testimony. So I don't know if that's helpful or not. We can still have a conversation about briefing if you want to do that. But here's what I envision is something like this. We come up with a date that I simply get briefs and proposed orders from both sides.
That's also agreeable.
I'm not looking to,
that's agreeable.
I'm not looking for response briefs after that or anything else. How's that sound?
I'm okay with that, Judge.
All right. So talk to me about time frame for you, Mr. Luttrell and Mr. Dowds.
We'd ask for 30 days, Judge.
Ms. Ross?
That means mine's due on the same day or a different day?
Same day.
The 30 days will be acceptable to the state, sir.
Would Your Honor prefer us to do it as in the form of a proposed order? I know some courts want it as a proposed order or brief, but
two separate documents if you want to do it this way. One's a brief, and I don't know why they call it a brief, because I have this feeling that that's not what I'm going to get, but you can be guided by that. Both sides can be, because I remind you that I have lived this. I mean, this was not a jury trial. This is something that I've had. So anyway, but it's, for instance, argument dealing with the cell phones, a citing to the page, the transcript page numbers would be helpful to me. I'm just trying to say what would be helpful to me. So I'm just looking for a brief and then a separate proposed order if you want to give one.
That's fine.
Your proposed order would not be very long, probably.
It's March 2nd.
Would be my guess. But and I'm just trying to say we don't need to get a situation where we're getting reply briefs and that sort of thing. Because it's fairly straightforward, I think. So, 30 days?
30 days.
All right. So that's the end of,
Technically, it's March 2nd because the way that February is short.
it is. What is,
March 1st is a Sunday.
so that works out.
It is quite smart of the state. I would like to just hammer down a specific date. I guess
Why don't we say 5 p.m. March the 2nd? That's a Monday. And filing is, of course, that's fine, but I'm really more interested in sending me a copy electronically to my office.
Yes, Your Honor.
Yes, Your Honor.
Through Ms. Parker, right, Your Honor?
Yes, you can put her on there. You can put me on there.
Does Mr. Wilson still work here, Your Honor?
He does not.
Is he retired, I believe?
He has. He has.
But he has not yet been replaced, I suppose.
He has not.
I just want to make sure that I'm giving the copies.
Sure, that's a fair question. Anything else we can take up or need to take up?
I don't believe so.
Not from Mr. Ibarra.
No, sir.
Judge, if we could just check, since we were on WebEx and we do have Madam Interpreter here, if there was any issues with the defendant hearing or seeing the WebEx and communicating with his counsel and interpreter today.
So if you would, my question to Mr. Ibarra, well, you can go ahead. You want the interpreter, if you will help him to determine if he's been able to hear.
Do we want to argue this shit?
Yes, yes.
Does that satisfy your question?
It does, Your Honor.
Okay. Ms. Ross, I think it's actually Ms. Ross's question. All right. All right. We're adjourned. Thank you.
Thank you.
Everybody keep your seats for 5 minutes.
All right. That's that.
Yeah, when we're clear to move, SMU has to get out first. Can we all move someone together? Are we going to do that there? Okay, we still have a Stacy and global fire results.
That makes any sense.
Yeah, that seems to be about it. Just going to walk them out.
Yes, you did. Yes, you did.
I run off with evidence all the time.
You can.
I don't think anything else happens after this. So yeah, so they have until March 2nd, up to 5 p.m., as you guys are talking about, March 2nd, to file their briefs. No, judge is still there. Wait, hold on. If anything else happens. And I think they're done. Seems like they're done. Yep. All right, so they're done. So I didn't take notes per se, but what was really interesting is that they being the defense said they had 3 issues. 2 of them had to do with no continuance, which means the defense asked for more time, and the judge denied them. This judge denied them. and Judge Haggard, and then during the trial. And then there was a motion to suppress cell phone data. And then they started talking about DNA. And of course, they had Dr. Ballard on for 2.5 hours, 3 hours. And she did not come across as very impactful to change my mind as far as what Jose did. And then now, so then we came back to the defense saying that the brief that was written contains the cell phone data, so they didn't need to litigate that, I guess, or they didn't need to argue it or bring in testimony, which is really interesting. Two things though that did stand out, or one thing that was two things. The state twice made sure that Jose was able to see the witness and then was able to understand what was happening. So it was the state that was asking. So again, Sheila Ross, Miss Ross, she was making sure that Jose was being taken care of, and she didn't want any improprieties on her end, which, excuse me, just shows her class. You know, you may have really strong feelings about this guy, and I'm sure we all do, but you know, follow the prosecutor's decorum, if you will. You know, that's what I always look at that. I'm like, wow, you know, as much as you want to like jump across the aisle and, you know, strangle this guy or do something, you know, bad to him, she's like, hey, was he able to understand what just happened? Was he able to hear? Was he able to see? You know, that to me shows a lot. That shows a lot. So the person who's prosecuting him still has the, you know, compassion to be like, all right, does he understand what's going on? Is he able to hear? I want him to spend the rest of his life in jail, but does he understand what's going on? So, all right. With that, you guys, that's it. That's it for today. We had a good day. We did Jose Ibarra, obviously. We also did the Tepes in the morning. If you guys missed that, definitely go back and check that. Check that out. Spencer and Monique met their ending at allegedly at the hands of Monique's ex-husband, McKee. So that's just starting. It's not a trial. It's just happened December 30th. So it's just in the infant stages of that investigation. So we'll be following that for sure. And Jose, so I'll update you guys on this. So they have 30 days. So March 2nd, they're going to put in their briefs and their proposed order. And I don't know when the judge is going to rule. I don't know if he will rule. Well, he has to read whatever they give him. So I don't know if he's going to take a week, a month. I have no idea. So we'll keep on it. We'll let you guys know. We'll drop something in our community page as to what happened. So. All right, so with that, thank you guys. Thank you for the super chats, the gifted memberships. Really appreciate that. Appreciate the support. Thank you for spending your day with us. Really, really do appreciate that. And we will see you tomorrow. I've got Super Ball here. I can show you a little Super Ball. Yeah, good girl. Got a little Super Ball over there. Got some kitty action over here. So kitties are... We have one more cold day, or I should say cold night. We have a front that just went through, so we have one more cold night. It's going to be about 33, I think, 34 tonight. And then after that, I was looking at my my app, and we're going to be in the 40s. So as lows, there goes Houdini as she walks by. And then I even saw 70s. I saw 70s coming up for next week. So it seems like the cold might be loosening its grip here. Hopefully where you guys are, it's warming up as well. So Paul Canero tomorrow. Don't forget, Paul Canero picks back up. They were off today. Hoping that the state's going to rest. I don't know who else they're gonna call, but I'm hoping that they rest tomorrow. Defense kicks in, and we can get to a jury deliberation by next week and put this to bed, because we got Corey Richins. Corey Richins is coming up in 2 weeks. Yeah, 2 weeks, 24th. Corey Richins is coming up, and it's going to be all hands on deck for Corey. So we will absolutely be streaming Corey Richins. So with that, have a fantastic night. Thank you to our mods for potentially a difficult day. And I want to thank you guys for those that are still watching. Thank you for being civil, being courteous, being respectful. This, I know, brought up a lot of emotions for everybody. And I really appreciate you guys respecting yourselves, respecting the channel, respecting our mods, respecting everybody else in the chat. So pat yourself on the back. Thank you for that. Really appreciate it. And thank you to Erin for all that you do, putting this together. She put both of these streams together, so good job there. Thank you. And with that, we will see you tomorrow, 8:15 for Paul Canero. Have a good night, guys. Thanks again for watching. Bye.